When was it vacated? What is the interim order?
Stay off disbursement of the responded because they have placed the wife as flying for maintenance and the expenses of the unmarried daughter. That was paid. And for entering appearance of the other side.
Application filed under 125 CRPC.
They are not for maintenance.
Marriage expenses under 125. Yes, end of the list. Yes, one of the list. Yes. It was listed yesterday. Hmm.
Malads, is this writ petition Martin Topal being mentioned? I'm unable to hear the advocate side.
You appear in her case.
No, not at all.
Yes.
Sorry, I'm so sorry. ma'am.
Stating that they're on a 41-day mourning period and he will not have any access in respect of the daughter. And she says that I'll give you a phone number. Just call her over the phone and talk to her. Whereas your lordship is aware of the matter, parental alienation. Even after having granted visitation rights, she doesn't comply, my lords. Now, should I believe the fact that she gives me a phone number and I should believe that she will talk to me, my lords? And Dasara vacations, my lords, that day.
What is the order passed by this court?
This honorable court, in fact, had granted me not overnight custody but visitation rights, which are also not being complied. Now, under the guise and using a demise of a person, she's stating that she will not send my lords. It's very unfortunate.
See, after vacation. Now there are always so many matters today. Yes.
My lord, date given matter has not been
Uh,
a date given matter has not been listed. My lord, on 23rd September, your lordship will
tell the
please-
court what is urgency. You
My
understand?
lord, on 23rd September, your lordship was pleased to meet the
Yes, I'm
father,
appearing
mother,
in
and
this
both the
matter.
sons.
Hmm.
My lord, I may be
Yes,
permitted
yes.
to complete my submission. Your lordship was pleased to meet the father, mother, and both the sons in chambers, my lord, post which an order to exercise interim visitation on Saturday and Sunday were passed, my lord, from 10 a.m. to 5 p.m. Post which the matter was ordered to be posted on the 1st to pass further orders on vacation visitation, my lord. It was a date
No,
given
Malad,
matter
the
in the
order is not
presence of both the councils and both the parties, my lord, but the matter has not been listed to date. May I
Malads,
kindly take an
yesterday the
application?
list has come out and today at 10:15 a.m. they have messaged us saying they're moving this memo. Malads, my tickets were booked. I'm a counsel that comes from Delhi. My lords is aware. And I had in
Please
fact
appear
checked-
online when there is some
Malad,
difficulty for that.
Malad,
It's not listed. We'll see. We'll see. Nothing will. Yes, end of the list. Yes.
Malads,
Wait for your order.
unfortunately, there's a slight issue here, Malads.
You
Since
can
I'm
appear
not,
online. You can
Malads, there
appear
is no
online.
order for
Date
visitation
given
for
order,
vacation.
ma'am.
The order has
Court
not even
said
been
that
uploaded.
Court has observed that basing on how it goes on, we'll consider it.
But also the children are not available today because on the last date, my lord had said the children have to come today then. The children have
No, my
also now
lord.
gone to school, my
The
lords.
parties were
There
not
is no
permitted.
urgency in this matter, my lords.
No, that's for you, but for him, for her, there
My lords,
is urgency.
the children are already traveling, my
We'll
lords,
see,
from
we
the
will
7th.
see. Please appear at that time online. Yes, after
Yes,
end of
ma'am.
the list. Yes. When was it obtained? Then, no. Yes, next.
Serial.
25 proceeding, my lord. There is
Huh?
25 proceeding.
Huh.
In the ex parte interim order has been passed.
When?
It was on 17th.
Hmm?
17th of this month. And now the FLW has been issued. And
17th, you had a lot of time and just
we
before,
have
on the last day, how is it possible?
First
It
week
can
enough
wait,
time.
it can wait.
on Wednesday
It
we
can
have
wait
filed-
after vacation. Yes.
Wednesday we have
Your
filed
lordship.
FLW has been issued. NDPK. Not even considering any of the documents that are passed in ex parte.
Why have you not mentioned it before? Before.
Day before yesterday again, but not this. Sitting, my lord.
So whenever you get a brief, that's not the time to mention.
Not that.
The
Yeah, filed it
the
on-
party should have come before the court. You understand so many matters are today. Everybody has urgency on the last day. How is it? Will the
End of
court
the-
be able to do it?
End of it. Not even consider any of.
Everybody end of the list, then there is no end to the list. Take it up. Yes.
Your lordship, there was a direction for the respondent father to give a consent for the minor child passport renewal of USA, your lordship. Twice
It
he
can't
has,
wait.
your
It
lordship,
can't wait.
twice he has
No,
denied.
it's okay. Can't it wait till vacation, after the
Your
vacation?
lordship, according to the order, the last,
Then
third-
if he is not complying it, what is the remedy?
We have booked
But that taking up the matter before vacation is not the
I had
remedy
booked it
available
on
to you.
Friday, your lordship. However, date was given on today, your lordship. The file is not traceable, your lordship. That's why the matter was
We'll
not.
see after vacation. Passport from how many years he is not giving the consent?
It's from
It can
last
wait, it can wait. It's
Yeah,
just,
your
the court will reopen on 14th.
US consulate appointment has been fixed. My tickets to.
When is it
my-
fixed?
4th, your lordship. Considering that the matter was, date was given on today, your lordship, for the memo. The matter is not listed.
Yes, end of the list. Yes,
May I make a
please
mention?
call the
sir?
list.
May I make a mention? Serial number 30. Your lordship has heard us with respect to that LCR wherein the notice being served on ASG on his personal inconvenience is not available
I
today.
appear for the appellant in serial number 30, my lords.
Maybe immediately after vacation due to ASG serial number 30, my lord. At least one.
Have you informed the other side?
Other side.
I appear for
advocate
the
is-
appellant, my lords. I appear for the respondent, my lords.
They seek time after vacation. At the request of, it is submitted that the ASG is appearing in this matter and request the time for, they request the matter to be taken up after vacation accordingly. Yes, post after
My lord,
vacation. List it on October 21st. Yes.
Obliged.
My lord.
24, my lord.
Obliged.
Page by page 1, serial number 1 and 2, page 2, serial number 3 to 10.
Serial number 3, my lord. I pray for some time.
Hmm?
I pray for some time, my lord.
You appear for whom?
Petitioner.
14%, Priyanka.
I filed the wakalat, my lords. My name is
Yes,
not
at the request
reflected.
of the counsel for the petitioner post this matter after vacation.
Serial
on
number-
28th of October. Yes, next.
Serial number 10, your lordship.
Yes.
Appearing for the petitioner, seek a short accommodation.
When do you want?
Any date as per your convenience. A date may be fixed post vacation.
Request Post this matter on 28th October. Yes.
Much
next.
obliged.
Serial number 18, ma'am.
Page number 3, serial number 11 to 15. Page 4, 15 to 25.
Serial number 18, my lordship.
Yes.
Kindly, senior counsel is down with high fever.
You appear
Kindly,
for whom petitioner?
petitioner.
Have you informed the respondent?
We will inform.
No, please inform and come
Serial
back.
number 24, my lord.
Yes.
I informed the other side, madam. Kindly 2 week time, madam. Please.
Have you informed the petitioner?
Respondent, my lord. I am petitioner, my lord.
Have you informed the
Inform
respondent?
the other side, please.
Huh?
Inform the other side, madam. Respondent.
At the request of front counsel, the petitioner post this matter on 4th of November.
Please.
Yes. Hmm.
25 only there.
25 is saying yes.
This time,
Huh?
this time. I am appealing for the.
You are for the respondent. Can it be adjourned? The TSI. Post
This time. Senior is unwell.
at the request of the counsel for the responding post this matter on 11th of November. Yes.
Page number 5, serial number 26 to 32. Page 7, 33 to 40. Page 6,
Serial number 40, ma'am.
Hmm.
Time may be granted, may be fixed on 15th or 16th, my lord, senior is requested.
At the request of appellant post this matter on 22nd of October. Yes.
Page number 7, serial number 41 to 47. Page 8, 48 to
My
51.
lord, serial number 48, I am for the petitioner, my lords, filing memo for withdrawal. The matter has been settled before the mediation, my lords.
The memo is filed stating that the matter is settled before the matter is settled. And as per the settlement, the MC number 262 of 2019 is allowed for granting a decree of divorce considering the same.
Serial number.
The memo is taken on record and the petition is dismissed as withdrawn.
Much obliged.
40? Hmm.
46, my lord, I'm very sorry.
It's your case.
49 is our case, ma'am.
40?
For the petitioner, my lord.
Sharat Gowda GP.
The arguing counsel is currently on.
At the request of counsel for the petitioner, Pose this matter on 21st October.
Serial
Yes.
number 49, my lordship. I'm
Huh.
for a petitioner. Petition become infractious, my lordship.
Why the MC is disposed of?
Please, CMIS is disposed of.
DB, huh?
CMIS, my lordship.
It
Wife
is
filed
submitted that
125.
The main petition itself is disposed of and the petition has become infractious, dismissed as infractious. Yes.
Page number 9. Page,
When you want posting? Huh?
14th is the next date when the court is.
Take that. Post the matter on 16th of October.
16.
Yes.
Page number 9, serial number 52 to 56.
Lordship, serial number 60, my lords. I appear for respondent in that case. My lords, due to prior engagement, in-chamber meeting can't be happen, my lords. The child has exam and he has a chess competition going on. So he can't be present in chamber. Maybe taken up after vacation, my lords.
Yes. Have you informed the other side?
Other side has been informed, my lords. He is before Kalburgi
Yes.
bench, so I have informed
Yes,
him.
it is the request of counsel for the petitioner. Pose this matter after vacation on
Much obliged,
28th
my
of
lords.
October. Yes.
Page 1, list number 1, serial number 1, Raju H. for
Your Lordship, if I may.
Manjunathe.
Pause. List number 3, serial number 11. The arguing counsel had an emergency travel.
What is that? It is,
It's a fresh matter.
which is the serial number?
11. I'm for the petitioner, Your Lordship.
It's on the maintainability of the appeal against an order. We'll see, this all can be, I
Lordship,
mean, you can go before the competent court. This is all where you have to file an appeal before the district court. You're coming to the high court.
Your Lordship, the respondents have already filed the same petition. They have also appealed on the same matter.
Then both of you will go.
But the question of maintainability didn't arise in their case. So the arguing
So
counsel. should seek
the
time.
section was more vigilant in your case. That doesn't mean that, then you raise the same objection
Your
in
Lordship,
their
a
case.
short accommodation after vacations.
Then this 2024 MFA will be here till 2027. Then you will say, I'll go to give me the liberty.
Your Lordship, a date may be fixed, that matter.
11 on 14th of October.
Your Lordship,
the
14th is
request
we have a personal inconvenience, third week, 20th or 21st.
So you have to give your feasibility chart. Accordingly, matters will be fixed, 23rd,
Grateful.
at the request of counsel for the applicant.
List number 3, 18, serial number 18.
Serial number?
18, list number 3.
Hmm.
Kindly 1 week time.
Why you moved the memo for this?
It's memo simply pagination itte swami adike portal ಮಾಡಕ್ಕೆ.
You moved the memo for this. That's why it is listed.
ಅಲ್ಲಿ ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡಿದ್ರೆ ಅದರಲ್ಲಿ ಏನು ಬರಲಿಲ್ಲ ಸ್ವಾಮಿ
What
ಅಬ್ಜೆಕ್ಷನ್.
is that? For complying the office objections by 14th of October, no, not 14, by 21st of October, office objections have to be complied with. If the objections are not complied with, the petition shall be dismissed on that ground. Yes.
List number 1, serial number 1, Raju S. for appellant.
I appear for this.
Yes.
Manjunath,
Appellant.
opponent.
This matter, my lords, lords may kindly recollect, my lords, it was heard on.
Why is it adjourned on the
Thursday.
last occasion?
Lords, your lordship said, my lords, that the matter requires to be heard and we'll hear it. That's how, my lords, it is listed to today.
We'll hear it in the afternoon or after vacation. If it's acceptable, we'll take it up in the afternoon or else after vacation.
Yeah. Could be heard after vacations
Huh?
also. It could be
Huh.
heard after vacations also.
At the request of appellant for this matter on 21st October. Yes, next.
Interim order may be extended.
There is an
Interim order earlier granted is extended till then.
May I
Yes.
request, my lords, for a date?
Huh?
May I request for a date, my lords?
21st.
Please.
Yes, next.
Serial number 2, Raghavendra C. for appellant. Nanda Kumar.
This is the aspect with reference to the caveat not being served and the law.
Yes. Yes. We can proceed on the merits of the matter.
No, I just looked at the office file, my lord. I just want to make one submission on the caveat. So that is relevant. Insofar as when the caveat was
Fine. What is, in terms of office object, said that there's an email being,
Email?
email was served to. I want to please to see the record. His email is lawvibes@gmail.com.
Why did he give a phone number which do not belong to him? Number one. Then,
Now, okay.
you give a phone number which do not belong to you. And you will,
Address, my lord. I mean, what my learned friend has stated in the covering sheet of the appeal.
no, first of all, without going into that, look at, look at your wakalat caveat file.
I had overruled this and informed the other side to argue on merits.
No, that particular order, request my lord to kindly consider.
Where is that wakalat?
Is it
On
caveat?
that caveat? Last occasion we've seen.
Instead of 9/7, he has written 9/4.
Why he has written?
Clerk.
And last occasion, your colleague was saying that that is not at all in existence. The number which is not in existence is written.
Yes, but there's no email address.
Then you only write,
There's no
none,
email address.
it's
The
like
number my lord-
nobody can understand whether it is Nandakumar TM or Nandakumar TH.
Learned friend is not aware, email is on the index. That's not email. That's the index of the caveat, filed in the caveat petition.
This is not our handwriting. Please see my lord. Email which my learned friend has.
Which index you are referring to?
Caveat index, my lords.
Let's see.
Caveat index. Caveat index, 107. Yes,
Nandakumar@gmail.com.
gmail.com. I have sent to that email. Now they are telling email only is not.
So anyway, you cannot say that this is for right and written by him.
Email which they have sent. This show. This is the email, my lord. Written to Nanda.
Nandakumar@gmail.com. This is the email, sir. Nandakumar@gmail.com. That's also perfect.
What is our email address? We have filed an affidavit, my lord, to say this is our email. According
No,
to us-
first, before that, before looking at the affidavit, who asked you to do all this and come up with something saying that that's not, this is filed by you?
Yes, the number is been.
Nandakumar@gmail.com is also then shall we call for shall we ask the Registrar Judicial to conduct an inquiry and will initiate perjury proceedings on whomsoever it is?
No,
sir.
No, who will file according to you? A caveat he cannot file on your behalf.
That's why I requested him to file an affidavit. He has
No,
filed-
affidavit will not do when something is here. When you have filed a caveat,
Affidavit is to clarify, because it's a serious issue. I'm not undermining the seriousness of the issue.
no, you don't come to the court when you give this kind of particulars. Your name is also not clear. And the court will spend some time on that.
Court
Now
has al-
come and say that's.
Court has
it's
also
not
posted it
served
for
out.
next day, mentioning it is for judgment in the cause list. Next day it was mentioned for judgment in the cause list.
Mr. Counsel, please understand. We will first look at what you have filed and what is it first you tell the court. Please come to the caveat.
Can I just,
Yes, show it to him.
that it's clear?
Yes. Show it to him.
Is your, sir. Course, yeah, okay.
Handwriting it, pen also different. ಇದು caveat ಇವ್ರು ಬರ್ದಿರ್ತಾರೆ, number ಬರ್ದಿರ್ತಾರೆ, officer ಬರ್ದಿರ್ತಾರೆ. ಮಾಡಿ.
What my learned friend is saying, the number is in here and this mail ID, this is his pen. I'm just saying it as it is. What he's saying is, yes, you have not.
When he is making such a submission, he should conscious of what he is making. Just because a pen, no, in any of the papers, if two pens are used, does it mean that it is not his?
Get this examined by a forensic. This is
I have not written, sir. I have not written.
He might have not written. Generally, who will write all that? The clerk
Ajay,
will
it
do
was
it.
mentioned, its clerk is filled, the learning council mentioned. His clerk was the one who has filled everything. Now he is coming and telling that it's not his signatures.
Let's see. Please give that affidavit. We'll see.
Yes.
And I'm making it very, very clear. I will not, definitely not take this very casually. And everybody or anybody who is concerned with this has to pay for it. Because, the process, when you're appearing before the High Court, please come to that. Let's see, the affidavit. What did you say? Yes. I'm the on-record counsel for respondent caveator. Please read that.
State that I am the on-record counsel for the responding caveator in the above appeal. I'm well conversant with the facts of the case and competent to swear to this affidavit. Hence, I'm swearing to this affidavit. I state that the respondent has filed OS number so-and-so pending before the so-and-so court session, sir. I state that I have filed a caveat petition before this honorable court against the appellant on 19/6/24 in view of the order dated so-and-so. Copy of the caveat petition is produced as document number 1. I state that at the time of filing the caveat petition, I have forgotten to write my email ID, that is so-and-so, and my colleague Nandakumar PH email ID is so-and-so in the petition and wakalat number. But I've written my phone number on the wakalat.
So on the last occasion, your colleague was submitting that. It's not that, what he says, but I have written my phone number on the wakalat number for service. What he was saying on the last occasion is that that number is like, that's a non-existing, is somebody's number. No, he said, so that's not his number.
He's saying that it's an error.
Not, he said that it isn't like how that number has been written, but it's a mistake. My clerk has written, it do not belong to anyone. I think that's a statement. No, what your colleague has also, Mr. Counsel, now the court is online. All the records are there. So, no, just like that, because I remember all whatever that happens in the court. So that day what his submission was, like that is not the phone number. By mistake, my client has written. Nowhere it is their case that it is my colleague's number.
So he's admitting that number is not his number, right? That's what he said.
But what is this? What is this admission?
974 is his number.
No, I'm looking at the para number 4.
Yes.
But I have written my phone number on the wakalat nama for service. How is this statement is going with the other day what the statement is made?
He's saying is, my lord, that until my learned friend for the appellant raised this subject, he had not perused that number again. And when he noticed it, therefore he brought it to the notice of the honorable court on the last day. So saying that instead of 97.
He didn't say so. He didn't say so.
Yes,
He
Lord,
didn't say.
he is-
If you want, we'll have the records.
Lord, he is
You
neither,
have not said so.
he's neither Jagdish, neither Nandakumar, he is Mr. Murali.
Correct.
He's
That's
neither Jagdish, neither
correct,
Nandakumar.
correct.
He's Mr. Murali. He's neither Jagdish, neither
I had my
Nandakumar who are there on the
submission, but
caveat.
he was there. He was there.
Your number.
Your number, his number.
Your number. He's saying that instead of 9.
I think right from the client to the advocates, nothing is going as it is supposed to be. Nothing appears to be fair. No, it is, if it is as simple, no.
He's not even filed wakalat. Murali was who argued the
No, I
matter.
have-
No,
That's why I've taken leave of my lord. Submit
no,
on
not
behalf
you,
of
sir.
On behalf of the advocate, which is subject to leave of this honorable. Because I, as per the Karnataka High Court, I can seek leave of my lord. That's why my first submission.
No, the court is not particular on that, whether you appear or anybody. Ultimately, it's what the court wants is.
Because it's their affidavit, they were wanting me to explain it, therefore. I'm not saying anything more. What is on the affidavit?
No, what do you say on that? What they're trying to submit and what they state and what has happened? Do you feel that there is anything in
I
that?
would fairly say that if they agree that that is their number, and if they file an affidavit to that effect, and then they would say that they have noticed it. Obviously, factually, it's wrong. I can't say otherwise. I think my other friend will agree.
What has happened? The matter has come up. That day the court has not heard. In the morning, the caveator was not there. Again, the matter was put to the afternoon. Afternoon, he was not there. Then I heard him. I said, we'll have it some other day. It has come up on that day.
Clearly for judgment, it was clearly mentioned in the order sheet.
There in that, the court has also recorded that yes, the morning and the forenoon and the afternoon, there is no representation. Heard him in part, post for judgment, giving them one more opportunity. Court has heard him, like spent lot of time. And now, what is the purpose of filing a caveat with all incorrect details? How do you expect that you will be put on notice? Even your name is also not clear.
I think the cause list shows as PM.
That's what you look at the wakalat. Can anybody say it is TM or TH? Look at the wakalat. You will only understand. Even if you were asked to say what it is, you will say it as.
My lord is right on the top. It could be read as TH or, but at the bottom, I think it's a little. The top, my lord is right. I can't. It could be read as even. The top, my lord, is what my lord is trying to. So at the bottom, it is shown.
No, what the court understands, right, from what all the years is they want to file a caveat and they do not want to pursue it. And let's just see what happens, how the court reacts to it. Basing on that, then we'll come into picture and take care of the other things.
For this honorable court. It's a serious matter. Nobody would, my lord, take a chance litigation to file a caveat because they have good grounds to argue they are innocent. And the fact that a person would file a caveat is to, and that's why I'm just bringing it to my lord's notice, not for any other purpose. And I think my lord is going to set it down for hearing on the merits. I just wanted to bring it to my lord's notice.
No, what I said was, do you argue on the merits? We'll see. You please argue. Yes.
As per section 60 of.
Give that order.
Manoj, we have put a statement of objection. Manoj, can I place it?
Yes, yes, yes.
Basically the pleadings before the.
Yes.
file go. I don't think there's any new document.
We'll take up this matter at 2:30 so that we'll complete the main list.
This take only 10 minutes.
Yes. Take that.
See, their appeal memo at paragraph number 4.
Yes.
Paragraph number 4. The controversy is in this little. Oh my lord, I'll just take 10 minutes. My lord, you should see from the bottom, the 10th line, a fresh mortgage.
Yes.
My lord, a fresh mortgage dated 29/6/2017 was executed by the plaintiff and the father to secure the loan to a tune of rupees 15 crores. However, this is what is the entire case about. The earlier mortgage dated 30/8/2013 for the aforesaid sum of 8.5 crores was discharged by executing a discharge deed receipt dated 27/6/2017, and soon after which a fresh mortgage deed came to be executed on 29/6/2017 by the plaintiff and her father against the loan of rupees 15 crores, which the plaintiff dispute the same, in spite of the same being registered before the concerned sub-registrar. Along with this, para 9.
Yes.
It is also brought to the notice of the court below that the present suit filed by the respondent plaintiff is to protract the recovery proceedings.
You're reading which para?
Para 9, page 9, my lord, of
Yes.
18 minutes. It is also brought to the notice of the court below that the present suit filed by the respondent plaintiff is to protract the recovery proceedings. The appellant is not in a position to recover his due The pleadings are none and the same, which is a stereotype when compared to the litigation posted by the plaintiff and a family member. Further, insofar as the loan amount disbursed, this is what is relevant, to Vaishnavi Infrastructure Corridor Private Limited, while account number so and so, the plaintiff's father is the managing director and his wife is one among the directors. The transfer of money was made to the said company upon the instructions of the plaintiff and her father. The plaintiff's father had utilized the loan granted in 2017 in order to cause delay and embarrassment. My lord, the narrow scope of this matter is, in para 5, they say that the loan was discharged. According to me, my lord, please see my documents along with the claim, my right, which I filed just now. Page 27. Page 25.
No, before you submit that, whether the surface proceedings were initiated by the bank or not.
Yes.
When were they initiated?
Archa chemicals, my lord, para 53 says if there's a fraud, I'm entitled, I am aware of section 34, I'm not on that. Section 60 of the Transfer of Property Act grants me a right to redeem the mortgage before the property is sold. Telecast chemicals, and if there's another judgment, I'll claim for my lord. My only short submission is this, my lord, that I had an individual right independent of my power to show that, my lord is pleased to see the sale deed at page 25.
No, that is filed by you. What has happened to that, the other proceedings which are filed by you with regard to the very same litigation?
There are 3 borrowers.
The wife filed, the father filed, the sister, no, the daughter files.
My father, my mother, myself. I have agitated my right, coming from an independent right under the sale deed. Please see in page 25.
Yes.
Is my sale deed. Page 27.
When was it executed? What is the date of?
17/1/2013.
By whom?
By my predecessor in title. My father purchased, it's not a gift during the pending of the litigation. That's why I'm placing it to my lord. In page 27, I'm shown as daughter of so and so.
Yes.
Now please see the loan document. My lord, I want to say for my lord, all the documents are ready. The controversy is limited to only 2 words. Whether after discharge of the loan of 8.5 crores, was I given 15 crores? That's all. Now please see the deposit of title in page 47.
Yes.
This is dated 17th January 2013. And at the bottom, my lord will be pleased to see. I mean, on the first memorandum of deposit of title,
Yes.
second sentence, Bhavana so and so.
Yes.
And at the bottom, my lord is pleased to see the signature.
Yes.
Now, my lord is pleased to turn to page 71.
Your mortgage is property
Please, my lord.
for obtaining the loan.
Yes. Page 71.
Yes.
Page 71. Is the deed of discharge.
Yes.
This deed of discharge is
Yes.
executed on 27th January 2017.
Yes.
And my lord, please to see the second unnumbered paragraph.
Yes.
Before the recital, now this deed is necessary.
Yes.
Whereas the borrowers
Yes.
have paid the entire amount due to the bank in respect of the loan transaction. My lord, please to see that.
Yes.
Yes. So according to even the bank, as of 27 June 2017, the entire loan has been discharged. And this is a registered document. And at the bottom left is my signature.
Yes.
My lord, it says, in page 86 is a possession notice, and there are series of proceedings initiated, which my learned friend has already explained. That's at in page 86. Now, independent of this, amongst other proceedings, my father had approached this honorable court at in page 147,
Yes.
seeking for certain information. And the operative part of the order, this is with reference to in page 153. With regards to the information. My lords, my entire case is summarized on this basis. That after the deed of mortgage was cancelled, the bank takes a contention that on my consent, therefore it has to be in writing. Money was dispersed to me and then given to my father. I deny that. My father has got a direction to ask them to produce this document. They have not complied. Now the law, my lord, in that would fit whether they have any document, then I'm not sure. If they show to this honorable court that as on that particular.
After the discharge of the mortgage, your documents are not released.
Please, my lord.
After
No,
the discharge
I
of,
fixed mortgage 2 days later. What I'll submit for my lord's time that there are instances which even I. would
no,
say-
1 minute.
Yes,
No, first is, initially that was mortgage, according to you, it is discharged.
yes.
Thereafter, loan was obtained. Again, this property is mortgaged for that loan which you have taken.
A fresh document, my lord, is pleased to see, my learned friend has produced on 5/8/24, memo of documents.
Hmm.
You see in page 28. In page 28.
Yes, 28.
Yes. This is executed.
Hmm.
I mean, my signatures at the bottom.
Hmm.
And we see the unnumbered paragraph 2. Whereas the depositor being bank member intend to deposit the title for the purposes of availing of a loan of 15 crores.
So according to you, after executing this document, an amount of rupees 15 crores is not dispersed.
Is not. That is the
Hmm.
controversy.
Hmm. Yes.
If they are able to place before my lord a document to show that I have authorized, first of all, they should have released this money to me. Second of all, I should have authorized that. There are cases that I authorize somebody else to receive it. I'm only saying I have an independent right of my father. That right is not diluted. My father would have done right or wrong. That is different. It does not compromise my right. Because
Who are the borrowers?
Please, madam.
Who are the borrowers?
Me and my father. Me and my.
So if you are both of you have jointly borrowed the money.
Yes.
So according to you, because you have mortgaged the property, that should come to your account, not to any, for any joint purpose, for any joint account of your, or it is of your father.
Well, if I would.
So is it your case that it is not given to you or it is not even given to your father?
As per my records, it is not given.
Hmm. So it is your case that because property belongs to you, amount should have come exclusively to your account.
Or I should have given an authorization.
So when there is when you're, when two people are jointly borrowing the money, for that, they will mortgage a property. Law doesn't say that because A and B are the joint borrowers. So because property belongs to B, that the amount should be transferred to B's account.
Their contention is that it is given to a corporate entity called Vaishnavi something.
That is how it
That
is.
has- But their contention is further that I have authorized this payment. They have two contentions.
No, when you applied for no, let's see now, like, for what purpose they have sought for the loan.
For closing the earlier two loan accounts. For a moment, I may take your lordships. I don't think they have, in fact, this copy was served to them in advance. In your notes, page 160 may be kindly seen, document number.
160 of the documents
Yes,
you
yes,
passed
yes,
on.
yes.
Hmm.
All these documents are placed before civil court, my lords.
Hmm.
Page 160, it's a statement of account.
Hmm.
Lords, the account will stand in the name of Srinivasa N and Bhavana S. Both the plaintiff herein, the respondent number 1 herein under father.
Hmm.
Lords may kindly see the transaction dated 29/6/2017. 15 crores has been disbursed to their account. Lordship may kindly come little bit further down.
Hmm.
29/4/2017. 13 crore 27 lakhs is
No, no, no,
transferred to
no.
Vaishnav
No,
Infra.
I can see 29/6/17.
15 crores credit is to 15 crores.
Huh.
And further, my lords, in the debit column, if your lordship comes little bit down, a 13 crore 27 lakhs. Same page.
Hmm.
13 crores 27 lakhs is dispersed towards Vaishnavi infrastructure. Means the my borrowers have transferred this money to 13 crore 27 to Vaishnavi infrastructure, another 1 crore 47 to Vaishnavi infrastructure. My lords, I have produced the statement of Vaishnavi infrastructures
No.
also.
Please again come back to page 160.
160, my lords. 160, 15 crores is dispersed in the credit.
That is 29/6/2017.
Yes. Further
Loan
transaction.
amount dispersed to loan so and so is 15 crores.
Yes.
And then
Down the line, they are the debits, which are the expenses which has been done by my borrowers, the account holders.
Mm.
Down, the two main transactions are there to the extent of 13 crore 27 and 1 crore 47. 29/6/2000.
13 crores, 30
Yes,
crores,
yes, yes.
75.
This was transferred, the lordship will see,
Mm.
Srinivas to Vaishnavi infrastructure, that our father has transferred this money to Vaishnavi infrastructure.
Mm.
Kindly come to the statement of account produced by me with
Mm.
respect of Vaishnavi infrastructure. They will not deny the fact. In fact, before civil court, before high court in the writ petition they filed, we doesn't know who is Vaishnavi infrastructures. The father of the Bhavana under second wife are the directors. The articles of association is also produced before this court as well as before civil court, which demonstrates that they were the directors. Now, your lordship may kindly come to page 187.
187. This is Vaishnavi
Yeah, your lordship
infrastructure.
will tell him Vaishnavi Infrastructure Corridor Enterprises Private Limited.
Mm.
Your lordship will see the credit on the very same day. 13 crore 27.
No.
Page 181.
Mm.
Your lordship-
Vaishnavi infrastructure.
Yes, two credits are seen, which was transferred from there. We'll come to this account. In the subsequently, my lords, two debits are there. Loan closure. This loan were closed. Earlier loan what discharge deed were there. Those loans were closed to the extent of 8.5 crores. Page number 170. Loans were closed. And subsequently, other money has,
To 181.
my lords, yes, my lords,
181 is statement from 21/3/2014 to 27/9.
yes. 29/6/2017, your lordship will see, ma'am.
20?
Sorry, my lords, 171. 171. Sorry, I'm sorry.
There's some confusion with regard to the numbers which you are showing. I'm
Yes.
not able to see here.
I'm sorry.
170?
171. 23/6/2017. The statement will start from 23/6/2017. Lordships gets it.
You please tell the date. Date of transaction is what?
Date of transaction is 23/6/2017. Starting transaction. Statement from 21/3/2014 to, Lordship will find it in the post date. First credit will be 13 crore 27.
That is 21/3/2014 to 27/9/2020.
Yes, down the date statement will start down. If your Lordship go further down, 23/6/2017.
23/6/2017.
Yeah, you just Lordship
Is
may kindly
is,
credit
13,27,000.
is 13 crore 27 lakhs.
13 crore 27,000.
This subsequently, my lords, debit column may be kindly seen.
Mm.
Two loans are cancelled, 6 crore, 7 crores.
Mm.
And balance money is also transferred to his account, which he transferred from his account. He has used it as per himself. But the strangest part is, this transaction took place in 2017. Until 2019, I issued demand notice. Not even a single representation, single complaint, any of the grievance has been raised by the plaintiff before the civil court or by our father. Only after I issue demand notice, all these contentions are raised. And all these documents were placed before civil court. Lordship may kindly come to 13-2 notice reply given by our father once I issue demand notice.
Where is that?
That is in page 61, my lords. Sorry, my lord, that is in page.
So many numbers in one page. What is that you want to show? 13?
He admits of having received the loan. He tells that kindly grant me some time.
24/2/2023.
This is on page number 51, minutes. Page number 51. 7/1/2020. This is after I issue demand notice, a published demand notice. This is given by our father. As regards to the contents of para number 1 and 2 of the notice is concerned, the same is in the matter of record. The financial assistance in terms of annexure 1 was sanctioned against the security of assets mentioned in the annexure 2. Therefore, further clarification is not required. He admits of having utilized this loan. And here, none of the, in this entire objections, clause 13.3 is a foundation where a borrower is permitted under SURFACE Act to raise objections on the demand notice. None of these contentions which is being taken forthwith later stage has not been taken in the demand notice. And even most recently, my lords, he has come to bank. I just place these records. He has come to bank. He has executed additional mortgage to sub-register office to secure this loan for only grant of additional time to repay this loan. After that fails, he files this civil suit. I'll just.
Not necessary. That's not necessary. Yes.
A fresh mortgage deed is registered.
Yes. What do you
And
say?
I'll only one clarification with respect of Madia Chemicals. Lordship may kindly come to civil court judge as considered the fact what my learned friend had told. Obliged.
Yes.
My limited submission is only that.
Please come. This court on 6th August 2024 had allowed the appeals filed by the bank and orders passed in I number 1 and 2, invoice number 7855/2023, dated 12/6/2024. Passed by the 22nd Additional City Civil and Sessions Judge Bangalore is set aside. And also directed the court to decide the petition within a period of 6 months from the date of receipt of the copy of the order. Where is that case sheet? It's here only. On 5/8/2024, as for the order passed by this court, it is observed that in the morning session, as there is no representation on behalf of the respondent caveator, the matter was passed over. Even in the afternoon also, there is no representation on behalf of the respondent caveator. Heard the counsel for the appellant in part, posed this matter for judgment on 6/8/2024. Even on that day also, as there was no representation on behalf of the caveator, this court had allowed both the appeals. Thereafter, application, the IA number,
1 of 20.
IA number 2 of 24 is filed to recall the order dated 6/8/2024. And IA number 3 of 24 is filed to condone the delay of 5 days in filing the recalling application. It is stated that the affidavit is filed by one Mr. Jagdish, stating that he is on-record counsel for the caveator in the appeal. That a caveat petition is filed before this court on 19/6/2024 as an order is passed on 12/6/2024 in their favor. At the time of filing of the caveat petition, he has forgotten to write the email ID, that is jagdishramchandra@gmail.com, and his colleague Nandakumar TH email ID kumar.26386@gmail.com is in the petition and Wakalatnama. But he had written his phone number on the Wakalatnama for service. It is also stated that his name is not shown in the caveat petition and his colleague's name is shown as Nandakumar TM and instead of Nandakumar TH. As for the court daily cost list dated 5/8/2024 and 6/8/2024, the colleague's name is shown as Nandakumar TM for caveator instead of Nandakumar TH. Because the name was mistakenly shown and the colleague's name was not shown in the cost list, and hence they have no knowledge of the listing of the matter, on both the state. There was no, as such, they have no knowledge about the appeal filed before the court, and recently on 5/9/2024, the respondent informed about the orders passed by the court on 6/8/2024, allowing the appeal. Immediately on 5/9/2024, they applied for the certified copy of the appeal and received the certified copy and filed the recall application on 11/9/2024. It is stated that when the matter is posted for hearing on 21/9/2024, office has raised an objection with regard to the delay of 6 days in filing. Hence, they have come up with an IA to condone the said delay and to recall the order dated so and so. When the matter came up for hearing, this court had perused the affidavit that is filed and also the caveat that is filed. On the face of it, the facts that are stated by the respondents, by the caveator, that is the affidavit that is IA number 2 and 3, and the caveat that is filed before the court. Absolutely, there is no connection between the two. In fact, in the caveat petition, the caveat. In the caveat petition, it is stated that the advocate's name is Mr. Nandakumar, whether it is TH or TM, which cannot be seen from that. The email ID is shown as nandakumar@gmail.com. And they have also furnished a phone number. When this matter came up on the last occasion, learned counsel, so representing the petitioner submits that the name was wrongly mentioned and the phone number was given, which do not belong to any of them. And the email ID on which the petty appellant had sent the notice or the papers of the appeal memo also do not belong to them. And in fact, their email ID is like their email ID is so and so in that. When the matter, when the council, what's your name?
My name is Ajesh Kumar, for the
So and so, please write. So and so has sought the permission of the court to represent so and so. Accordingly, permission is accorded. This court is not convinced with the reasoning that is given by the caveator, and on the face of it, on affidavit, all the statements that are made appears to be not the correct facts. In spite of that, the court wanted to hear the counsel appearing for the respondent, and the argument that is put forth by the counsel for the respondent is, plaintiff is, that initially both the daughter, that is appellant herein, and her father had taken a loan and they mortgaged the property. Thereafter, as they have paid the amount, the said mortgage was discharged. And according to the bank, they have given 15 lakh rupees. 15 crores of rupees by mortgaging the property belonging to the daughter. According to it is the case of it is submitted with the land council that amount was never given to the appellant, to the plaintiff. That amount was never given to the plaintiff, nor she has given any kind of intimation to the bank to disperse the amount to some other person. According to her, that is the fraud laid by the bank. Though surface proceedings are initiated, they have approached the court in the light of the law laid down by the Honorable Apex Court in Marida Chemicals that Canada Chemicals, when there is a dispute when there is a, when a question of fraud can only be decided by a civil court and the same cannot be decided in the surface proceedings. In view of the same, the trial court was right and the trial court was right in granting injunction, restraining the bank from taking coercive steps. What is that order?
Section 14 order.
Uh,
Section 14 order.
no, bank, what was the injunction granted?
Not to dispose and not to alienate. Two IS.
Granted not to dispose
Not
and
to alienate.
not to alienate. This court has perused the material on record, which is placed before which is part of the record of the trial court. As per the same trial, the counsel for the bank had drawn the attention of the court to the statement to the bank account, which is held by both the plaintiff, respondent and her father. Page number
116.
116. Filed on 5/8. These numbers, they're writing.
That is in the list of documents given by me.
It is filed by them, filed by you.
Filed by us, my lords. Filed on 5/8/2020.
Correct. That numbers are that's a whole confusing factor. You have erased, wrote 3, 4 numbers.
Document number is 11. my lords.
Where do you get the document numbers?
Page number
1 minute.
150.
There are only 5 documents. As per your,
Sorry, my lord. Page number 160. my lords. Page number 160. 160.
and yes, placed before the court, statement of the bank account of the plaintiff and her father, which is in their joint name, that is Srinivasa N and Miss Bhavana S. As per that, on 29/6/2017, there is a debit from the loan account, an amount of rupees 15
There's
crores.
a credit to the, this is
Credit
from,
to the,
from,
credit to the
credit
loan,
from the loan account, credit from the loan account.
credit from the loan account and a transfer of
13 crore 27 lakhs.
13 crore
27 lakhs.
In that page, it looks as
Yeah.
13 crore 75 lakhs.
27 lakhs.
The same day.
Yes, on the same.
Dated?
29/6/2017.
Yes. So there is something, some confusion with what you are referring and I'm seeing.
I'm a pass on this.
Please pass on. On 29/6/2017, an amount of rupees 15 crores is credited to the joint account of the plaintiff and her father. And on the same day, in favor of Vaishnavi Infrastructure, an amount of rupees
13 crore 27 lakhs.
13 crores 27 lakhs is dispersed, is debited,
Transferred. And one
is transferred
on 1 crore
to their account, and another amount of rupees on the same day 1 crore 47 lakhs is transferred to the account of Vaishnavi infrastructure. He has also drawn the attention of the court to the account of Vaishnavi infrastructure, wherein the credit in their account is also shown. It is submitted that the father, when he was unsuccessful before the court, then the mother has filed the suit. And there, when she was unsuccessful, then a writ petitions were filed before the court.
Mother as well as she is a power of attorney holder in the plaint in the present.
And now the daughter has come up with this. He submits that this court on the has considered all these aspects and passed an order, and no grounds are made out seeking review of the order, seeking to recall the said order. Next part. This court, having heard the counsels on either side, peruse the material on record. First, the reasons that are stated by the petitioner by way of IA number 2 and 3 are not at all the grounds to recall the order. And this court feels that there is the respondents have have filed this petition with all suppression and misrepresentation of facts. Then the contention that is advanced before the court that there is no amount transferred to her account is also falsifies by the account of the joint account of the parties, which shows that only for the purpose of getting an interim order when already a surface proceedings are initiated. The respondent plaintiff had approached the court. This is nothing but a pure abuse of process. For all this, the latches, for this kind of submissions before the court, with all by suppressing when already the record is placed before the court, their bank account speaks about 15 crores amount that is transferred, and still without appearing before the court when an order is passed, filing a caveat with all the incomplete details, this court feels that this is a pure abuse of process of law. Accordingly, I number so-and-so is dismissed with costs of 50,000 to be paid to the Advocates Association within a period of
Statement was also produced by.
50,000 to be paid to the Bar Association within 4 weeks from the date of receipt of the copy of the order. Yes, next.
Cell number 3. Cell number 3 adjourned. Cell number 4. Vinod Prasad. Petitioner. Lokesh SG.
Yes.
Husband's petition, my lord. Against the interim maintenance of rupees 5,000 amount.
What is the interim order?
Interim order is to pay her 5,000 since 2018.
Are you paying or not?
There is no,
You are paying you're complying with the interim order?
no, because I have not paid anything because there is not of stay by this honorable court. Then, as per annexure A to the writ petition, kindly page 20 amendment kindly be looked into. That page 20 is a joint petition seeking divorce.
According to him, he had paid an amount of rupees 3 lakh to the respondent.
That amount is with
Is
her
it
now.
correct?
That amount is with her now. Let me explain. That 3 lakh is with her now. At the time of marriage, I have purchased a site.
How did you pay this 3 lakh rupees?
That site which I have purchased in joint name of mine as well as hers. She has sold the property for 7.5 lakh on paper. And in fact, it is more than 30 lakhs. She has sold, she admits that she has sold. Kindly, the sale deed is I have produced.
When did she sell the property?
Pardon, my lord?
When did she sell the property?
Subsequently,
There should be some date for that.
I'll give the date that, property she has on 28/7/16 for 7.5 lakhs on paper. Entire property she has sold. Though she is entitled for 50%, she has sold entire property. Market value is 23 lakhs.
For this matter, after vacation, on 21st of October. Yes, next.
Number 5,
Intermodal granted is extended till then. We'll see.
Babu TC.
For the.
Yes.
My lords, in this case, the file has come up to the in the pending branch on Friday, my lords.
Huh?
Which on Friday, the file had come to the pending branch on Friday, my lords. I couldn't seek the DD which I had deposited. So I have bought the fresh DD today in the name of Varsha. I just give it. This is with
What is the
respect to
amount?
30,000 and 20,000.
What is the order on the last occasion?
Before Thursday.
Upon submit that says comply with the order passed by the court, Canada Bank preliminaries deposited the.
Very same
I
day.
mean, already fund.
Yes, my lord.
Though they have account details, they have prepared the DD instead of transfer the amount of their account.
Anyhow, take it. DD is also money. Please take it. What is the amount?
30,000 and 22 lakh
30,000.
and 2 lakh.
Land council for the petitioner has handed over 2 checks for an amount of rupees 30,000 and two DD for an amount of rupees 30,000 and 2 lakhs. To the council for the respondent, post this matter after vacation on 28th of October. Next,
IA extension.
intermodal earlier granted is extended. Yes, next.
Number 6. Siddharth B. Muchandi, petitioner.
I'm for the petitioner, your
Yes.
lordship, wife, seeking enhancement in the main.
Notice to the respondents, petition is permitted to take out notice on the council appearing for the respondent with the trial fellow. And shall file a memo to that effect by 28th of October. If the memo is filed, this is matter on 30th. Yes, next.
Cell number
Achok,
7. Sarath Gowda GB.
For the petition, my lord.
Yes,
Nisha.
Kindly pass over, my lord, the.
let's see what is it. You said the other matter, the council on record is not,
My lord, the council, arguing council is Vidya Gowda. In this, GB Sharad Gowda is there.
so no interim order granted by this court.
In the other matter where they have filed a WP, the interim order is granted.
Is there?
for,
Yes. Pose this matter after vacation. In 7.1, the interim order earlier granted is extended till the next date of hearing. Pose this matter on 30th of October. Yes, next.
Cell number 8. Cell number 8. Party in person.
Petitioner, my
legal
lord,
support.
appearing as party in person. My lord, in this case which I am seeking the writ petition, it is an MC case filed by husband for the divorce.
Page number, where is the order?
Annexure E1, my lord, page number 64 to 80. That is a certified copy of order sheet in MC 209/2022.
Which is impugned now? Page number 80 is impugned.
60, last page number 64 to 80. The my lord,
Can't engage a counsel, will ask somebody to appear legal service.
my lord, can I submit a few matters? Because in Kerala already, I was the first one to file a divorce petition. I had a counseling.
I'm not able to understand what is the order impugned.
Oh, okay.
What is the order impugned?
Okay, my submission, my lord, in Kerala, he came for a settlement agreement. Settlement conditions were written. As per the conditions, he agreed.
Please,
He
let
will,
us see, let us see.
he
what
will
is your-
withdraw this case. He has
Please
written
come
in the.
to the prayer. What is the prayer you are seeking so that the court will understand what is that you want.
Okay, prayer.
Let's see, where is the prayer of yours? to direct the respondents to pay 1 crore for compensation for mental agony, cheating and physical abuse induced to the complainant and her minor child, to dispose application IA number 13 seeking for production of documents, to direct the judge to undergo
To
seek
direct
a
the
direction
respondent
to
to
the
undergo.
respondent to undergo medical examination of
Importance.
impotency test as per application IA number 12, to direct the third additional judge to dispose of the matter within 3 months in MC number outcome of the
3129 of
impotency.
2023.
Can all this be granted by this court?
My lord, two IAs also I have filed, IA number 1 for the stay of proceedings, and
Why should that be stayed?
he has agreed, he will withdraw this MC case as well as there is a property case, OS 2892. Both the cases he is not withdrawing. As
Why the court is saying that you need an advocate, you have so many grievances, but all cannot be redressed by this court. There is a forum for everything. So, no, you can't seek these many reliefs in a writ petition.
Okay.
And 2023 matter cannot be, no, you're coming to your relief number 4 to direct the court to dispose of the matter within 3 months. That cannot be done. It's an MC of 2023.
And that is expeditious disposal I am seeking because
That
I am the
can't be,
petitioner
because in
that.
2023 matters, we are not granting such orders. Because there are several matters which are pending even before you, the
My lord,
2019.
there is a condition of nullity in our marriage. That is why I am seeking.
No, all that has to be decided by the court and it has to be decided in a due course. Then number 1, for this mental agony and all, this court in this application cannot grant any relief.
My
Come to
lord,
your prayer at page number 30. 30 of the papers which are filed before the court. It appears that you also do not have the
yes,
complete
yes,
set.
I have, my lord.
Look
No,
at 30.
Yes, page number 30. These are my
Look at
prayers. One more submission, because I didn't know, okay. I have filed a criminal petition and I seeked for the stay of the same matter. Then the court hold number 17 judge directed me to file GMFC case. That is why now I am filing the IA for stay here. Otherwise, earlier I have filed in that court and that court has granted a expeditious disposal in the criminal matters, like criminal miscellaneous case as well as the domestic violence case. My lord, because 3 years I am running behind the court with a minor child, no remedies, no interim maintenance, nothing, my lord. We are made to starve to death. And I have to take care of a small child. How will I without any?
Please understand. Court understands all your difficulties.
Um,
No, you're not, please understand, you're not getting maintenance.
Yes.
If that application is not disposed of, if you can tell the court will ask the trial court to dispose of that application. But court will not take a, in your case as a different case and tell the court that 23 matter you dispose of, keep pending all 2019 matters.
My lord, see, he has written a settlement agreement, page number 41 to 55, my lord. Kindly see the settlement conditions he has written, my lord.
We'll appoint an advocate from the Legal Services Authority. She'll be of some help for you. It won't happen like this. Because you don't know what kind of petitions are maintainable before this court or not. You can only know about your problem. But the solution has to be if a advocate is there, then he'll be able to tell you all these can't happen.
My lord, in Kerala court, my counsel only cheated me. Whatever my petition, she changed that petition with a false sign of me, and whatever alimony I have asked, like 1 crore, she changed it to 5
You
lakhs.
have one option.
So
If you want, we'll appoint.
I'm kind of
please
scared
understand,
to
We'll
even go with an
we'll
adjournment.
appoint a counsel from the legal aid. If not, nothing can be granted in this. Because the manner in which it is framed, none of the reliefs you sought can be granted by this court. If any IA for maintenance is pending, please tell the court that will direct the court.
That is already expeditious disposal. I already got the direction, my lord. And this is the condition which he has written in another matter, my lord. It is the same divorce. Actually, this MC 209 is a res judicata divorce petition, which is running by.
Res judicata has to be decided by the trial court. Please understand.
My lord, I have filed the IA. 1 year my IA is pending, and they are not even giving me an order in that, my lord. That is why I am seeking.
Where is that IA?
IA number 11, my lord. Annexure E2, 81 to 86, my lord.
IA number 11, when is it filed?
It is, I have filed soon after the disposal of the care.
Should be a date for
2023, my lord.
Huh?
In the May, my lord.
Have you filed here? That where is that I number
Yes, sir.
11?
IA number 11, my lord, page number 81 to 86.
Hmm. We'll ask the trial court, family court to dispose of this within a period of 3 months.
My lord, one more IA, that is the IA number 12, Annexure F, page number
What is
140.
that I number 12?
And that is to direct the respondent to undergo medical examination of impotency test, my lord. Because he is telling because child is there, I cannot pray for nullity. The child is born through donor sperm IVF treatment. I have already produced the same document before the court. But for the evidence, I needed that, my lord.
Please come. The present writ petition is filed seeking the following prayers, extract all that. The party in person has submitted submitted to the court that the marriage had taken place in Kerala. And from the last few years, she has been roaming around the courts and along with her son, and not able to get any relief from the court. It is stated that she has filed I number 11 and I number 12. I number 11 is filed. That these proceedings are barred by res judicata. And I number 12 is filed, seeking a direction to the husband to undergo the medical test. It is submitted that the said applications are pending consideration before the court. This court has perused the prayers that are sought by, no relief can be granted with respect to the other reliefs, as desire number 11 and 12 are filed in the year 2023. The trial court should family court should consider the same and pass appropriate orders in accordance with law within a period of 3 weeks, 3 months from the date of receipt of the copy of the order. No, this court is not proposing to issue notice to the respondent as expeditious disposal of the matter is in the interest of both the parties. Is next.
Cell number 9, Purnima.
Yes. Which case? Fourth matter, interim order earlier granted is extended. Yes, next.
Cell number 9, Purnima.
No representation on behalf of the petitioner. Pose this matter on 21st of October. Yes, next.
10 urgent, cell number 11. And K.
Petitioner.
Yes.
This is the wife's petition, my lords. Earlier round of litigation, my lord, your lordship, are pleased to pass an order annexure K, page 79. My lord, this honorable court had directed, my lord, the trial court to conduct an inquiry with regard to my application, my lord, for appointing a guardian. Because, my lord, the petitioner wife was of unsound mind and not able to, my lord, defend herself in the case.
Where is the order?
My lord, order is at page, observation is at page 79, annexure at page K, annexure K at page 70, relevant portion at page 79.
No, I'm asking you about what is the impugned order now?
The impugned order, my lord, the relevant portion, my lord, is that the entire order sheet I have produced, relevant portion, page 132. It starts at page 132. Relevant portion at page 137. Lord, despite medical certificates being produced, saying that the wife is suffering from schizophrenia and her judgment is impaired, my lord, the learned judge, my lord, conducts a 10-minute video conference meeting with the wife and comes to the conclusion that the wife can defend herself. I had even filed an application for appointing an expert by the court. Even that is also not considered, and consequent to dismissal of IA number 4 for appointment of guardian, IA number 8 is also dismissed. That is for appointing an expert from the court. Now, in case, my lord, after 10 minutes of conversation, the judge was of the opinion that, my lord, she is capable, then, my lord, that application could have been allowed. And
what do you say?
Order sheet dated page number 120.
120? I think if I remember in this case, it is also your case that wife is mentally unsound.
Yeah,
Demonstrate.
his own petition,
I
he says,
demonstrate.
he says,
He has filed an IA 8, thereafter he filed an IA 9, number 9 to get through the.
No,
inquiry.
if an ex-friend guardian is appointed, what is that you lose?
Have a look at Millet. If she considers that I am suffering from mental illness, you must take it as it is considered. You must
not
straight
a
away
person with
appoint the
mental
guardian.
infirmity,
What?
how can she concede?
What?
Medical opinion is there, and my learned friend wants me to concede. I am nobody to give an opinion here. Medical opinion is there.
Yes, 126, what is it? 126?
121.
20?
121 of the, after the
Yes.
disposal of the reputation.
Yes.
But on 19/7, the order is placed on the court, hold before the trial. Next, on 22/7/2024, both the parties are absent. Mr. So-and-so appearing so-and-so. AK for case is advocate for the respondent, praise time. See the conduct in the praise time. Next, turn to 27/7/2024. Once again, you got that. Appearing for the documents, counsel 15 days time, keeping the parties for the respondent. The time bound order has been made by this court to dispose of the application within 2 months. Can you see the content? On 27/7/2024, once again time. Next, 3/8/2024, petitioner absent so and so. The mother respondent by saying is present, appearing place 10 days time to keep the parties present. Next, 5/8/2024. The respondent absent, mother is present, so and so. I advocate appearing for the respondent praise time. The appearance of the respondent once again absent. Next, 7/8/2024, both the parties are present, so and so, AK filed certificate dated so and so, Kasturba Hospital. As per the medical record, I also so and so examined Dr. on so and so. Here the advocate is appearing for the petitioner submits that the application is not cooperating with the proceedings in compliance of the order dated so and so. Next, kindly see that next 17/8/2024, both the parties. In that end of the moment she files an application under 8. Now, after filing of this application, on the second day, on 28/2024, another application is filed. It is not been produced before court. Kindly see this happen. Instead of IA number 8, she prays that she herself shall be examined by the court through video conference. That is the mode of handling.
That was allowed.
1 second.
IA number 9 was allowed. And that is how, my lord, the judge.
You didn't want her to be examined by a doctor, but by the court.
Yes.
My lord, no. My lord, I filed.
What is the purpose of this application?
My lord, that application, because, my lord, she was, my lord, now she is residing in Dehradun. My lord, she could not travel. So that is why, my lord, we file an application so she can be examined through video conference.
When the matter came up before the court passed an order.
Yes.
In a time-bound manner, orders were directed to be passed.
Yes, that is
You are
true,
a
my lord.
party before the court. How can you seek these many adjournments?
My lord, you
can come up with
because your
some
lordship may
application.
kindly see.
No, you only invited it. And court has.
My lord, your lordship may kindly see, my lord, the medical certificate.
She is fit.
My lord, your lordship may kindly see the medical certificate, my lord, at page
But you
83.
didn't want a
84.
medical
No,
certificate.
not only mental infirmity, my lord, she is also having some physical.
Why did you ask for this is the question. Why did you file
No,
this?
because
again?
court, my lord, had insisted for appearance. Because she was in Dehradun, she was not able to travel. I finally, my lord, requested for
Thought
a video conference.
You will keep the judge engaged. Is it what that the judge has no other work? So
My lord, certainly not that. My lord, certainly not that, my lord.
And then
Because, my lord, section application under section.
when you know that, why did you file this application? Nobody asked you to file it.
Nobody asked me, my lord, because she was, my lord, not able to travel. And, my lord, since she
I
had
don't
to be
think that's the
personally
answer for
examined, my
that.
lord, IA number 9 was filed.
If you cannot travel, you cannot travel.
Yes, my lord.
That you can tell the court, but you cannot say.
My lord, we told that. Then, my lord, the judge requested that, my lord, she should be kept present. Then, my lord, as an alternative, we filed an application, my lord, under IA number 9, so that she can be examined through video conference. My lord, that order, that was allowed.
Nothing like it is allowed, and court felt that no.
Yes.
You do not want your medical examination. You wanted the.
Madam, no, my lord, medical examination was filed in the beginning. Initially, medical examination was filed. IA number 8 was filed. My lord, your lordship may kindly see when my learned friend read. First, my lord, IA number 8 was filed for medical examination.
Why did you not pursue it? It's a question. You don't pursue it, you keep
my lord,
quiet,
my lord,
and suddenly you'll come up with some other application.
my lord, no, my lord, IA number 4 and 5 are pending. Then my lord, IA number 8, my lord, I filed 2 certificates that saying from the doctor saying that she is not mentally sound, and then my lord, her judgment is impaired. Then my lord, I filed another application to get an expert opinion from the court so that the court appointed doctor can examine the my lord wife.
What is the purpose to be achieved in from IA number 9?
Then, my lord, the court insisted that she has to be present before the court. That is why, my lord, I said she cannot travel. At least we see, my lord, the court can, my lord,
Court may be pleased to pass an order permitting her to produce the applicant in the court to video to assess her mental and physical condition.
yes, my lord,
And pass
that is,
such other
my
orders.
lord, that the reason was,
Wanted it, she passed an order. Now what is to be done? What is wrong with that? That's what her under, you want her to assess her mental condition. She
no,
felt
my
that
lord, the
is-
judge,
she's all right.
my lord, there are 2 types of inquiry, your lordships, my lord, on the last previous occasion also I had argued this.
You opted for it.
No, my lord, one is judicial, my lord, where the judge himself questions the person. Second, my lord, is, my lord, to obtain a medical opinion. Now, my lord, I placed 2 medical opinions, my lord, before the court.
Will pass an order on costs of 20,000. Please ask your client if she is like, because courts have a lot of work, then just to have a time pass on this, that you will stay at Dehradun and file these kind of
No,
applications.
my lord, she,
And from
my lord,
there-
she's undergoing
there-
rehabilitation
No,
there.
no,
My
and
lord,
the-
she's undergoing
Shouldn't
rehabilitation.
you tell the court that? Why have you invited an order by filing an IA?
My lord, that is because, my lord, earlier your lordship had directed that, my lord, evidence can be led and, my lord, the petitioner can be examined.
For
That-
that.
That is why, my lord, we file an
If
application for video conference.
if an order to be passed on costs, it will be passed.
He is not at Dehradun. He was very well within the jurisdiction of the court. Kindly see the application which I want out. She was never been in Dehradun. Kindly have a look.
No, in Dehradun, her brother is there. Her brother is there. She was residing with her brother in Dehradun.
Advocate for respondent,
Puttur.
My
Mangalore.
lord, that is her mother's address. Mother's address is in Puttur. Doesn't mean that she can't stay anywhere else.
See. That now the cat is out of
You
the
cannot deny it, your own papers.
Which application? No, I'm-
That is you.
Your IA filed and where it is notarized at Puttur. Show it to him.
That means proceedings all together in the day 1. They file an application under order 7 rule 11 that is going to be rejected. They appear before the court. Take a time and again, file an application at the back end of the court. Then file IA number 9 to appear. The court has done its duty. Now.
My lord, this
actually,
is
where
mother,
is
my
the-
lord. Mother has signed, not the wife. The mother is staying in Puttur.
1 second. Kindly see the averment at para 2.
My lord,
This is the
notary by the mother who is staying in
Let him
Puttur.
be, let him.
Thought is currently living along with me, which means you should be in Dehradun. No,
My lord, it's a too hyper-technical approach that my learned friend is,
No.
my lord, adopting.
Court
My
is,
lord,
in please wait, court is in Bangalore. Court is in Bangalore. Affidavit will be filed, notarized at Puttur. Mother says that she's staying with me. You say that it is hyper-technical, she's staying at Dehradun. How
Lord,
can it be?
she was undergoing rehabilitation
At
according
where?
to my instructions in Dehradun along
But
with her brother.
what are they
And-
doing at Puttur?
Kindly check the page.
Anyhow, please get instructions on 20,000. If your client is ready, then we will pass an order. And
Lord, that
af-
application is
after
not
vacation-
challenged. He should have challenged that order on that application.
post this matter
Your lordship, I have it on 14th, my lord. 15th, the
On
trial
14th.
court matter is
on
14th.
14, post this matter on 14, the request
Obliged.
for, then comes for the petition. Next,
Number 12, Kashina JD.
give those papers to him. Yes. Yes.
Appearing for petitioner, my lord.
Kashina
Yes.
JD.
This, my lord, the maintenance is awarded 20,000 per month.
You're for the husband.
Yes,
How much is the maintenance awarded?
20,000.
What is your income?
The income is 1 lakh. I am not challenging the quantum, my lords. Here.
Mm.
Here the issue is, my lord, he is an employee.
Mm.
And my lord, this issue, my lord, the issue is of the divorce. Under the Muhammadan law, my lord, she is claiming that she is not married. That is the claim. That, my lord, of award is, that our award of maintenance is also confirmed by this court. I am not disputing that. After this, my lord, in the year 2022, I have filed an application, my lord, for alteration of the order of maintenance on the ground that she is working. But my lord, to that effect, I have produced some document to show where that she is working, the profile of the company. And soon after that, my lord, she has shifted to another company. My application still pending. I also produced that profile, my lord. My submission is, my lord, after 2023, consistently, my lord, since the recovery of the entire amount is concerned, I have paid 17 lakhs 94,000. They are claiming that 40 lakhs, even today. But I have produced the, my lord, details of the bank statement along with the relevant affidavit before the court. In spite of this, my lord, 31/7/2024,
Come to the impugned order.
page 31, my lords. Warrant is issued, my lord. Warrant is issued on 31/7/2024. I have paid 40,000 addition to 20,000 maintenance and arrears is concerned 20,000. And my lord, recalling the warrant is concerned on 21/9/2024, my lord, I have deposited 1,50,000.
Page number.
Page 32, my lords. Page 31, where warrant is issued by the family court. May I read? In 32, my lord, I have filed an application for recalling. And then, my lord, at that time, my lord, I have deposited 1,50,000. Here, my lord, the court has said, my lord, to make a deposit of substantial amount. He is an employee, my lord. My application is pending. Even today, my lord, in support.
When is the order passed?
Kindly, madam.
When is the order passed?
It is, my lord, on 3/9/2024.
3/9?
2020.
Not this order.
Yes.
Maintenance order.
Maintenance order, my lord, it is on in 2016, my lord. It is
2016.
finalized by the High Court.
Was it questioned by you?
Yes, that is confirmed by High
It has
Court.
become, no.
I am not disputing.
So then you have to pay.
I am paying, my lord. The arrears is concerned, my lord. I am ready to pay, my lord, along with monthly. The matter out of my salary, my lord, proportionate to my income, my lord, I am ready to deposit in addition to the.
From how long you have not paid, where it ended up in arrears?
Definitely, my lord, definitely.
From how long you are not paying?
It is, my lord, their submission is since 2018. The earlier to that, my lord, what exactly I have paid along in my objection, I have stated 17,94,000 overall is paid.
Had you paid 10, 20,000 every month, this all would have not arisen.
Along with that, my lord, I am ready to deposit additional amount till the disposal of my application. My lordship before the trial court has said,
Now,
you
what
deposit
is the
substantial.
remaining amount according to them?
According to them, my lord, 31,57,000.
So 31 lakhs at 20,000 rupees, how many years you want to?
I'm not saying that.
Pursue this one?
No, 20,000, I'm not ready. I'm not saying to deposit. I'm only depositing 20,000.
How much you will deposit?
I'm ready to deposit, my lord, another 2 lakhs by the next date is 3, my lord. I'm ready to deposit 2 lakhs on that day. Kindly, my lord, after that, I'm ready to deposit 50,000 each date of hearing till disposal of my application, where my application for alteration of maintenance is pending since 2022. Before the same court. I'm not, my lord, I'm not ready to escape from my liability to pay the money. The same time.
Pay for 4 lakhs.
Kindly, my lord, he is an employee. Monthly salary is the only source. He once see, my lord, the issuance of.
You only invited all that. Had you paid 20,000, there was no
I'm only seeking
occasion for all this.
I'm only seeking, my lord, the only equitable relief, my lord, since I'm an employee. If, my lord, this warrant order may be communicated to an employer.
The petitioner submits that the wife is gainfully employed, and in that regard, he has already filed an application before the court. That is IA number?
That is IA number 2, my lords, 2000. It is filed on 12/10/2022.
He has filed an IA. So IA number?
IA number 2, my lords.
IA number 2 in the year 2022. To determine the
12/10/2022.
maintenance. And the said application is pending. It is submitted that he has filed all the documents before the court to show that she is gainfully employed. So far, no orders are passed. It is submitted that paying a lump sum amount of arrears at time is not possible, and he is ready to pay the amount on every month 50,000 towards arrears. And he's also ready to pay an amount of rupees 2 lakhs by?
And the next 3 is the date, my lord, 3/10/2000.
By 2nd October.
Yes, the 3rd October.
3rd October.
Yes.
Considering all this, there should be stay of all further proceeding pursuant to the order dated
31/7/2024.
31/7/2024.
29/2000.
The condition that you shall deposit an amount of rupees 2 lakhs by 3rd of October
Before
and
the-
shall continue to pay 50,000 apart from 20,000.
In addition to 30,000, 20,000 plus 30,000. Otherwise, my lord,
Shall pay. When will you pay all that amount with that?
till my lord, if my lord, my
shall pay
application is
an
disposed, I have
amount
no
of
other option.
rupees, 60,000 every month, along with that, including the maintenance till the application. That's IA number 2 is decided by the court. Petition is permitted to take out notice on the council appearing for the respondent and shall file a memo to that effect by 21st of October. If the memo is filed, is this matter on 23rd.
Kindly, my lords, hand delivery.
Same default, the default clause also. Yes, next.
Maybe hand delivery.
Hand summons, huh?
Hand delivery.
Take that. Yes, next.
I'll take hand summons. I am permitted to serve the,
But petitioner wife before this court, it's a common order. The order on IFI, your lordship, is well appraised because the husband had filed the writ petition. The wife is aggrieved by IA number 8, wherein she is being restricted to take the children out of the jurisdiction. Now, because of vacation, she just intends to take the children for 5 days.
Where is that? 13. Where is the order?
At page 136, my lords. Now, the reasoning, my lord, is at page 145, is a one-line reasoning. If I may just be permitted to read, my lords. The respondent is also educated person and she may take up a job anywhere and there is apprehension of the petitioner for shifting the child. Therefore, considering the facts of the case, issuance of direction is necessary not to take the children. This is all the reasoning that has been given. The court says that the second child is 11 months, no passport, everything it says. But just because she is educated, though in the previous para also the court observes that she has no job and she is staying with the parents. Point number 2 is where IA 8 is addressed, my lords.
Passports are with the father.
There's only passport for the elder child, and that is, I think it is, the court has said that it is with the mother. The second child does not. Actually, there is no passport
should
even
not be
for the
taken?
elder child. There is no caveat, my lords. Sorry.
The child who your lady is supposed to be in the chambers and the.
No, why should, on the vacation, why she should not go out?
But I have asked for petition. I have filed an application in the lower court. The order was passed by this honorable.
You will take her, you can take the kids for vacation and she should be restrained from her.
12/7/2024 was the last day I saw my children, despite there being an order here that I have overnight visitation unsupervised. I am not able to see the kids. From 12/7.
Why you have not given the children for?
Because there is a modification application filed by both the parties, which is pending before your lordship. Now, they say just because grandparents were allowed, the temporary custody should shift to the grandparents.
The difficulty in these matters are like, because the court is showing some indulgence, the parties are forgetting what is the scope of the litigation and coming up after one petition after the other. The court will not pass any orders on that.
What, I'm sorry.
I can understand modification, that the same, and a particular thing. You can't, no, the court will not, the contempt, everything, no, everything should be done in the writ petition itself by filing the application. That's not the scope of inquiry.
Melissa, I also brought it to the notice of the court, what derogatory messages he has been sending to the wife. And that application, I have produced it, my lords, in that petition. Here, what has happened, just last week, he files 3 applications. One for birthday, festivity, and half of vacation, 50% vacation. And the court, there was pressurizing me to file objections. I have filed. I was ready to argue all of those things. In fact, even for the festival, I volunteered that she's ready to bring the child. They did not oblige for that to the house itself. Be that as it. For the vacations, I filed my objections and I'm ready to argue also. However, on 24th September, which is the last date to give consent for admission of the child to the school, he refuses. And they come and seek time to file objections on all the applications in their own application to October end. They're not worried about even 50% vacations. Just because I file an application, asking him to give consent to the elder child whom they both have admitted during the matrimonial life, same school. He refuses to consent. And they take objections, time for to object.
Very unfortunate. Both of you are not fair. Both your clients are not fair. This is not the way the litigation is
Not
fought.
only on the ground, the derogatory remarks, my lord. In fact, I don't want to produce in this petition because it was not relevant. It is not about visitation. But he has gone beyond the limits, my lord. Beyond the limits where he has alleged her. I don't even want to submit before this court as to what he has made remarks against the wife.
We'll modify this
Things are
order.
not are uncalled for. Anyhow, I am before this court on.
File it in the section. How can you file here?
There is no caveat. Looks like they've been observing the proceedings, and I am intending to take only for 5 days. That is all, because the kids want to go. Now, otherwise, I would not have filed also, my lords. Because of Dasara vacation, the kids want to go 5
I
days.
number 5. File, you can file I number 5 and 8. The agreed with orders passed in I number 5 and 8, dated 5th January 2024. The mother is before this court. The trial court.
In fact, there are no passports at all, my lords, for both the children.
Had allowed the application, that's I number 8, restraining the mother from taking the children out of the jurisdiction of the court. The court has observed that the passports are with the children, are with the father, and the mother is a housewife. It's a case of the mother that she won't be taking the children out of the jurisdiction of the court. But for 5 days
That is
during the Dasara vacation, they want to take the children. She wants to take the children out of Bangalore. Where are you going?
No, she wants to go. Actually, there is a family get together in Bombay. From there, she may one day go with the family to Goa. This is all the.
She wants to take the children to Bombay and Goa for 5 days. The court had granted visitation at Children's Visiting Home BMC on every Thursday between 3 p.m. to 5 p.m.
Overnight custody from Saturday morning to Sunday morning, which they have not complained.
No, which court has run it?
Same order, it was a joint order, IA number 5.
And overnight custody is given between.
For the elder child. He's talking of for the elder child, this court
For
had.
no, he's talking about then order passed by the trial court.
No.
Court had enhanced it. This court
The trial court has not passed any order on that.
But this is,
overnight.
when is this order? This is,
Look, this is a common order on 5 and 8.
no, what are this 5th January 2024 order is questioned now?
Look, IA number 5 and 8 was a common order. 5,
No, what is this? Why are you questioning a 5th January order now?
Milords, IA number 8 was to restrain her from taking the children.
Why have you not questioned it till now?
It did not arise. She never intended to take the children outside. Now, because of vacations, that is the reason I'm filing. If she, it is not at all her intention that she wants to
Then
move
the
out.
court has to look at what is earlier order passed by this court. Please place that before
No,
the
Milords,
court.
only, no, IA 8 is different, IA 5 is different. IA 5 is.
It shouldn't come in the way of the order passed by this court.
That is, not at all, Milords. IA 5 is different. Let me.
I
just
can understand what you are submitting. What I'm saying is if the court is giving you permission to leave Bangalore, whatever are the orders that are granted by this court in their favor, it shouldn't be interfering with that.
No, it is not interfering. In fact, there is.
Unless and
May I
until the
submit?
court sees that order and basing
may I-
on that, if you're taking the children away, from Bangalore to somewhere,
Let me-
during that time, how are you going to compensate? It has also to be recorded in the order.
Yes,
For
may I
that
submit?
reason, I have to look at the order.
No, may I submit, my lords? I'll just submit. May I, 1 minute. This court had passed overnight for the son from Saturday morning to Sunday morning. It's not every day.
That's
For the
what I'm
second,
saying.
look, just 1 minute.
Let me have the benefit of looking at the order.
I can produce.
Once, yes, please produce and then we'll pass an order in the afternoon.
Yes, ma'am.
Pass over.
Grateful.
Yes, next.
Cell number 14, parted matters, second BS, for petitioner.
Lords, on the last occasion, Lords had directed, my Lords, that to deposit a sum of 6 lakh rupees, my Lords, for modification of the order. Lords, if my Lords remember, I had also filed memo of modification, my Lords.
Considering the submission and counsel of the party, this court deems that to direct the petitioner husband to deposit an amount of rupees 6,02,000 before this court within 8 weeks from today. If the said sum is deposited within 8 weeks, would pass appropriate orders on the modification sought for by him, as the wife has not received any amount.
Please, ma'am. Lords, I have filed the memo along with.
Also, we'll see.
Please.
Yes, next.
He has deposited the amount as per the disseminate process. And until now, I'm not received. I mean, you should think of any date fixed after vacation. So that
It can, both can be done at a time. Yes, next.
Serial number 15. Hemant Bharadwaj. For
My lord, I am for the
petitioner.
respondent. My lord, it is posted, my lord. My lord wanted to pass orders in the presence of the physical presence of the petitioner.
Yes, what is happening? Why are you know, why is she not complying with the orders of the court? That's why she's asked to be before the court. Tell her, let her say. Then how do you, then how you want to deal with this? With your daughter's state of mind? Is it that if she wants, if you give a medicine to her because something is bitter, you'll not give her? The child will resist generally, even for taking a medicine also, she will resist. Not your daughter, anybody for that matter will resist because it is not tasty. So does it mean that we will only do things which are of her liking? She is too small to understand all this. And you have to think about the future of the child. When you also know that what kind of a state of mind she is it not your duty? By this time, everything should have happened. It only appears that the court is only interested in the welfare of the child than the mother. What the doctor said, you remember what the doctor said? Nimhan's doctors, it is not possible to do that kind of a counseling. Then this court had interacted with the director of Nimhan's. He said, because I just wanted to know personally whether it is possible on coming on a daily sessions and all. He said no. To evaluate her, she has to be there. And you understand, if you're not doing it at this point of time, what will happen to her? Yes. But that point of time, every day she was traveling 25-30 kilometers. Then how do you, what now yes, we'll take what you say, that your daughter is not interested to go. And if she, unless and until she is interested, you will not do anything to her. So how do you want to deal with all this? And you know what is her submission, what she has stated before me in the chambers? And how do you deal with it now? It has to be dealt with, isn't it? And if you're, come up with a problem, come up with a solution. And the court do not want her to be admitted in Nimhan's. You tell the court there is some hospital better than Nimhan's where my daughter can be treated. Then we'll ask the report from that. But not on a day-to-day counseling. It will not happen. That's what the doctors are saying. You also know about it. But you should have done it. And you know when was the order passed by this court? I think it's almost 4-5 months. When was the order?
Absolutely, my lord.
When was the order passed?
13.
Huh?
My lord, the visitation has stopped. I have not been allowed to see my child. My lord, there have been number of orders, my lord, which have been consistently violated by her on the same pretext.
And the problem with your client is only concerned with the visitation.
Not just
when
that.
the daughter is saying so many things,
My lord,
then why he wants to see her?
My lord,
at
my
this
client-
stage with her state of mind now? He has also understand what is this visitation. First of all, there is a problem. What is how to deal with the problem should be the concern.
My lord, yes.
Not that I want visitation all the time.
My lord, my client
And the
is
daughter is
cooperating with the
showing lot
doctors.
of reluctance, and for that only we want her to have a counseling. But your client is not at all bothered about anything except visitation. If he has visitation, fine.
No, it's not that. My lord, kindly do not take me amiss. My client was present at Niman's on each and every date, even on the 30th or on the
No,
30th.
that the court will look into, but that don't tell the court about the visitation.
No, my lord.
That's not the stage for visitation now. What you have to look at is how to get her out of all that. And then you can have
Yes,
visitation.
my lord, kindly, my lord, protects my daughter. Kindly protects my daughter, ma'am.
POXO case.
No. According to section
How can
22,
there-
my lord, I will explain, my lord.
Oh,
According-
under the.
Because she has filed a false complaint, I have the liberty under law, my lord, to go for
What is wrong with him?
Nothing, my lord. Yes, how kindly, my lord, appreciates the ignominy.
Please
he has-
understand. No, that has to be decided. So
He-
you want to use this order for that?
No, certainly not. That was filed, my lord, some time back. Because, my lord, the.
Sometime
honorable-
means when? When is after the order was passed?
No, my lord, once the.
No, please
POXO
please tell the court what is the date of that,
The filing.
that filing of the complaint under the POXO
Yes.
Act by the father? Huh? That is after the order passed by the court.
Date. Oh, sorry. 11 June.
Hmm?
11 June.
When is the first order of this court?
ফাইল করেছিস কবে পক্সোটা? কোথায়? Sorry? When did they file the POXO? When? The date of filing?
It is much before. This court has passed orders in the month of August. Whatever is the complaint filed is much before the orders were passed by this court.
That is different.
That is different aspect. What the court wants to know is the complaint filed basing on the orders passed by this court. It is July, court has passed orders in the month of August. That's much prior. The first order of this court is, when is the complaint, you said? You said 8th June.
What is the
Initially, there
date
was a
of
complaint
filing
filed.
POXO application?
On the basis of the complaint.
11 June we have filed.
Huh?
The POXO case has been filed on, the section 22 of the POXO
Yes,
has been filed on 11 June.
11th June.
June.
That is exactly next day after the order is passed by this court. This court has passed an order on 10/7/2024.
My lord, that too at a very belated stage, because my lord, it was 1 month before.
Hmm?
1 month before, my lord, the proceedings were quashed with the observation, my lord, that this complaint.
Oh, this is June. Hmm.
Yes.
Yes. What is going to happen now? But the girl knows the difference between a private hospitals and demands. That hospital is a hospital for her.
So activities and the hygiene that has been the primary concern of the child.
Of the child or the mother?
The
Hmm?
child concern, my lord, she is more than concerned, she is showing resistance, my lord. We can somehow, anything that is okay with the father petitioner as well, my lord. Private hospital on their suggestion for a counsel.
Neither your understanding what the court is saying nor your client is understanding. Counseling is not on a day-to-day basis. What is done is not possible.
Demands, child psychiatric center, there are other things various other medical also attacked and killed by a
That's why please tell the court what it is. You can't tell just like that, say, where is that hospital? Which is that hospital? No, you know what you want, then you should find out. You should find out.
No, certainly. Manipal, we have an issue. My lord, it is the doctor in the Manipal, so-called doctor, my lord, whose narrative was completely copy-pasted in the POXO complaint, the false complaint. In the false, that is why, my lord, there is a tendency to drag the child.
Then you come up with some hospital.
Fine with me, man. It is the best facility in the country. It is the, my lord, the doctors have assessed. The doctors have assessed the child.
counseling, not a test. State has not taken action.
Anyhow, let's not go to what has happened earlier. Now what is going to happen? That's what the court wants to know. And happily, like from 3 months, nothing has been done except, coming up with problems. That, this. Where is the intention on the part of the mother to take care of the psychological needs of the child, which are more important? Court need not ask her to what is to be done. She should have done, and she should have come up with it. Until somebody, the other side comes and tells the court, you just keep quiet. If she's taking her, and if it is really working out, she would have not said to the court what she was saying on that day. So what does it mean? That what is she doing is not working out. Yes. It's not about academics. That's even on the day when she was telling all that, also she was doing good. So then why the father is not permitted to see her when she's all absolutely normal? If she's normal, then the father should see her. She can meet her. Come to the mic. Not able to hear you clearly. Yes.
My lord, whatever she told you, and why that may be her, why she told. So you yourself
no,
have
if
made
you
your
say that she is all right, let the father have his station. If everything is happening and she is now all right, let the father have his station every week. Then we'll see how it is working out. If she is normal, let us not send her to hospital. Let the father exercise his station.
My lord, in my presence. My prayer is in my presence. Because we want to, as you say, let us observe. So let us, let her gradually get accustomed to the.
In your presence means you will go to his house?
Not in house, my lord. In, wherever we were meeting, that, whatever order you passed for the 4 Sundays, if you remember, we will adhere to that order weekly.
When is the vacation for the girl?
Vacation starts, this week only.
How many days?
10 days.
Where are you going in these 10 days?
No
You are
more.
in Bangalore itself.
Yes.
Then let's see. Let's have this matter after vacation for these 10 days. At some convenient time, let her tell the time. Let the father have the visitation for continuously. Then we will see what is happening.
My lord,
Sometime
continuously
or
as
other.
in?
Vacation, after that, it has to be once in a week. No vacation, he'll come he'll come wherever you want him to come.
During the vacation period, my lord, once in 3 days.
Let it be one day. Because all that time, for the last 3 months, without any visitation, your client could be successful.
1 day. But okay, my lord.
Huh? Every day.
Every
day,
My lord,
not
that-
1 day in the vacation.
My lord,
Lord,
Huh?
at least the native days we can try initially, my lord.
It's always try. Why try?
It is not up to me, my lord. It is to the child.
Child will do it. Have to do it. when you say that you're taking her to counseling and she's doing very well, she should meet the father. A problem, huh? One?
1 hour every.
Yes. Where?
My lord, she can come to my place. My mother is there, a grandmother. My lord, I have CCTVs installed. I will deposit the entire footage before this honorable court.
My lord,
No, why the grandmother is coming in now? You're not having visitation from the last couple of months. Now, when the court is granting you something, first of all, meet the child every day, 1 hour for till the vacation. Then we will see, basing on what happens. So you should be on somewhere the mother's presence is there. That's good for you,
My lord,
for
the
your
only-
client.
Only question, the only issue is, my lord, we have
The
seen.
daughter will not talk to him because I've seen her. I've seen the kind of
My lord,
resistance she has.
if the mother is not there, that is the entire case from day one. Kindly sees, my lord, the last time my lord ordered visitation at our flat, the learned lawyers were also
Seen that,
present.
I've seen the
She was
photograph.
quite comfortable.
It
She
is
was
not,
drawing, she was
it is
drawing
not how
sketches.
how he's projecting it. I've seen the videos and everything. This is not that, that it went on how he's projecting it.
The problem is, my lord, the mother will cling on to the child and she will not look at the father even. That has always been the case.
Please come. The
1 hour.
court
my
has
lord,
already
if I-
passed
if
an
I
order.
Have an exclusivity. my
This
lord.
court has
Let it
passed
be a
an,
public place, I don't mind.
this court has passed an order permitting the, uh, passed an order whereby the daughter was directed to be admitted in IMHANS, considering the statements that are made before the court.
my
It
lord,
is submitted.
if I may, she wants to take a break for some time.
No.
So may I just request that the vacation is still there, the father will be meeting, will be adhering, I'll be bringing my child every day over the vacation. But can we please start from Sunday? Every day I will adhere, I give you my word. I will bring my child. But
Sunday
for-
means?
Sunday is 6th. 6th. I would like to take her somewhere outside, so she will also be in a positive
Sunday
frame
is
of mind.
20?
No, 6th of October, my lord.
Then holidays are till?
14th is when the school reopens.
Then let it be 2 hours then. You go out, come back. And from 6th to 14th October, let it be 2 hours.
My lord, 14th the school opens, 13th.
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 What did you do? And what was directed to be directed, this court has directed the mother to admit the child in IMHANS. It is submitted that there is a lot of reluctance from the daughter. And in fact, she has been taking her to counseling and now she has improved emotionally and otherwise. And they find a lot of change in her. Considering the said submission, this court is making an interim arrangement from 6th October to 13th October. The father can exercise visitation for 2 hours between 6 to 8 or 4 to 6. Not
6 to 8.
necessary.
6
Yes.
to 8, my lord. 6 to 8.
Between-
My lord, please keep the timing flexible. I give you my word. I will communicate.
She will come up with
Because-
So
everything.
when both of you are not going well together, how do you expect it to happen at your convenience? You have to tell the court and there should be an order in that regard. Which day, which time, what is the convenient time to you? You tell the time then. Because you also work, right?
Yes, my lord.
She also works. During the daytime, it's not possible. 6 to 8 would be the convenient time, I think.
Okay, my lord.
Between 6 to 8, where do you stay?
Prestige Shantiniketan cafeteria. Their apartment has a cafeteria inside.
It's an expansive space. It's like a food court in a mall, shopping mall. It's a 100-acre place.
Write it on a paper and give. In so and so. Between 6 to 8. The next condition, the mother shall cooperate with the visitation and shall see that the father spends a qualitative time with the daughter. This arrangement shall continue till 13th of October. List this matter on on 21st of October.
My lord, just one,
Yes.
in her presence, my lord, is not going to, she'll cling on to the child. She'll not allow her to look at me. There is a history of this, my lord. I have brought many pictures and applications on record, starting from the court of the learned principal family judge.
First of all, let the child, at least your client, see the child first.
Right. Agree.
Once our presence and every day if she's seeing him for some days, then we will make arrangement. Everything can't be done in one day.
Right.
Yes.
My lord, one more humble prayer, my lord. If the returnable date, my lord, can be on the,
21st,
can it be on 22nd?
22nd.
Great.
Yes, next.
Great.
That's it. Yes, next.
Cell number 16.
Yes.
Number Raju. This is the matter where the last day hearing. The petition is filed by the wife, my lord, sought for modification of conditions.
He's a petitioner, right? Yes.
Thus, the petition is filed challenging the impugned order passed by the sixth additional family judge, my lords, wherein the family judge had passed an order where the visitation right for the father was given every alternative day between 5 p.m. to 6 p.m. my lords.
Where?
In Bangalore, my lords.
No, which place?
In the mutual agreement before the
Agreed
divorce,
place.
as per
Yes.
the agreed place, which was in the memorandum of settlement, my lords.
Questioning that you are before the court.
Yes, my lords. As per the memorandum of settlement,
What is the age?
age of the child is 7.5 years old. my lords. Now the mother is divorced, she's remarried again, and the difficulty lies there that she's her matrimonial house is in Hyderabad right now, my lords.
Oh, the other day that matter has come.
Yes,
Yes,
my
why
lords.
is it adjourned that I wanted a, either he'll travel to Hyderabad.
Travel to Hyderabad.
Permitted to video call and off on the phone, and on the weekends I will be allowed to go to Hyderabad, see my child. And during vacation, my lordship had stated that I can bring him to Bangalore and keep him here for 3-4 days. And on that condition, my lordship had adjourned the matter. They saw time, my lord, to seek instruction from the client.
Yes.
Yes, my lords. So far as the visitation rights is concerned, my lords, when this writ petition was filed and the stay of the impugned order was granted, my lords had passed an order on the basis of the condition that there should not be any issue for the father to contact the child for either through video call or visitation right in Hyderabad, my lords. And so far as the visitation for the vacation is concerned, my lords, she has a 3-year-old child right now.
No, let her stay. Why she has to come? The father can bring the child.
Yes, my lords.
So then why don't you, no, from how long you are not meeting him?
My lord, the order was passed in the year 2021, my lord.
From that you are not meeting him.
It's never made even a single, please.
Order was passed by the family court in memo of settlement, my lord. They agreed that I can see my son. Within 6 months, my lord, they go to Hyderabad. I filed an execution petition.
All that I don't want to know. What the court wants to know is when did you meet the child?
Met child on the date of memo of settlement, my lord.
Yes, that's in the year 2021. From 2021 to 2024, you have not met him. So please, in this vacation, no, instead of getting the child straight away from there to Bangalore and spending time, go to Hyderabad whenever, right from now to till vacation, how much time you want to spend, you can tell the court will pass an order. Once he has an acquaintance with you, then next time when the matter comes, we can pass an order.
Case when, my lord, they undertake in the memo of settlement that the child can be.
That's true, but you know, like she got married and she has to move.
My lord, during.
And you can't know she has a small girl, you can't expect her to carry.
Just
What were you doing from 21 to 24 when nothing is happening?
Court, I have even filed an execution petition. MPW was issued against them. They have not filed for alteration of charges. Conditions, my lord, it is my case where I file execution, then they come.
Please understand, from 21, what is not happened? No, you just wait for some more time. Now, in the vacation, now, as far as the video call is concerned, that throughout the vacation, we can give you every day.
Wrong address.
No, my lords. No, my lords. That's a wrong submission. my
Please
lords.
don't tell what has happened. The court is going to tell you what is going to happen, which should happen. So video call, when do you want every day? Every alternative day, video call, that she has to adhere. Then next,
Yeah, right.
My lord, also, my lord, during vacation, my parents are also here in Bangalore. Even they want to see grandson. She's.
they will
really
see,
because
they
she's
will
married.
see. They waited from 21, they will wait for some more time.
Child there.
Then unnecessarily you are compelling the court to confirm the order.
they'll allow me to see my son every alternative days and also on vacations. And she
No,
goes
my lords, we never,
to Hyderabad.
we never.
After issuing of MDW, they've come before the court, my lord. It is not them who sought for alteration of charge conditions, my lord. Even on the last date, my lordship had stated that, all right, during vacations, at least 3 days that I can bring my son. I'm only on that ground, my lord. I'm not saying.
Please
that I
come.
want to See him or.
The present petition is fine. Agreed with the orders passed in. Because court has given you an option, you didn't want to exercise it, then I have no other alternative but to suspend this order.
They have sought.
So please tell the court, when are you going to Hyderabad?
Sought for is wrong, my lord. They have sought to alter conditions in execution petitions.
No, my lords, we never made such any prayer before this honorable court or before the family court.
Then we'll do one thing, well, whatever is a prayer that they sought will grant and adjourn the matter, and after vacation you can exercise it.
My lord, it's a matter where, my lord, I'm not on any, I'm not saying that I want to see my son like the.
Please, you have to understand the mind of the court, what is the order going to be passed? Even if you tell 100 things, that won't happen. So what the court is ready to give, yes. So please tell the court, every alternative day you will have a video call. And then what else you want?
Every weekend when I go to Hyderabad, she should allow me to see.
Yes.
My son, take him out
Yes.
for about 3 hours, my lord. And I'll drop him
Take
back,
more time also.
please. Also,
Yes.
on other alternative days, when I have vacation, when I go to Hyderabad on Saturdays, I may be allowed to take my son for a day, keep him in Hyderabad and drop him back the next day to her on Sunday.
It's so far as the,
As far as Hyderabad is concerned, if the boy is not comfortable, the same will be intimated by the father to the mother. She can take him. For everything, she cannot have any objection.
no, my lords. No
Yes.
objections pertaining to visitation right in Hyderabad. So far as that, we have.
That's
absolutely no
not only the court is granting as of now.
As far as the staying with the father overnight, that is where the issue lies, my lords. Staying with the overnight with the father, the child has a severe ADHD and other psychological issues, where for that I have also produced the.
No, no,
this thing.
what we'll do is, now the vacation is there. So initially, for for a couple of days, let it go on. Once you all feel and the boy also feels comfortable, then you can have the overnight visitation or overnight custody of the child.
Them
No, you can have the entire day with you instead of 3 hours. Instead of 3 hours on whenever you visit Hyderabad, right from 10 o'clock to 5 o'clock in the evening, you have it and leave the child. And if you keep doing it for some time, once he is that acquaintance develops between both of you, then you can take it forward.
Also, my lord, to condition where if my child is, my lord, things are not seen for 4 years. After I meet him, this court may also observe the fact that I may be allowed to bring him to Bangalore once my child is comfortable, so that he can see my grandparents also, my parents.
Court will not tell you
Depends
what
what
can
the
be
order-
done, what
that
can be
becomes-
done. Yes, where is impugned order, page number? Yes,
Para number 3,
not 28.
next should be, my lord,
And it should be as a memorandum of settlement.
that is
Where is the order now?
That's at page 21, my lords. The order is dated 24/11/2021 in the execution, wherein the
The court in the
order is dated
execution
12/11/2021.
had permitted the father to see the child on every alternative day between 5 PM to 6 PM without disturbing the peace of mind of the child. Agreed there by the mother, for mother is before this court. It is stated that both the mother and father, by way of a settlement, have taken the divorce, and as per the said settlement, the child shall be in the custody of the father. And the father is at liberty to visit the minor son every Wednesday between 6 PM to 7 PM. And further, he is at liberty to take the minor child on Saturday evening 4:30 PM and to drop the minor son next day, that is Sunday by 5 PM to the agreed place. That is Bethany Park at Koramangala, Bangalore, once in 15 days. During vacation, the father is at liberty to take the minor child 2 days in a week, that is to take the child from 4:30 AM and drop the minor son next day by 5 PM. This settlement was entered into between the parties on 13/1/2020. 2020. It's a grievance of the father that the mother immediately after this settlement, she had remarried and moved to Hyderabad. And from there on, the father was never permitted to see the child. it is submitted that even the order that is passed by the court is in fact contrary to the settlement. The mother had never cooperated with the father to meet the child. Land counsel appearing for the mother submits that after the marriage, she relocated to Hyderabad. Now out of the second marriage, she's having a son who is aged 3 years.
Yes.
And for on every date of on every visitation, it's very difficult for her to travel from Hyderabad to Bangalore along with 2 children, facilitate the husband to meet the child. Considering the submission of both the counsels, this court is passing the following order. Number 1, the father is permitted to meet the child 2 days a week of any of his choice, and the same shall be intimated to the mother in advance. As in the vacation, the father during the vacation, in those 2 days, father can take the boy from at 10 o'clock, and he can have the interim custody till 5 o'clock and drop him back at mother's place. If the boy expresses any inconvenience, that should be brought to the notice of the mother. Initially, till the boy gets acquainted with the father, the mother shall facilitate and make all her best efforts to see that the boy develops bonding with the father. And apart from that, when you want alternative day, video call. On every day during the vacation, this is only during the vacation. On every day during the vacation, when he is not having the visitation, the father can have the video call, can see the boy through video call and interact with him between 7 to 8.
8 to 9 would be.
Between 8 p.m. to 9 p.m. Post this matter after vacation, basing on how this visitation goes on, further orders will be passed.
Was correct number, my lord.
It has already been communicated to the father, my lord.
The- What is that?
The phone number and the email ID and the house address, everything has been communicated. And as and when she has moved from one place to another place in Hyderabad, that has also been intimated to the father, my lords.
By today evening, the phone number,
Please.
the email address
Please.
of the father, of the mother shall be communicated to the father. The address,
Okay, details will
email,
communicate.
phone number, all the particulars. And it should be on intimation. Prior intimation, father shall give a prior intimation about when he is visiting the
Visitation as well as pertaining to the video call as well.
video call is fixed.
Yes, my lords, please.
Video call is fixed.
Yes.
Yes, next.
Number 17, P. Balakrishna Shastri, petitioner, Nilesh Krishna.
For the petition one.
What is the urgency?
Paper.
Huh?
My lords may have it after.
Huh?
That would be matter.
What is the urgency?
My lord, since was nothing, my lord, the maintenance has been reduced from 15,000 to 7,000.
But anyway, you are getting it. Is she paying or not? Is he paying? Yes, at the request of land counsel for the writ petitioner. This is matter on 22nd of October. Yes, next.
Bill number 18,
Somebody has made a request for adjournment in the morning, I think.
Vijay
To ask for, you move the memo, he only moved at the request of land counsel for the writ petitioner. This is matter on 28th of October. Yes, next.
Bill number 19,
And for the petitioner wife.
Rita Shetty,
Petition. I'm seeking for modification of the order passed on IA number 24, filed under section 24, my lord. I'm having custody of 2 minor children.
Let's see the order, page number.
Page number 13, my lord.
30?
Page number 13 is the order, impugned order. Impugned order in the sense it is in my favor only. All the observation made in my
The
favor.
petitioner is directed to pay monthly maintenance of 25,000 to respondent and 2 children from the date of till disposal of the petition.
Yes, my lord. The last para is, the petitioner is at liberty to deduct the monthly maintenance. It is paid in SIM.
That's the monthly maintenance which is paid in.
SIM is, my lord.
How much is paid there?
That is 25,000, 20,000 to me and 5,000 to one child.
I
So
have
again, 25,000 here is,
it is to deduct. He is misusing this order, my lord. He is saying I have paid something there, I have paid something here, and I am deducting that. And really, he is telling the court that it is only 3 lakh is pending. In spite of this order, my lord, I am not.
what is the modification you're seeking?
This is not to deduct, my lord. Some order may be passed on 24 application, my lord. There's 25,000 and this is 25,000. If the order is to deduct it, it is zero, it is as good as zero maintenance I'm
What
getting.
is his, what is the salary?
He is working his own admission in his evidence, my lord. He is a engineer at Singapore. Though I'm having LLB degree, I'm not able to practice, my lord. I'm managing 2 children and one elder son is concerned. He is having disorder, speaking disorder or something. He need to attend the therapy, speech therapy. This also.
What is your income? Huh?
I've instructed the party, he'll be coming down to Bangalore in the next week. I'll file a detailed affidavit with respect to my salary and what are the amounts already paid to the respondent. We are not denying the maintenance.
Pose this matter after,
Lord,
immediately after on 14th of
My lord,
October.
till then proceeding, my kindly, my last occasion also I have asked for it. Otherwise my IA become
Why
infractuous, my
should
lord.
it be?
This is
No,
a
unless
divorce-
and until the court understands, no, 25,000 here, 25,000 there, 50,000.
No, deduct, my lord. To deduct, adjust it towards the maintenance paid there. In the sense, my lord, 25,000 minus 25,000, zero, my lord, in this 24 application.
So that is you're having 25,000.
Yes.
Only 25,000 in still, if at all my IA is allowed here, my lord, 25,000, at least 10 or 15,000 in this way. This is independent relief, my lord, whatever is sought in
The trial court had granted 25,000 maintenance, and it's observed that the amount that is granted in the criminal miscellaneous shall be deducted. Land counsel submits that the husband is working in Singapore and earning a handsome salary. The wife is unemployed and she has to support 2 children. One is a
son,
a specially able child, has some and he for his therapy sessions also, she has to spend a lot of amount. Considering the same, it is clarified that the husband shall continue to pay an amount of rupees 10,000 in these proceedings, 10,000, apart from 25,000 that is already granted in the other proceedings till the next day, till the next date of hearing. Not till till the pendency of this petition. This matter on 22nd October. Yes, next.
Till number 20, petitioner, Sai Guru, Ishikant, Satyara.
It takes some time.
Only arrangement to be made for the Dasara vacation. That's
My client is ready to send both the children for the entire vacation.
obliged.
But in fact,
Grateful.
my client wants that there should be shared parenting. Let him take the children for 15 days a month.
Grateful.
That's a good, she has come out with, all this, that's an end for all this.
Then we could also go to
issues.
mediation and sort out all the other our matrimonial differences also.
Not paying 1 rupee of maintenance from last 1.5 years. That has to be sorted out. You can't escape that.
No, absolutely not. Absolutely not.
No, we'll pass an order that 15 days, no, during the entire vacation, they'll be with you.
From 4th evening, my vacation starts 4th evening.
Hmm.
I'll pick them up and drop them back on 13th evening.
Hmm.
Obliged, sir.
Next
And-
part.
My lord, so far as the maintenance concerned, my lord, kindly see the bank statement produced by them. 40 lakhs, there's an entry into her account credit. Therefore,
What we'll do is.
yes, let that matter be taken up on the
Your
14th.
client is here.
He's not.
No,
He's
what
not.
we'll do is,
He's not in-
please get instructions.
Yes.
Now, the remaining other things and how you paid, what is that, we will see. No, this 14 days or 10 days, you're going to have the.
8 days vacation. Yeah.
No, as of now, for the month, whatever is the maintenance he has to pay or what is the requirement, just get instructions. So that later we can deal with it about the joint parenting and
But
other.
2 lakhs for 35,000 rupees undisputedly I'm paying every month. School fee and rent alone.
Together.
And she has 3 crores of my money, which is not disputed. That is why I'm saying, let the matter be. Lord, on the eve of vacation, on the eve of vacation,
You please get your instructions from your client, we'll have it at 2:30.
very.
Yes, next.
number 21. Prasanna Kumar RS for petitioner.
Petitioner in this case, my lordship. At previous date, my lordship, the lordship was pleased to stay the operation of annexure A, my lordship. The matter may be listed after vacation for final disposal, my lordship.
Interim order is
Correspondent
granted.
in this
Please,
case,
my
my
lordship.
Interim order all are granted is extended to the next date of hearing. Let this matter on
I'm appearing
29th
for
of
the
October.
respondent.
No representation for the respondent.
I'm
You are
appearing for
here?
the respondent.
Yes, yes.
Yeah, I'm
After
appearing for the.
vacation, we'll have any
Yeah,
interim
they
order
have
is
not
there
made
to pay the
but
amount,
they have not
half of
made the
that.
payment, my lordship.
Huh?
They have not, they have not paid the amount. They have not paid the
4
amount
weeks
till
time
date.
is there, my lordship.
When is the order passed?
Not
Let's
even
see.
paid a single rupee.
1 minute, 1 minute. When is the order? Let's see.
Ask August.
This is on 30/8/2024. Considering that he is earning an amount of 10,000 per month, this will be 5th of every succeeding month towards arrears for ready. Yes, post after vacation, the request of non-counsel for the petition. Yes. On 29th of October. This next matter.
Please.
JAM for petitioner.
Huh?
Lordship, I am for the petitioner in this case. We have served these copies to the respondent.
What is that? You have instructions to appear.
File my being out of time.
So and so submits that he has instructions to file wakalat, poses matter after vacation on 29th. Interim order is there? No interim order. Yes, next 20.
Number 23. Sapadi. Petitioner Rashekar S.
Lord, impugned order is at page number 42, annexure E.
Page number?
42. Operative portion is page number 57. 57, 58.
The respondent is hereby directed to make payment of interim maintenance amount of 20,000 per month. You're for the,
I am for the wife, my lord, that is the
you're seeking
petition-
enhancement.
petitioner. This is enhancement.
We'll have it after vacation, enhancement.
Now, what has happened, my lord? She is in Mangalore. Since from then, my lord, this is in the year cropped up in the year 2022. Since then, not even paid a single pie, except in DV case, 6,000 was awarded. That
Oh,
has been.
in this case, that's your
Please,
petition.
please.
Execution is always available to you. File execution.
Execution is filed, but even then, my lord, that is also, it is not processing. Already arrears is around 3,60,000. That is also not paid. At least if they paid in the objection, kindly go through the objection, my lord. In 2 paragraphs, they said I have been paying 20,000. At least this also, this could have been paid. So
Poses-
kindly see the objections.
This is a writ petition filed by the wife seeking enhancement of the.
No, let there be a direction because they have already filed an objection. Let the arrears be paid at least.
What is the scope of this writ petition to direct them to pay the arrears?
Not
You're
because,
seeking enhancement, whether you're entitled for enhancement or not will be decided by the court.
that's correct, but I am seeking for enhancement. The amount which has already been granted by the trial court, at least that could have been paid. That is an arrears as on today. That is what I am requesting.
Yes, post after vacation, the request
Huh?
of non-counsel for the respondent.
Lord, the
30th of
child has to get operated. That is why I am kindly see the annexure at last annexure.
What you're not understanding is, trial court has passed an order.
Please,
That's not complied with.
please.
Now, why there is another order for the same thing? That's what I'm asking. No, either this order or that order has to be
That's correct.
executed.
Yes, yeah, that is correct, my lord.
Uh.
Even then, having come before this court and for an enhancement, this court has a ample power or a highest power than to that. It can be in the meantime of interagnum for disposal of this case or enhancement of this. Lord, is it not bounden duty of them to pay the enhancement amount?
their
That is what
duty.
I
If they are not
request the
doing it,
court to
we'll-
make an observation.
No, I can understand if they have come before the court questioning it, court will ensure that. But they have not come before the court, you have come.
Not
And you
they,
have already filed an execution petition. No, even if an order passed by this court is not complied with, for also, that also you have a mode of execution.
Lord, anyhow, my lord, latest Supreme Court says that in all these matters should be settled in one umbrella. I have come here, my lord, at least
Suppose if they started paying, I'll take back that petition. Not they, I don't understand why these persons are not paying it. From 2020 to 23rd February.
His order. Yes, yes, yes.
No, he has been in a central government organization. That is a undertaking
October 29.
organization.
Yes, next.
24 and 25 adjourned, serial number 26. Girish.
My lord, which date, my lord?
It's on 29th,
29th
October. Huh? 30th October. Yes,
30th is too long, my lord. At least
Huh.
30th of this month, my lord. Too long a date that is.
October, I said.
October, this is 1st October, 30th October is almost 1 month.
Weeks holidays.
Yes, holiday 23rd.
Okay, for the appellant in this matter, I filed an IA for extension of interim order granted earlier. May be extended and may be taken up after vacation for hearing.
When is the interim order granted?
Granted earlier, madam.
When is earlier?
3/1/2023.
This is granted on 3/1/2023.
Yes,
Which is not extended never, and that has to be extended now in 2024. No. Pose this matter after vacation.
A date may be fixed.
This
A date may-
matter on 4th of November.
No, my lord, they are alienating the property that we have a grievance with regard to that.
Problem is there are no, now the court just like that give the numbers, it's for the other court to, for the difficult to deal all with the matters. Yes,
Any
next.
day within this month, madam.
This month, there are so many matters listed already, given dates. Yes, next.
No, they are not cross-examining in the suit. We have filed a suit.
Yes, yes, next.
There is a collusive suit and there is a decree which we have challenged.
Yes, 27.
Vasant Kumar KM. Petitioner. Santosh S. Nagarale.
Hmm. No, any of, they are not there. Interim order is there. And then the no representation for the appellant, counsel for the respondent is present. Pose this matter on 11th of November. Yes,
Serial number 28. Karun Bhaiya TA. For appellant.
My lord, my only contention is that I was the nominee number 2, my lord, and
you are arguing the matter or what do you want?
my lord, succession certificate, my lord, is what I'm claiming. Because I was nominated.
Pose this matter after vacation on at the request of the appellant on 19th of November. Yes, next.
Serial number 29. T. Sheshgiri Rao. For petitioner MP Chandrachud.
My lords, I seek for a short adjournment.
Yes. List the matter on 11th November at the request of non-cons for the appellant. Yes, next.
Serial number 30 adjourned 31. 31 Srikanth S.
May be taken
Nathan
after
Ravi.
vacation. my lord.
Yes, after vacation.
Interim order may be
12th of November. Huh?
Interim order may be extended.
Interim order.
It was extended, my lord.
Let's see that.
It was extended. my lord.
It's extended on the last occasion.
The order is passed in 28th February. They paid in month of April. The interim order was passed in month of September. My number requesting not the interim order, not the extended.
Interim order earlier granted is extended in the next date of hearing. For this matter on 12th November. Yes, next.
Serial number 32 Kalyan R. For petitioner appellant.
And appellant for this matter, kindly the interim order extension and the pass for this matter,
Huh?
Interim order in this matter, so kindly extension of the interim order and the pass for the matter.
Why interim order extend and pass over the matter?
Kindly pass for this matter for the afternoon.
Interim order earlier granted is extended in the next date of hearing. Post on 4th of November. Yes, next.
Pass for this matter.
You understand, on the last day of vacation, how can the court hear all the matters? Yes,
Kindly pass for this matter.
33 adjourned to 12 November. Serial number 33 Shiva Reddy.
notice to the respondents,
Serial
post after
number
service
30
of notice.
Serial number 34
Maybe taken up after. Maybe taken up after.
At the request post on 19th of November. Yes,
Cell number 35. Raghavendra C.
Appellant, please. The temporary injunction is granted.
any interim order in your favor?
No, my lord. No, it's a
And
fresh
what
matter.
about by
Fresh
this
matter.
court? Huh?
Fresh matter, my lord.
Oh, fresh matter. Oh, you're a caveator. Yes. What is the suit for?
Suit for injunction.
But till such time, he requires an order.
There was an earlier order of status quo.
Where is that?
Here, in the writ petition, my lord. Thereafter, this one of the court directed the matter to be heard on item number 1. That is 39 After that, there is an injunction in my favor.
That is being challenged here.
That has been challenged.
That's why he is before this court. Two things. Either you have to argue the matter today or else some interim order has to be granted. If it is, if the court feels that it's a case for interim order. Yes, next,
Cell number
Lord, it
36.
maybe I have it on, Lord, after vacation.
after vacation. The request of.
25th, my lord, date.
This is marked on 12th November. Yes,
Cell number 36.
Yes, appear for appellant. In the matter may be.
P. Rajan.
yes, I remember that. Yes,
After vacation, please, Lord.
you want after vacation.
Allah,
No,
there
interim
is
order,
no,
we are
there
not-
is no interim order,
No,
please,
no,
Lord.
interim order, we are not granting, let him, if the court is now wants to dismiss this appeal, let him take a chance.
Please, Lord.
Matter on 19th of November at the request of grounds for the applicant.
Grateful, Lord.
Huh? This month, post on 29th of October.
Grateful, Lord.
Cell number 37.
Yes.
G7, I appear for the appellant, my lord.
Yes.
My lord, this is a matter suit for specific performance. There was an interim order, my lord, not to alienate the property during the pendency. Now the order has been vacated on the simple one ground, my lord, in para 17, that the respondent denies the signature in the agreement. But while in the written statement itself, he said that he had taken some money and that he has returned it by cash. That's the only ground, my lord. He's not come with clean hands. Amount has been paid 17 lakhs by check. All amounts have been encashed by him. Now he is coming out with the theory, my lord, the signature is not his. When he admits that the payment
Is
has
it
been
true
received.
that just on the ground that you denied the agreement signature?
Only, yes, my lord.
Not only signature, there is no agreement of sale. There is no agreement of sale.
What is the agreement of sale then?
It's not an agreement of sale on the eye of law.
Which para?
My lord, I am submitting because the LCRs are not there. They are not
No,
produced.
no, before that, we look at the order, which para of the order deals with that? Para 13, please read, let us see.
Order.
Para 13 of the impugned order.
Yes. Agreement of sale on 24/12/2020. But on the date of the entry into agreement, the sell the plaintiff has already paid 15 lakhs is as per the plaintiff by cash by NFT. Balance and consideration of 3.45 crores was agreed to be payable at the time of registration, subject to defendant providing all the original documents and all, etc. Further, agreed to get the approved layout from the competent authority, the plaintiff has produced a copy of agreement of sale. Dated so and so, entered between the plaintiff and the defendant. Said agreement
of sale in unregistered one. The plaintiff stated that he has invested 80 lakhs, 25,000 for the development of the property, believing the defendant plaintiff made investment. Further, on 24/1/2021, plaintiff paid 1 lakh by cash, and on 6/2/2021, 1 lakh by cash to the defendant on his request. The no document has been produced. Let me submit. In total, parents have paid 17 lakhs towards the same contribution and invested 80 lakhs, 75,000 for the development of it. However, there are no documents produced by the plaintiff for having invested such huge amount in the suing property. A copy of the letter by Siddharth Plastic is produced by the plaintiff, where the state of Plastic has acknowledged the amount paid by the plaintiff. However, it is important to note that there is no recital of delivery of possession to the plaintiff and consent for development of the suing property by the defendant for the development of the same by the plaintiff under the lease agreement of sale. When such being the case, on what basis the plaintiff started development works and invested so much huge amount is not stated by the plaintiff. Further, it is further case of plaintiff that defendant has agreed to execute the sale deed by providing all the documents pertaining to suing property as per the agreement, like original documents including the latest CASA up-to-date receipt, and also defendant agreed to get the approved layout plan from the community market, but without approved layout and plan.
Yes,
Permission.
yes, Madam Senior Counsel.
Yes, my lord. My lord, what is there in written statement? This is what in paragraph 5 is states, my lord. After payment of this, he admits the payment of amount in written
How
statement.
much you paid? You said cash. What did you pay through NEFT?
My lord, 5 lakhs, 5 lakhs, 5 lakhs through check and NIFT and bank statement, bank extract
No,
I'll
through
produce.
bank, how much is paid?
15 lakhs. And then cash, 2 lakhs, 1 lakh each, 2 cash, and admittedly he has signed the receipt. 17 lakhs.
Consideration is 3 crores.
Yes,
3
3 and then my lord, I had engaged the contractor to make the work there. 85 lakhs I paid to him. That also I produced before the court.
Yes.
My lord, in all I have paid. And then my lord, what he says in the written statement is, he has admitted that he received the amount. His case is, this is so, defendant this is what he says in the written statement. He had failed to enter into joint development agreement and development the suit schedule property. Thereafter, in the month of March 2021, the defendant had conveyed the meeting. In the said meeting, there was settlement and the defendant had to pay amount of 5 lakhs to plaintiff. As per the settlement, in the first week of April 21, defendant had paid the amount of 5 lakhs by way of cash. This is his statement. Amount he has received, he admits. Then he said there was a settlement. Where is the settlement? Where has he paid? According to him, he has a list of paid by cash. No records are placed before the court. On the other hand, I produced before the court all the records from the bank which shows that he has received 15 lakhs by cash and 85 lakhs paid to the contractor for who was doing the work. These are the things, my lord, and he has not disputed. Then, my lord, what he does is, he prepares a legal notice said to have been issued by one Ramanna to the purchaser. Well, that's also concocted. I had not authorized any advocate by name Ramanna, nor I had issued any notice. These are the equity. This is an equity, injunction is equity relief. He who comes before the court for an equitable relief, he must do equity. Here is a case, admittedly, he has denied the receipt of the payment. Then, on bank payments, he admits only 5 lakhs. So falsely. Other payments are payment through the bank. I had to get the record from the bank and his own check, his signature, and all those things I have produced before the court. He has not denied the bank statements. Admittedly, he has not denied. Assuming that the matter has to be, he's denying the signature, last time I say, within 6 months I will close the case. I am ready with all my evidence. I will prove the matter, that is admittedly his signature. If I'm able to prove that it is signature, my lord, then the prima facie case will be on me. My lord, the equitable relief, my lord, you lost my recall justice going but as early as 1959. The only prima facie case, balance of convenience, irreparable injury are not the only grounds. Equitable relief, he who comes with equity must come with equity. That was laid down in 1959. Up to date, that's the law. Here is a case, madam, I'm demonstrating before your lordship that he is not coming with clean hand. According to him, there was a settlement, and according to him, in this settlement, he paid 5 lakhs by cash. In other words, he admits. All other things are admitted. Now he is coming for the man, it is burden is on him. If there is any material to show that he has paid that amount, then I will withdraw my case on the face of it. Nothing, all the things. That's why I am saying safeguard my interest during the pendency, and you lost my with the status quo granted and direct the court below, my lord, within 3 months I will close the case. You lost my fixed date. Till then, my lord, he said that he has sold the properties. Then when I got the encumbrance certificate from the authorities, it shows nothing. No alienation has taken place. All that is false statements. Or no,
No alienation.
yes, my lord.
Joint agreement. It is joint agreement between the respondent DS Max. You have got para 15 by PB.
I've seen that. What is at your place to show that?
The construction is
No, you said that some alienations have taken place. What is the material before the court? No, you said so that in the order, it is reflected that the construction has already taken place and the
Yes.
alienations have also been done.
Everything is there. I am producing the copy, other side copy, document they are not produced. India is really they are not produced. Let me produce these documents.
Encumbrance certificate, well, 230 I produced, well, I have the copy. No alienations have taken place as on 24-25.
The document produced by the client is as well as the document produced by the defendant.
May I also be permitted to furnish the documents as regard to the payments, my lords?
Hmm?
I'm also furnishing the documents as regard to the payments, bank statements also.
You deny this, these photographs.
My photographs show my board, my name.
Is
No,
that?
that is produced by other side, actually.
That shows petition's name is there in that board. In fact, I wanted to know after this whether any alienation have taken place. I applied to the encumbrance certificate. The income certificate has been given to me, my lord, only 3 days back. It shows no alienations. Nil. I am only telling, my lord, if there is no alienation, you will ask me safeguard the interest of my party only for a period of 3 months and direct it. I will go on with the case day to day.
No, if at all any sales have
Yes.
affected, the EC would have reflected all that.
Hey, it's not there.
It is a joint development. In the joint development agreement, we jointly sell it to the purchasers.
Have you done so till now?
Not yet. Page number 30 may please be seen.
30 of this.
Okay, just now I agreement
Oh,
document.
oh.
Page number 30, agreement of sale.
Hmm.
It is an unstamped, not even an insufficient stamp. It is an unstamped. Please look into it. There are only fraud appeared by.
No, let us see, where is that joint development agreement of yours?
Yes,
Page number?
John, page number 23 of my, let me. Registered joint development agreement. That is the internal page number 76. 78. It is a registered joint development agreement.
Dismissed, reasons follow. Yes, next. Any other matter?
Please, my lords.
Dismissed, reasons will follow. Yes, 38.
Then number 38.
Appearing for the
38,
presence, my
appearing
lord.
for
Kindly
respondent,
pass
yes.
over, my lord. There is an.
Yes,
abstract.
pass over. Pass over.
39.
Yes, 39.
Uma Shankar.
Yes. Hmm.
For partition and separate possession, relationship with the plaintiff and defendant is admitted.
Suit is for?
Partition and separate possession of 3 items of suitable property, my lord. Suit is filed in 2011. My lord, 3 IAs are filed, not to alienate, not to create any third party rights, not to alter the nature of the property.
You are
not
the
to put up-
plaintiff?
Yes, my lord. 4 daughters. My lord, the learned trial judge, in the year 2024, my lord, I'm sorry, my lord, last 2023, they are about to put up construction in one of the suit items. I filed application not to put up any construction. The defendant number 8 is a developer. My lord, without the consent of plaintiffs, he has obtained sale deed and some agreements of sale. Maybe it was brought to the notice of the court.
Whose name that property stands?
The property stands in the name of the original proprietor of the joint family, Oblappa, Totappa. It is admitted fact in the written statement. No dispute at all. But application is filed. 3 applications are filed. My lord, one application is filed in the year 2012. Another application is,
Your case is that the property is a joint family
yes,
property.
ancestral property.
What is the case of the defendant?
My
In
defendant
respect to-
admits,
Huh?
defendant also admits the properties were in the name of the original proprietor, Totappa, the father of the plaintiff. Written statement is categorically admitted, no doubt at all. My lord, in all the 3 applications,
How
your
that
lordship-
has passed on, how the right and title to the property has passed on to defendant?
my defendant, according to him, he has purchased the property for some
Which year?
from other respondents, 2011,
2000?
11, my lord. In the plaint, my
When
lord,
is the suit filed?
a suit filed in 2011 itself. When he is about to, agreement was executed,
Hmm.
at that point of time, my lord, suit was filed.
Please come to the impugned order.
My you also kindly see the impugned order, my lord, page 19, my lord. Page 19, my lord, 3 AS are mentioned.
Why you have filed these applications now in a suit of 2011?
My 2000, along with the suit, it was filed, my IA number 4 was filed on 21/3/2012.
Application that is filed in the year 2011 is decided on 3rd September
My lord, that
2020.
is the, my lord, fate. 2012, one application, not decided. Again, 2014, we have filed one more application, that is also not decided. When the my lord, construction was proceeded with, we filed one more application in the year 2023. But also kindly see the attitude of the learned judge of the trial court. Point number 1, no, my lord, all the 3
Please,
applications,
how can the ISP decided of 2011 in 24?
my lord, all the IS are clubbed now. Order was passed on, my lord, 3rd September 2024. Page 22, my lord. Page 22, para 11. The learned trial judge, my lord, has not applied the test of tribal doctrine.
Let's see, please read.
Page 22, my lord.
Yes.
My lord, before that, 3 IAS, my lord, all the 3 IAS, 1 para order.
Read. Defendant number 8 admitted.
Admitted that the purchase of the suitable property and conclude that the suitable property lost the nature of agricultural land. Now it is converted, layout was formed, sold to intended purchasers. In support of the contention, defendant number 8 produced 47 sale deeds. Sale deeds discloses that the suitable properties were divided into 47 sites and sold to different persons. As per the sale deeds, as on the day, defendant 8 is not in possession of the suitable properties and defendant number 8 is the owner of the suitable property, not the owner of the suitable property.
Court has rightly observed, now they have sold it long back, third party rights have accrued, you have not made them as a parties to this. Now nothing will happen if injunction is granted to defendant number 8, but what will happen to those purchases of the property?
What I'm saying is,
No, they should be before the court, you should have made them, you make them as parties to the suit and seek the same.
Now,
relief.
one more question, madam. Now you will also kindly see the photographs. Madam, one more thing, in respect of IA number 9, what is alleged is, madam, they are putting up construction. Defendant number 8 is putting
Yeah,
up.
that is also an order against them, the purchasers, they should be parties to the suit.
Defendant number 8 is the party.
Yes, he has already sold away the property in favor of different purchasers, sir.
Correct, my lord. Defendant number 8 during the pendency of the suit, if he sold the property, my lord, that is not binding on us.
Then be happy with it.
Correct, my lord.
It is hit by pendency, I'll wait till whatever happens.
Correct, but in the
you are
meantime,
seeking a relief. If
Ma-
you're seeking a relief, they should be before the court.
madam, in so far as IA number 9, my appeal is filed only in so far as IA number 9, not to put up construction in respect of
order
one item of the
also-
property.
That order also, unless and until they are parties to the suit, because the sales have taken much.
Well, defendant number 8, well, there is no discussion with regard to construction. You will also kindly see the order. Kindly see the order. Kindly see the order.
I have seen.
In the entire para 11,
with regard to IA number 9, there is no discussion at all, there is no finding at all. Your Lordship, kindly see that.
No, there are two IA, three IAs,
Hmm.
not to
3
alienate.
IAs, 2 IAs I am not pressing.
Not to alienate,
I'm not
not to
challenging
make further constructions. For all that, this reasoning will apply for the reason, the properties are purchased by some third parties who are not parties to the suit. Unless and until they are there, they are before the court. How can the court pass an order against a stranger?
No, my lord. Defendant number 9 is the party to the suit. And in the year 2024,
No, he's
construction.
he's happy without disclosing the things. He has sold the property. Why should there be an order against a stranger? Why don't you make them a parties?
Madam, sale deed was also under question. That is the consequential relief. I also challenge.
The more reason that we should have made that person as a party to the suit.
But I will make it,
Purchaser.
madam. I will make it a suit for partition in separate position. If they have got the minute, they have take out their rights in the final degree proceedings. Purchaser may be a proper party, not a necessary party. All the family members are before the court. Madam, one more question, madam, very importantly. Whether the
That too, a suit that is filed in the year 2011, interim applications are considered in 2024. What has happened and what are how the properties are sold and all those things should be there before the court to pass any order.
Madam, all the documents are before the court. Let us judge
Parties
observe
should
that
also be there.
photographs are produced.
What
show the
parties-
construction.
parties should also be there.
And you also kindly see the construction at least. Photo, I have produced the photographs.
Might be. The court is not denying that the constructions might be taken place, but you should have made all them as a parties. Now, either will order notice so that parties will come or else I can pass orders now also.
Madam, if the construction is proceeded with tomorrow they will claim equity.
Orders can be passed.
Madam, one more last submission I will make. Last kindly issue emergent notice. Madam, last submission I will make.
The appellant is permitted to take out hand summons on the counsel appearing with respondent to the trial court and file a memo to the defect. And in addition to that, emergent notices
Madam,
shall be
one more
issued
submission,
to the
Lord,
respondent.
kindly say, madam, construction is alienated, subject to the result of the suit.
Any of the
That's what
constructions,
Supreme
any
Court
of
has
the
said.
constructions. But they have to be parties to this.
Madam,
When you don't do
Madam,
what you're supposed to,
2000
why should the court pass an order?
of the year 2011, madam, all these days there is no construction. Now they are proceeding with the construction, madam. If they proceeded with the construction, they will claim equity, madam.
Was this matter on 15th of October? Yes, next.
Madam, you will also kindly say, at least, madam, construction is
let-
subject to result of the suit.
No, let them come. Yes.
Party adjourned, 41. Okay.
The urgency, my lord, suit for declaration filed by plaintiff. 1997, we purchased it.
When is the order passed?
My lord, order passed on September 20th.
Yes.
September 20th, my lord.
Yes.
You not annexure, my lord, passing. Trial court initially granted order of injunction, my lord, not to alienate.
You're the plaintiff in the suit.
I am the plaintiff. My
What
suit
is the
was
suit for?
suit for declaration to declare I am the owner of the property. And the defendants in turn, my lord, has obtained a compromise decree without making me as a party.
When was that compromise decree?
2021-22.
2020.
21,
What is the
22.
suit?
That is for partition, internal partition, they himself filed without.
You are a
making-
purchaser from one of the.
Yes,
joint-
my lord, one of the original owner. Defendant number 5 is one of the original owner. He is also one of the signatory to my vendor's GPA. Now they filed without making all purchasers, they filed a compromise decree,
Is of which year?
1989, my lord.
When was, when the plaintiff had purchased?
My lord, plaintiff purchased on 14/7/1997, my lord.
14/7?
1997.
Compromise decree is in the. year
Compromise
2020.
decree passed in OS, my lord, is on 20,
Please come to the order.
yes, my lord. Please page number 42, relevant page, para 17, my lord. Para 17. From the rival contentions of the plaintiff and defendant 1 and 2, it is found that both the plaintiff and defendants are claiming the site number 70 and 71 formed in survey number 25, Andhralli village. It is not in dispute. Original land is 25, was purchased by one Mangamma in the year 1965 under the sale deed. However, plaintiff claimed after the death of Mangamma, her family members executed a GPA in favor of husband of the plaintiff. Based on the GPA sale deed has been executed in favor of the plaintiff, her husband. But on the other hand, though the defendants claimed that original lands was purchased by Mangamma, but after death of Mangamma, her legal heirs have filed a suit in OS 1009 of 2020, where the portion of 25 has been allotted to defendant number 1 and father, and later it has gifted site number 70 and 71 in favor of his daughter, defendant number 2. Therefore, it is observed both the plaintiff and defendants are claiming having derived the title through the original owner Mangamma, both based on the different two documents. The question whether the GPA executed family members of Mangamma in
Not to alienate.
Milord,
What you sought is not to alienate.
not to alienate, not to interfere. Status quo at least, Milord,
The-
for earlier trial court granted injunction.
Agreed with the orders passed in I number. This is in I number?
3 and 4, Milord,
I
page number
3
20.
and 4, dated 20th September 2024. The plaintiff is before this court. The suit is filed for declaration and
Declaration and injunction, permanent
Injunction.
injunction.
and that you are the owner of the property and
In
that
possession of the
compromise-
property. Compromise decree is not binding also sought.
Compromise under a compromise decree is not binding on the plaintiff. It is the case of the plaintiff that the original owner has executed a GPA in favor of the plaintiff's husband in the year 1989, and her husband has executed a sale deed in favor of the plaintiff on 14/7/1997, and ever since she is in possession of the property. The defendants who are the original
Owner's legal
owners
rights.
who was executed, one of them was executed a JPA in favor of the plaintiff's husband. They have filed a suit for partition and obtained a compromise decree. When the plaintiff had sought for an injunction restraining the defendant from alienating the property, the same came to be dismissed by order impugned, observing that the plaintiff could not make out a prima facie case whether any GPA is executed, whether the said GPA is binding or not, whether the plaintiff is the owner of the property or not, has to be decided by way of a full-fledged trial. This court has perused the order passed by the court. There is no dispute that the plaintiff had a sale deed dated 14/7/1997. And both in the name of the plaintiff and the defendant, the kata is made. They have produced the kata. Considering all this, unless and until the suit property is preserved in the disposal of the suit, the relief that is sought itself would be frustrated. In that view of the matter, there shall be an injunction restraining the defendants from alienating the property till the next date of hearing. Same emergent notice. Hand summons on the counsel appearing for the respondent and shall file a memo to the defect by 21st of October. List this matter on 30th. Get those signatures.
May I make one submission?
Yes.
Serial number 51, both the council were present after vacation. Interim order may be extended. 51. The interim order dated
At the request of both the councils, post this matter on 29th of October. Till then, the interim order granted.
interim order dated 23/9/2024.
23/9,
2024.
2024 is extended in the next date of it.
Please.
I'm not in.
I appear for that.
That is about not to execute the, you appear, not to execute the sale. Yes.
Yeah.
I was thinking that respondent would be
Yes,
this side.
My senior counsel is for the respondent, I am for the applicant.
Yes.
Lord, serial number 53. I'm for the respondent, my learned friend is for the petitioner. It's RPFC matter. Talks for settlement is going. I am appealing for the.
50,
Three, my lord.
it is submitted by both the council that the settlement talks are going on, post this matter on 4th of November.
My lords, serial number 58, my lords. I'm appealing for the respondent number 5, my lords. Respondent number 5, my lords. I'm appealing for respondent number 5.
58.
Please, my lords.
I appear for
My
the
lords,
defendant, my
the
lord. This
thing-
is that matter, my lords, so recollect, my lords, that,
Oh, passport.
no, no, no. This is matter related to, my lords,
Ah.
overlapping of
Ah.
the layout, my lords, and unilateral
Remember, I
cancellation.
remember that.
That,
Hmm.
I oppose seriously, my lords, adjournment, because activities on the site, my lords, is going on last
We'll
one.
grant an interim order and then adjourn.
Yes.
My lord, senior
We'll
counsel
grant-
is not.
Maybe,
available
maybe.
after-
That's how it's been adjourned now. Now if we'll grant an interim order and then you can, your senior can come later. We'll hear it in the afternoon. Yes. Yes.
Madam, serial number 29. Madam, 29. Serial number 29.
11. Madam, serial number 32. Huh? 32, 11. ಅಲ್ಲ 411. 411. Interim extension ಆಗಿದೆ. 51, 53. ಇಲ್ಲ, senior ಇದೆ. 30. ಅದು ನೋಟಿಸ್ ಆಗಿದೆ.
It is submitted by the land council that they've already issued the NOC. And they were permitted to attend the case. And on the last occasion, this court had directed the name of the party to be printed in the cause list. Having obtained an NOC from the council, it appears that the no other, she has not engaged the advocate, nor any steps are being taken. It appears that the appellant is not interested to pursue the matter, dismissed for non-prosecution. Yes, next.
Bill number 2 for orders. Devraju ji, memo for withdrawal.
The memo is filed, then to withdraw the petition as not pressed oblique infructuous. So memo is taken on record and the petition, appeal is dismissed as infructuous, as withdrawn. Yes,
Bill number 3.
yes,
That is also memo for withdrawal.
yes. The memo for withdrawal is filed stating that the case has been filed against the respondent challenging the award dated 28/10/2022 in AP number 71 of 2021. Now, the appellant is not interested to go proceed against the respondents. And accordingly, sought permission to withdraw the appeal accordingly, dismissed as withdrawn. Yes, next.
Bill number 4. Really. The respondents in this case.
What is this dismissal of the appeal?
My lords, the appellants had filed memo of withdrawal. They challenged the lower court order.
They
but
stated that
However, the matter has been
settled out of court. And
Proposal
submitted to-
letters produced along with the memo.
what is all this?
My lord, this is a closure letter, my lord.
The memo is filed stating that the matter is settled out of the court, with the intervention of the third parties.
My lords,
As the memo is filed seeking to,
my lord, the appeal may be dismissed without any liberty to file further, because the matter has been already settled, my lord,
no, why will the liberty be granted in this?
without any liberty.
No, why it will be dismissed as not pressed, considering the same? The appeal is dismissed as not pressed.
5. Gangadharaya.
The matter has settled between outside the court, my lord. And the matter has been settled outside.
It is stated that the appellant had executed a confirmation deed on 24/6/2024 in favor of the tenth respondent, confirming the sale deed dated 6/10/2020, executed with other respondents in favor of the tenth respondent. There's a present memo is filed seeking to withdraw the petition, and the same is settled out of the court. The memo is taken on file, and the appeal is dismissed as withdrawn. In the light of the settlement, yes.
6. Chetan B. Furnishing of cover and acknowledgement.
Lordship, in this case, appeal for appellant furniture. My Lordship, respondent number 1 and 2, Venkatesh P. Dalwai name may be deleted, my Lordship. Veeresh Budiyal name may be shown, my Lordship.
What is that?
My Lordship, respondent number 1 and 2, my Lordship, Venkatesh P. Dalwai is then standing counsel for respondent number 1 and 2, my Lordship. Instead of, my Lordship, he is not a standing counsel, my Lordship.
What is the name of the standing counsel?
Veeresh Budiyal, my Lordship.
No, in this MFS, notice has to go. They have to file wakalat, not like writ petition, we tell them that standing counsel take notice.
Last date of hearing, my Lordship, earlier order was.
They submitted that.
Trial court.
So and so is a standing counsel, delete the name of Venkatesh P. That
Dalwai.
guy, for R1 and R2, print the name of so and so. Then for, in respect of notice to R3, the steps shall be taken by 15th of, by 21st of October.
Respondent has
It's-
conducted action, my Lordship. Respondents 1 and 2 conducted action, my Lordship. It is challenging before this.
So, the And there is a delay of 124 days. Let them come. How can the court pass an order? That's the reason, let's give notice to the respondents. Take out emergent notice on them.
Please.
Ministry is directed to issue emergent notice on the respondents. Pose this matter on 21st of October. Yes, next. And the steps shall be taken also by 21st. Yes.
7.
Here
Anupama
for the
Board
appellant,
of
my lords. As per the direction of this honorable court, the trial court has heard the application, my lords. It is reserved for orders on 15/10.
Letter is there. Mm. This court, by order dated. This court directed the trial court to dispose of the pending IA. IA is within 2 weeks from the date of receipt of the copy of the order. It is stated that the copy is received on 4/9/2024 and within the time-bound manner. The IAs 1 and 2 could not be disposed of. And the legislature has sought three months' time for disposing of the IAs. It is stated that several applications are also pending. Considering the same, a 2 weeks' time is granted, 2 months' time is granted for disposing of the matters, the disposing of those IAs. As requested. Yes, next.
Cell number 8.
Our appellants,
Anand Veerananavar.
appellant seeking time for engaging senior counsel, seeking time for engaging senior.
For the office objections shall be complied. Post after shall be complied by 16th of October. Default law. Yes.
Cell number 9. Ajit A. Shetty.
The registry raises two objections. But the first objection, my lords, is that certain languages, certain documents, my lords, are in the vernacular language. The registry, my lords, has asked me to file a translated version of all these papers. But my respectful submission, my lords, is
No. The main objection appears to be.
yes, my lords, that is on IA4,
Hmm.
my lords, which is an application filed on my lords, order 26 rule 19. That, my lords, I'll have to respectfully submit that I need to file a writ petition. The reason why, my lords, I included that prayer is both these orders were passed simultaneously, my lords, and they are so intrinsically connected. That is the reason I included this prayer.
IA number. As far as IA number 4 is concerned, office objections are sustained and the appellant shall file an appropriate petition. Then with regard to.
Vernacular language, my lords, my submission would be, my lords, except for 2 schedules and 2 documents. My lords, I'll not trouble my lords with any other document.
The office objections with regard to the translation copy of pages so is overruled.
There is some urgency, my lords. What has happened is there are 2 applications, my lords, both applications filed under order 39 rules 1 and 2. One by the plaintiff and one by the defendant.
Because we'll not hear it at this stage, post after vacation.
May I request one request? Lordship may kindly reserve liberty, my lords, to move the vacation bench if need be. Because what is happening is they are now moving material onto this land. And my lords, this is a land on which I already enjoy, my lords, an order of permanent injunction. And that, my lords, that order is assailed in an RFA which is currently pending.
When is the order passed?
Lords, I understand.
So that liberty this court cannot. Yes.
Very well. Great.
Cell number 10.
May I request for a date soon after the.
Pose this matter on 16th of October.
So great.
Yes.
Cell number 10. Shankar A.
Appellant, there is no notice that is issued, in spite of which they have filed wakala, the defective wakala. I had requested my lord about 3 days ago for urgent listing, and my lords were kind enough to list the matter today.
But you know, when it is listed for orders.
My lord listed for orders because of their default. It's not my default. My lords have not ordered for issuance of notice.
We'll take it up like after other matters.
grateful.
Just 10 call later.
I'll
After-
seek for an interim order. That's it.
One more matter which I have filed. I have also filed an MFA. If both the matters can be taken up after vacation.
He
there's
says
no
that
urgency.
he's pressing for it. No, he's
If-
pressing for an, we'll see whether there is urgency.
The suit is stayed in the PR. Suit is already stayed.
That doesn't matter.
Further proceedings is stayed.
Further proceedings has.
But injunction was.
That's the.
Yes.
That we will, yes, next.
Cell number 11 adjourned, cell number 12. Allah Baksh.
The MFA, my lord, is filed against the ex parte application are pending in the trial court, my lord, against which, my lord, and before this honorable court, the trial officer there is objection to file and delay application, my lord. My lord, even the interim order granted in the trial court is, even today, it is in enforcement, my lord. It is continuous and recurring cause of action, my lord. It will, limitation application did not be filed, my lord. And MFA is clearly maintainable, my lord.
MFA is filed against which order?
Ex parte temporary injunction granted, my lord. And also I have filed.
When
a
was
vac-
it granted?
It was granted on 5/8/2023, my lord. I have filed vacate application 30 out of 39 rule 4, my lord. Both the applications are kept abeyance from more than 1.5 years.
What is the relief you are seeking here?
My lord, at least before the trial court, my lord, the time bound may be fixed and the application may be decided and the direction may be given, my lord.
For that MFA?
My lord, this honorable court also has a power to decide the ex parte application also, my lord, but I don't
No,
want
but you are
to burden this court.
simultaneously pursuing it. That's a problem.
I don't want to burden this court, my lord. All that my request, my lord, is kindly direct the trial court, my lord, within 30 days, my lord, my injunction applications will be decided on merits, my lord. It is covered, my lord, within 30 days, it has to be decided, my lord. After hearing both the
Council
parties-
submission with regard to non-filing of IA for condonation of delay along with office note.
Already, my lord, the plaintiff has suffered the judgment and decree.
If you want a
against-
speedy disposal,
Is my lord,
MFA
only
is
on
not the
application,
remedy.
my lord, only on my injunction.
No, that's not, MFA is not the remedy.
MFA, Lord, I can press for the relief on the IA number 1 to be vacate, my lord. But for that, my lord, since the other side is not there, my lord, what all that may request, my lord, in the trial court, my lord, IA number 1 and IA number 4 may be heard and decided within some time bound, my lord, and petition appeal may be disposed of.
What are those IAs?
IA number 1 is for grant of temporary injunction filed by the plaintiff. Ex parte interim order is granted, my lord, on 5/8/2000.
IA number?
IA number 1, my lord.
Injunction granted. What is the
Yes, ma'am.
vacate petition?
Vacate order 39 rule for IA number 4 filed by me, my lord.
IA number 4 dated?
Dated 2/2/2024, my lord.
The MFA is filed. Questioning the injunction that's granted in favor of the questioning the injunction granted by the trial court restraining the defendant from
Interfering and not.
interfering and alienating the property. The plaintiff had, the defendant had filed IA number 4 to vacate the said orders. Though in this case, he is questioning the order of injunction as already he has questioned the same by way of IA number 4. This court is not inclined to consider any of the submissions made by the council. Considering the fact that this application is filed in the month of February 2024, the trial court is directed to dispose of the pending IAs as expeditiously as possible, but not later than 2 months. The notice to this court is not proposing to issue notice. Disposal is signed. Yes, next.
Cell number 13. Chantraj KG.
I'm appearing for the appellant, my lord. In this case, the judgment passed by the Railway Claims Tribunal number by wrongly mentioned SBCs, but that is incorrect. I have made a submission. So as per the norms, I have written the OA to you, but trial court did the error in the judgment. SBC, my lordship. By wrongly, SBC means station Bangalore city, my lordship. Other case,
According to the court, that SBC is missing.
wrongly mentioned.
Office
SBC,
objections or overruled. other objections are complied with. We have to post this matter for admission after the opening. That is on 21st of October. Yes, next.
Till number 14.
Much obliged.
I appeal for the
Jay Kumar
matter,
K.
my lord. Office objection is regarding, my lord, this appeal is by the defendants arising out of a suit for partition. During the pendency of the appeal, defendant number 12 died. That was not brought to the notice of the court. And I, while filing the cast title, I showed that the defendant number is 12 is dead without any issues. And the defendant number 21 and defendant number 21 is also no more, and LRs are not brought on record by the plaintiff. That is, to that effect, I had made a note below the cast title.
You are the plaintiff.
I am the defendant in the court below.
Who died is defendant.
Who died is the defendants. It
Hmm.
was not brought to the notice of the court. And moreover, I filed, I have made a note below the cast title that I have not claimed any relief as against the respondents number 2 to 8. And I also sought for dispensation of the, in page number 10 of the appeal memo. Notice to respondent number 2 to 8 and 10 may kindly be dispensed since no relief is sought against them in this appeal. And they were placed ex parte before the trial.
Who died, you said?
One is
Respondent number?
respondent number, and they are not, respondent status is not shown here, madam, because since they are dead. So I have shown the status as in the trial court. One is defendant number,
No, you must have stated defendant, respondent.
I have shown as defendant number 12, my,
Respondent number?
defendant number 12 before the trial court.
Hmm.
12 and defendant number 21. Your lordship will find that in page number 9. Bairama, defendant number 21. And at in page number 8, Venkatama died without issues, defendant number 12.
So what is to be done now?
Office objection may be overruled, my lord, since I am not asking for any relief against those
No,
respondents.
you are asking, you are not asking only against 2, 8 and 10. You are asking against them
2
also.
to 8 and 10, ma'am. 2 to 8
2
and
to 8 and 10,
10.
but these are 21 and 12.
Hello, my, your dispensation I am seeking in
No,
respect
21
response.
is 9,
9.
9 and 12 is which defendant respondent?
21, my lord, defendant number 21 before
no.
the trial.
12 is respondent number 5. That you are seeking
Respondent status, we will not give when party is no more, respondent status will not be given.
No, an order will be passed against a dead person now. What is that? I'm not able to understand.
My only submission is,
Uh,
we are the defendants before
No,
the
all
trial-
these steps have to be taken before the trial court.
trial court. Yes,
That
ma'am.
you have not taken. No, you will
I'm
say
the
somebody
defendant.
died. No,
I-
no, you will mention that somebody died. And you want a,
The plaintiff has to take steps before the trial court for the consideration of this MFA. That LR application may not be necessary since.
that
no-
where did
no
you
rel-
say? That you did not say so.
I'm seeking dispensation of notice against the.
There is some
Except-
confusion in
la-
this.
la-
That's why I'm asking. Against these persons, you are not seeking any relief.
Relief,
You
no.
says, no, the respondent name will not be given because they are no more. Then where did you say so?
My only submission is respondent number 1 here is the plaintiff. He is the only person.
So you please tell that, except respondent number 1, against all the respondents, I am not seeking any relief, should be your note. Then all this will be dispensed with. Because no adverse orders are passed.
1 and 9, except 1 and 9, I will not seek any relief against.
One is who?
One is the plaintiff.
Uh,
And the respondent number 9 is the defendant number 20.
1 minute. One is the plaintiff.
One is the plaintiff.
Then other one is?
Respondent number 9.
Who is he?
Defendant number 20. Now he has filed an application to transpose him as a plaintiff. Except these 2 persons, I will not claim any relief against all other respondents. I will
File a
file a
memo.
memo to that effect.
Yes.
Hence, office objections may kindly be overruled and matter may be posted for admission.
File now.
I will file a memo now itself, ma'am.
It is stated that the plaintiff is not seeking any relief in this petition. It's against any of the respondents except one and respondent number 1 and 9. To that effect, a memo is filed and the memo is taken on record and the office objections are overruled.
And office has requested to furnish the death certificates of the deceased person.
Mhm. What is that?
Death certificates I am producing, ma'am, along with a memo.
The post if other objections are complied with, pose this matter for admission after the open.
There are no other office objections.
Then pose the matter for
Admissions.
admission
the date-
after vacation,
Date may kindly be some urgency.
23rd. Yes,
Till number 15.
yes.
4 weeks time may be granted.
Maintainability of the appeal. Why 4 weeks time? Give that, what is that?
We ought to have filed commercial appeal by oversight, MFA was filed,
Then for that, why you want 4 weeks?
and other office objections are
Office
also.
objections or sustained, and the appeal is disposed of, giving liberty to the petitioner to file the appropriate petition. Yes, within a period of 20 days from the date of receipt of the copy of the order. Yes.
15.
Plus.
Raghavendra Desai.
For petitioner, my lord, kindly pass over, I'm withdrawing that. Please, I'm filing a memo.
Huh?
I'm filing a memo for withdrawal.
Yes, you will file.
Right?
A memo is filed, stating that the petitioner wants to withdraw the petition. Memo is taken on record and dismissed as well. Yes, next.
Till number 17.
For the petitioner in this, Your Lordship, this honorable court had stayed the proceedings of section 125, subsection 3, on the condition that the petitioner will make a payment in 2 installments. Partly it was complied, 50,000 was paid, 2,80,000, 2,80,000 was the 2 installment. He could not comply because he was in JC for some time on the same petition, and he could not arrange for the money. The DD is ready. Yeah, he may be permitted to deposit the DD, and the second installment time may be
How much
granted.
is the amount?
It was totally 5,60,000. 50,000 is already paid, 2,50,000 DD is ready. Time may be granted for another 2 lakhs, for 2 months time may be granted.
Where is the petition for that? Have you filed an IA?
Yes, Your Lordships.
Where is that?
Extension of IA number 4.
I number 24, I number 1 of 24 is fine. Seeking extension of time for depositing the stipulated amount of 50% in 2 months. This court had by order dated. What is the order date?
7/4.
7/4/2024.
Sorry, Lordship, 18/4/2024.
18?
4.
2020.
2024.
2024, a granted stay, subject to the condition that 50% deposit, the 50% of the amount shall be deposited within 3 weeks. It is stated that in compliance with the order dated, order, they have deposited an amount of rupees 49,999 against an amount of rupees 2,80,000 and unable to deposit the balance amount. And then seeks some more time. Then counsel for the petitioner submits that a DD for an amount of
2.5 lakhs.
2.5
5 lakhs is
lakhs
ready.
is ready, and he'll deposit the same before the registry. And for further payment of 2,50,000.
Yes, 2 months time may be granted, Your Lordship.
For further payment of 2,50,000. 6 weeks, time is granted from the date of receipt of the copy of the order. No further adjournments will be granted.
18
Control list.
till number 19. 19.
Yes.
Passed in proceedings under 125, Manal.
No, like office objection.
Office objection, that is a typographical error. I
That
have
you
got
please
the
correct.
certified, corrected copy, certified copy I have got, my lord. I have,
Respondent number 2 is Rajesh.
he,
Katarapi.
he is the son of the, minor son of the petitioner. By mistake, Rajesh, son of the Rajesh anta. It is certified copy, corrected copy ಇದೆ. Anup
That
is
you
the,
file, that's what is the objection.
the objection, I have written this one, while complying, I have explained this one mistake error, correcting. This matter has been posted before your lordship. Lordship kindly peruse the certified copy, wherein corrected.
Take that.
First page of the order sheet itself, where it contains the name of the second respondent.
The same it is as it is. No, this Anup is not there in the in the petition filed before the trial court.
He was petitioner number 2. And that is reflected in the order sheet, which I have given.
This is what it is.
Another, just now I gave first
That's
page.
why you have given this only.
First page of this. Adralli Anup ಅಂತ ಇದೆ. Anup is the rate.
No, as far as the interim order is, this impugned order is concerned, he is not shown as a party. That Anup is not shown as a party.
No, Anup, by mistake, his father's name is shown. That is why I am telling. Just now, instead of Anup, son of Rajesh Katriki, Rajesh, son of Rajesh. That is a mistake.
Suvarna is the mother. Sri Rajesh Katragi, son of Sri, instead of mentioning, then the clarification should have been sought from the court in the order copy. That's filed. No, we cannot look at where is the other cause title and all. When the cause title is wrong, we should file a petition and court should clarify that.
No, just after filing only I put.
That should be, because we cannot look at some other document. If this is an order where the parties' names are not properly, then you have to file an appropriate petition and get it clarified.
Allah, if I am permitted to file the memo along with certified copy in this office, whether it could be accepted me.
Better you get it, this becomes.
Because time stipulated for payment, impugned order is now about to be expired. That's why. Interim order, that is why I filed.
This is on 14th June 2024. By this time, you could have get an order also. And just clarifying the names and the cost title.
Delay, there was a delay in receiving the certified copy. Same order, this Anup, second respondent, has been given in MC petition. Now they are divorce has been granted, even MFA filed by the.
For example, in this case also, no, court has to go by this. This has to be clarified.
I can do that, my lord. In the meantime, that time is till then, at least your lordship may kindly.
And that too in orders, this court will not grant any, when the matter is coming up for orders, no interim order will be granted in that. The office objections are sustained.
Obviously, it is a reputation of the already relief granted there, my lord.
Yes. Yes,
I may be permitted to file that order sheet along with this one. It is, along with the impugned order only, it has been furnished to me. If I am permitted, whether it will be, objection can be overruled, I request your lordship to do it.
the office objections are sustained and the petitioner shall obtain the correct copy as per the correct array of parties and file before the court for the registry. Yes, next, post after vacation on 15th of October. Yes, next.
Till number 20, R.S. Sector. A. Ravi Shankar, M.D. There.
Lord, I am appearing for petition. The petitioner has challenged annexure K,
Yes,
the order, Lord, passed by the,
I think we'll have it after vacation. There are so many matters. Again, we can't decide all this now.
I will leave it.
Yes. Post this
Some
matter-
date may be given.
Post this matter after vacation on 11th of November.
In fact, had on the last occasion.
I heard, but the problem is
But
now
no,
again,
I will
there are
convince
so many
that.
matters now today. There's no time for the court to dispose it of today. Post this matter on 12th of November. Yes.
Till number 21, Anupam Agarwal, Shima SK for respondent.
I appear for the petitioner in this
He's
matter,
asking that file, I think. Give it to him. Yes.
My lord, I have not filed the affidavit since I'm filing a memo along with the ITR returns of the last 3 years for the petitioner, my lord. The petitioner is not in a position to clear the arrears, sir. The arrears are coming to an amount of 7,70,000 rupees till September 2024, calculating from the date of the application, my lord. I'm filing, ma'am,
File in the registry and affidavit, the affidavit shall be filed before the registry. This is matter on 22nd of October. Till then, the respondent shall not press for the execution. Yes, next.
Till number 22. Murthy K. Memo for withdrawal.
Memo is filed stating that already the main MC itself is settled between the parties. Divorce was granted on 15/6/2024. The memo is taken on file. The petition is dismissed as withdrawn. Yes, next.
Till number 23. D.V. Shashank.
my lord, so here for the petitioner, my lord. My lord, respondent has entered appearance in the trial. I may be permitted to serve the lawyer who's operating for respondent in trial.
The petition is permitted to serve the hand summons on the counsel appearing to responding before the trial court and shall file a memo to the effect by 21st. If the same is filed, list this matter on 23rd. Yes,
Till number 24.
For the petitioner, my lord. Lord, the office objection is with regard to annexure E, my lord. My lord, for the,
yes,
my lord, the office objection is with respect to filing the main petition and objection of the CMIS 190, my lord. My lord, I am challenging only annexure E, my lord, which is the attachment order passed by the respondent number 1. My lord, what has happened is, my lord, the learned family court was pleased to pass an order of attachment of the salary of the petitioner to the tune
what
of
they say
20,000.
is, nature of prayer to be stated, corrected at prayer para A. What do you say about that?
My lord,
Yes,
I would like to take your lordship's attention to
what is the
page-
prayer you sought? Let's see.
to quash the impugned order that is at in annexure E, my lord, salary attachment order. My lord, the respondent has passed to attach the salary of the petitioner to the tune of
Where is that order?
67,000.
Where is that order dated 7/2/2024?
It is at page number 47, my lord. My lord,
How can you question this?
sorry, my lord.
How can you question this by filing this WP?
My lord, this honorable court was pleased to reduce the,
This is not an order passed by the court.
please,
This is an order passed by some authority.
please, my lord.
Uh,
My lord, but it is completely against the order passed by this honorable court. This honorable court was pleased to pass the order to attach the salary to the tune of 10,000, my lord. But whereas he has passed to attach 67,000, my lord, which is completely against this the
so
order.
that writ petition under 227.
Sorry, my lord.
You will file a writ petition under 227.
Please, my lord.
Office objections shall be complied with. Yes, next.
Till number 25.
Your lordship, here the petitioner number 2 is the minor. So petitioner number 1 is the mother. She is representing this WP, your lordship. This is the office objection. And main prayer and interim prayer both are same. I am seeking 4 prayers, your lordship. Main prayer are 4, your lordship. And interim.
The counsel for the petitioner partly complied the office objections. The following objections are to be completed. Prayer A and B and interim prayer are same to be clarified. What is that?
Your lordship, I am
What is
seeking
prayer number A? Come to that.
interim prayer amount pending, your lordship. The respondent has not paid the interior, this maintenance amount, your lordship. So both contains prayer, main prayer and interim prayer, both the contains that one, your lordship. Because it's more than 2 lakhs, respondent cannot pay at a time, your lordship. So that's why I've added in the main prayer.
Because both are one and the same. That's what they said.
I have 4 prayers, your lordship, in the main prayer. To increase the maintenance amount to pay the main remaining. So this may be overruled, your lordship.
What is impugned order?
Impugned order is this page 40, your lordship.
Page?
Page 40. 6,000.
Page 40 is?
Page 40 is the order, maintenance order granted in the year 2021 and.
What is this and what are your prayers here in
Your
the writ
lordship,
petition?
The trial has not finished, your lordship. It's at the.
No. In your, what is the relief that you sought before the trial court? What is the trial court granted? What is your main prayer? What is your interim prayer?
Lordship, I'm seeking 4 things, your lordship.
Can you seek all that before this court?
Your lordship, since 5 years, the petitioner is.
Please understand, please submit something legally. Is it permissible? Not about the problems court is asking you. What
Your-
is IA before the court?
IA is interim or in maintenance amount, he has not been granted, he has not paid, your lordship, till now. And speedy trial, it's for speedy trial.
You sought for maintenance of 25,000. Court had granted 6,000.
Yes, your.
Questioning that you have come before this court. What are the reliefs that you sought? How can you see the office objections? Of October.
Yes, your lordship.
Till number 26. Monica
I'm-
Patil.
And for the petitioner, your lordship,
Yes.
your lordship, we have served a copy of the petition along with the documents upon the lawyer representing the respondents before the trial court, your lordship.
So-and-so submits that. He has instructions to file wakalat. Was this matter on 15th October? Yes, next.
Name the.
Just call the passwords.
Yes, sir. Passover matter. Which one? Number 13. Fatima escape.
So please file the wakalat in the counter. File my wakalat in the counter.
Yes.
State institute asked to produce the order passed in 2819.
Yes, please pass on.
I could get a internet cost. Page number 8. This order was passed on 12/7/2024.
Madam.
Grandparents and the father can exercise the visitation right at their place on every Saturday. The father can pick up the boy from the mother's place at by 10 AM. And boy can stay overnight, and on Sunday 10 AM, the father will drop the boy at the mother's place. The petitioner father and mother shall adhere to the timeline and shall not create any kind of inconvenience to the other spouse. As far as the girl child is concerned, as she is too small, on Saturday, the father shall pick up the.
Yes,
girl.
so he, as per the order of the court, on every Saturday, the father can pick up the boy from the so and so. And on Sunday by 10, can stay overnight or the father shall. So they'll be staying from Sunday 10 o'clock to
One,
10,
Saturday.
Sunday 10 to Saturday, I mean Saturday 10 to Sunday 10. Ah.
Not follow.
Anyhow, that is a different task. So now any order that will be passed will be taken into consideration this order.
At all. I've been paying the maintenance. This is a conditional order. I was asked to pay maintenance of 1,25,000. I'm not in a capacity to pay. My father is paying. Now the condition is I have been requesting.
Your client is trying to act too smart. That's where he landed up. Otherwise, things would have been more simple. He himself has made it complicated. The court, no, the court at every time, how many orders, how many interim orders are passed by this court? How much of time the court had spent? How much the time court has spent on this? And how many times by virtue of the orders passed by the court, your clients have exercised a visitation? How things were going on? So if you understand that, it would have been good for you. You have not understood, then it will take its own time. You wait for it. Yes, where is the order? Impugned order.
Impugned order is at page,
They may be direct.
page one,
I'll ask them to do it.
page
Yes.
145, operation of the order. Number 2 starts with IA number 8.
The presented petition is filed, agreed with the order dated 5th January 2024. In I number 5 and 8, whereby the mother is restrained from taking the children out of the jurisdiction of the court for disposal of the petition. Land counsel appearing for the mother submits that this court earlier had disposed of the PP number 2819 of 2024, dated 12th July 2024, wherein on every Saturday, the father was permitted to pick up the child from the mother's place by 10 a.m. and the boy was permitted to stay overnight. And on Sunday by 10 a.m., the father has to drop the boy at the mother's place. It is submitted that seeking modification of the same, both the mother and father have filed applications before this court, and the same is heard and reserved by this court. And the orders are yet to be passed. It is submitted that in the Dasara vacation, the mother wants to take the children for 4 days. Between what is the time?
That's 5 to 6 days, not that is all.
There should be a time and date for that.
Whichever time, date the court fixes, we are okay with that also, because we don't want to.
So let it not be a Saturday and Sunday.
Yes, my lords.
Between, they wants to take the children for 5 days
Monday to Friday.
to Mumbai and Goa, where there's a family function.
Because even
In
date
view
can
of
be
the,
fixed
in view of the order passed by the trial court, they're not in a position to take them. The learned counsel appearing for the respondent father submits that in spite of an order passed by the court, the mother is not able to exercise a visitation from the last couple of.
From the 12/7.
One submission.
From the
Maintenance also
from-
is not paid.
Huh?
Maintenance is also due for.
From the couple of days and on couple of occasions. And they're complying with the interim order passed, they're complying with the order passed by this court and they're paying the maintenance. Learned counsel appearing the father, mother, has disputed the same and stating that no amounts are paid. With having further counsels. If the party is not complying with the orders, and any modification that is sought is pending before this court for passing the orders, which will be, and appropriate orders will be passed in the due course. Then coming to the submission with regard to taking the children out of the jurisdiction of the court is concerned. Admittedly, the boy is having a passport and the passport is with the mother, with the father,
That is going to expire.
with the mother. And according, it is submission that it is, that passport is expired.
Expiring, my lord,
His
expiring.
passport is expiring, and she is also, and there are no, it is stated that she has no intention to take the children out of the country, and she's a housewife. Now there, it is stated before the court that she wants to go to Mumbai and Goa. And the orders that are passed by this court on 12th July 2024 is the overnight custody on Saturday and Sunday. Considering the same, this court is permitting the mother to take the children in the with the children for between Monday and Friday. Any Monday and Friday in the vacation, she can take them to Mumbai and Goa as submitted before the court, as by Saturday and Sunday, children shall be in Bangalore in the light of the earlier order passed by this court, as the court had granted visitation. Great. It is submitted and council, no, we'll keep it pending. It is submitted with the land council for the, it is, what, so and so submits that he has filed a wakalat on behalf of the respondent, and he'll also come up with his objections. Suppose we list this matter on 21st of October. No further orders are required. Order what is existing is existing. That's why, then she has to comply. If she is not complying, you are not.
Look, these are the messages which I don't even want to submit before the court. So the message that he sends the.
No,
One day before vacation.
no, why your client, what modification you see?
Look, first of all, the child is refusing to go.
Why
That
will
I-
you refuse to
No,
go?
no, go overnight.
Then if not overnight, why are you not
Correct.
sending
Look,
him?
look, one submission. In fact, when I met him, even for the festival or for other things, earlier they used to meet in Hotel Grand Mercure, which is very close to their house. She has no, can I submit please? She has no problem even today taking the child, going there so that father can exercise. Even for the festivity, she said, I will take the child so that the child can witness the festivity. So these are the messages that he sends. Obnoxious. Even today, my lord, today let him
Anyhow,
tell, she will bring
anyhow,
the child.
please, you have to understand that the matter is still pending before the court. And the conduct of the parties will definitely will be
Definitely.
taken
I
into
think
consideration.
your lady
So
has-
for that purpose, now you're permitted by the court to leave Bangalore and spend
5
your
days,
time
yes.
for 5 days.
Yes.
So, okay, do whatever he says.
Well, if we can instruct this client.
That's
not
why,
to send-
after they come back, during the daytime, let the father and the grandparents have the visitation in their house.
Mercury earlier, my lord, in a writ petition, habeas corpus,
No.
when they had filed.
Considering
there is-
the submission of the land council for the, what the court says that if it's acceptable, then we'll grant. Otherwise, nothing to grant now in this. So what I'll direct them is that after coming from the place throughout the vacation, during the day, let the children be sent.
One submission, my lord. Let it be either Bangalore Club or Grand Mercure till your lordship feels and decides that application, because.
Why you want this?
That is not, nothing else.
No, why it should be in a hotel?
Nothing else, my lord. I just.
You say, why the
I just-
Bangalore club? Why are you after that Bangalore club when that's a whole issue between you?
No, that she was removed. I'm talking about the kids, my lord. She is removed, she can't exercise. She is removed.
Why should
She
they
has
be
made-
only, no, what is the difficulty? What your client's ego is?
My lord,
that is-
because, no, what was earlier passed, taking advantage of that, they file an application that the custody be shifted to the
How will it be
grandparents.
done?
That is what they filed.
If they ask, what will do? Why will, when the mother is
Because
there,
it
why
is-
will the custody be given to them?
Correct.
No, please tell your client, let her not have all these kind of apprehensions.
No, that's fine.
Let her, because all these things.
Only this,
But
I'm okay.
No, no, tell your client, in the pending petition, this conduct of your client will be considered by the court. That you please tell her.
It is not even
And
part of this thing.
before that, please let, Monday to Friday, go wherever you want to go, come back till the vacation is completed. Now, this arrangement, as far as this order is concerned, this arrangement shall go on, and the father during the vacation, you send them during the course of the day.
So let it
Sometime
not be recorded
between.
Because if that is in that petition, then modification may be affected. I will make sure. That is all. That is all my this thing, because it's my writ petition and it won't be fair.
It is submitted by the land council appearing for the mother that the mother is interested to send the children to the father's place after they come back from Mumbai.
But not,
Till the vacation, every day they will be sent to the father's place between 10 to 2.
all right, that's fine.
Yes.
The second child being too small.
The
I hope they-
second child, I think 10 to 2, second child can
That's
also.
okay, whenever she
It's
wants
not
to come,
overnight.
think
It
to-
won't
that is
happen.
all.
She will. Yes, next.
14, second BS.
What is that? Yes, Mr.
Lords, as per the direction, my lords, on.
What is the modification you wanted?
My lords, the modification, my lords, I had filed the memo of calculation also, my lords.
Hmm.
Lords may see the order, my lords, at page
Oh,
number.
that is like with that.
10,000 to
interim
5.
Period that has
Yes,
to be
yes,
changed.
My only.
Anyhow, as per the court order, he did it. Make this a parted. Pose this after vacation, we'll pass that order then. Pose this matter on, It is already in parted, let it be in the parted, and the amount that is deposited, you have deposited it or a check or
They
DD or
have
what?
deposited before
By way
this
of a
honorable
DD.
court. DD, by way of.
The amount that is deposited by way of a DD before the registrar, the respondent is at liberty to withdraw the same.
What's that
Pose
date
this
may be?
matter on 22nd October, please. Yes.
Yes.
Number 15. Till number 20. Arun Govind. Sai Guru Shashank.
What are your instructions?
I have not been able to speak to, my lord, he's in Delhi as of today, but on 7th of August, my lord, I'd made a submission before this court. Your lordships have recorded my submission that about 20,000 rupees per month is what will be paid. But now that they're saying that they're willing to have shared parenting, my lord, 20,000 rupees amounts to more than 1,500 rupees per day. If a son is going to live with me for 15, children are going to live with me for 15 days in a month.
You can deduct the 2 minutes.
I'm sorry, man. I'm unfortunate that such submissions are being made before the court. I'm paying as of today, Lord, 1 lakh per month towards educational expenses, 1,35,000 rupees towards rent. My salary is 3.9 lakhs. 2.35 lakhs is going only towards these two expenses. I'm saving, Lord.
No, when the husband is paying that much, why should she stay in a 1.35 lakh apartment?
On instruction, she is willing to go to a lesser house with lesser rent. She is willing to go. That's another concession I'm giving. But kindly have this affidavit, not income affidavit.
Affidavit
Filed
filed by,
This is filed on, I don't know when it is filed, but,
by whom?
By the
by the husband.
petitioner.
By the husband. Is it on
Doesn't
On the
have a
date of
date in
filing?
my copy, my lord.
19/8?
Yes.
Some documents are filed on 19/8.
Yes.
Kindly come to your
That's
second
filed by
page.
them. Mr. Arun. You filed it on, some documents are filed on 27/8/2024. There is
That's a list of documents that.
19/8/2024.
August, we had filed the list of documents.
And you are filed on 11th, and that's, I think.
On 25th, we had.
Yes.
Kindly
Sorry,
have the
27
second page, my lord. Page number 2 out of 19 pages, my lord, it is 19. No, this is-
These are all, one, yes. 2.
Page number 2.
Uh,
Your lordship says personal expenses alone, my lord, single person, is showing 182, out of which 52,000 is not rent, so let's deduct that. About 1,20,000.
no, where do you get that? Page number, no, like it is like this.
My affidavit, not your affidavit. I'm talking about the husband's affidavit.
This is ABCD, that's how he has given it, something.
No, that's our affidavit.
Tonichi Kumar, affidavit of assets and liabilities.
Why? I'm asking the lordship to take the affidavit.
Yes. This is also filed by him. Page 2, yes.
Personal expenses, the lordship says,
Hmm.
182 is showing for himself, single person, out of which 52,000 is monthly rent. Please deduct that. Even then it comes to around 1,20,000 rupees for only himself.
1,20,000.
Lord, now your lordship can take the judicious thing, Lord. For 3 persons, will it be anything lesser?
Very well,
Now,
my lord.
One second. Then, my lord, your lordship will show, see, the next 2 columns. 1,20,000 he is showing as what is being invested for college fund and his retirement. 1,20,000, that shows that he has excess 1,20,000 to invest. But now he is saying his income is 390. Total expenses he is showing 1 plus 2 plus 3 is 537. At the bottom.
Total is 5,37,500.
Out of 3, if a person who is earning 3,39,000 according to him, he is spending 5,37,000 on his own say. Now, my lord, I'll show, my lord. 1 minute, if your lordship permit me, my lord, I'll show the kind of lies that have been telling to your lord. Now, my lord, your lordship may kindly have. And not, we have only extracted the documents from his affidavit, my lord. Yeah.
Yes.
But all these are recurring transfers. So salary deposits, not by his employer, Ernst & Young, not. All I could get was from September to November 2023. It comes to not 27.45 lakhs, which comes to not 11 lakhs per month.
Page 39.
Current, no, where are you reading from this?
39.
This first page.
First page,
Not the
amount in lakhs,
salary from Ernst & Young.
27.45
I
lakhs.
don't have that, my lord. What's going to be mutual funds?
No, I'm saying-
Different page. Rumble them.
Yeah.
This was-
And we have given the page number, what, this column. Your lordship,
Yes,
in
I've
this
seen,
column,
I've
I've given the page numbers
Hmm.
of his affidavit, my lord, where these deposits, my lord, by Ernst & Young is shown. No explanation. Now, if your lordship has another second page.
Hmm.
This is another recurring deposit made to only one UPI ID. One UPI ID, total, my lord, comes to monthly average deposits made to this UPI ID, which we don't know which of what ID it is, which comes to, my lord, monthly deposits being made is 30,000 rupees. Total, my lord, from July 2023 to 2nd of October 2023, my lord, 1.8 lakhs, my lord, is transferred to some UPI ID we do not know, my lord. Lord, the third page, Lord, is, Lord, the mutual fund investments which he has made. It comes, Lord, to 30.6 lakhs in 1 quarter. That is from September to November 2020. Comes to, Lord, 13.56 lakhs. Page 4, Lord, your lordship will see. These are pension contributions. This is not, Lord, in fact, goes into a pension account. I will not make it. Then corporate reimbursements, Miller. What we have found is June 2024, Miller, 22.74 lakhs, Miller, has come to his account, Miller, as a corporate refund. Huh? So this from US transfer. And Miller, 6th page, Miller, credit card repayments which are being made every month comes to, Lord, average of 3.5 lakhs per month. Lord, can your lordship believe, Lord, that this person has 3,90,000 rupees of salary, where he's paying 2 lakh, not 10,000 rupees, not 1,10,000 as,
No, he was actually referring to that 3 crores and you said that you have something to say.
3 crores, I will explain.
Hmm.
Please have, first, my lord, your lordship may have this document which has been filed by us. Please don't mix up my files.
That is ours, that is ours, that is ours.
That is dated 19/8.
Yes, I'm sorry. This thing, Lord, list of documents. On the 19th August. It is filed on 19th August. 19th August.
No, 19th August. Yes,
But I want your lordships to see page 132.
32. Yes,
The lordship will see September 23, the third column, my lord, 2022, the transfer of 53,000 US dollars. This is my account, my lord, in the US. This is my account in the US, right? Singly, my lord. And my lord, the other page on this side, lord, if this.
so how much it will be 53,000 means?
Totally it comes to 232,000. No, I'm talking about 53, then your lordship will see three columns below that, 79,000. And the next one, my lord, $100,000. This is the amount which is transferred. Your lordship sees there. Transferred to State Bank of India, Kolkata, NRI Bank. From my account in US to my account, Lord, in SBI. This comes to Lord 1.85 crores, taking 80,000 rupees, 80 rupees as the USD value, Lord, of that day. That is 1.85 crores.
Yes.
Now, my lord, you can leave this document and come to Lord, my assets and liabilities. We come to page 251.
In the same papers?
In my assets and that is the wife's donation.
It's what that? Yes, sir. Oh, what is that? Give that. That's what it is, give. Yes.
To page number 251. 251.
Yes.
The lordship will see FDs were created by an SBI account. Out of the same money which came out, this is on 26/6/2022, in the name of the wife, Suniti Kumar. Mode of operation, the lordship sees single. But then there is one at 252 and then there is another one at 253. Three put together come to about 1.1 crore. 3 FDs were made. Now 254, your lordship will see, this is the forged document on the basis of which 1.1 crore, lordship sees here in the middle, 1.1 crore is clearly mentioned there. And here it says transfer, do not renew, transfer to savings account. This very my money, Lord, has been transferred to the joint account and Lord, this account has been frozen. So whatever money that I had, the 2.3 crores that had come, Lord, that has stood frozen. I have not been able to use. Now, my lord, your lordship will see the next stage. On 7th of October, my lord, where is that text? Lord, all the trouble between the husband and wife has started on 9/10. Before the trouble has started, Lord, when they were together. On 7/10/2022, Lord, 2 checks for 45 lakhs were Lord, drawn by the husband itself in the name of the wife, Lord. This is there, not in the documents. But I just wanted your lordship to see that.
Which page?
No, I'll give,
Hmm,
I only want to show the name. the date.
45 lakhs and 45, 90
45
lakhs.
lakhs and 45 lakhs. This is the amount which has been deposited in Bank of Baroda.
Hmm.
And my instruction is that this was when they were together, they wanted 45 lakhs to be invested in the name of the two children each for their future. But today I am left with only this money, except this 45 and 45 lakhs, which is in the Bank of Baroda. Let him show, submission has been made even today, my lord, that 4 crores I have taken away and run away. Let them show one document. And this 4 crores is not just come across the bar here, my lord, it has gone all over the internet. Let them show one document.
Very well. Lord, I'll
Let
place.
them show one document, Lord, from his account that money has gone. I am admitting this 90 lakhs. And I am saying, Lord, it has come from this very SBI account where my 2.3 crores was there. I'm showing the transfer from US. I'm showing the FDs that were made. I'm showing that he has got it transferred into a joint account. And from that account, my lord, 90,000 rupees has gone to Bank of Baroda. It is there. And I have actually, my lord, for these 2 years, I have utilized only that money. And some help from the father. He has not given me 1 rupee.
Yes, what do you say?
Not so far as the senior advocates
So
submission. that
first and
My
foremost.
income, my lord, that September to November. Not everything is on record. Kindly see page 71 of
No.
my.
Not that September to November income. In your statement of, in your personal expenses,
Yes, my lord.
you said so.
Yes.
You yourself require some 1,80,000.
No, kindly see out of 1,80,000 rupees. No, I listed out my expenses. 70,000 rupees, my lord, is towards loan payment, loan repayment, legal expenses, and transport expenses.
There is not in the affidavit.
Sir,
there is
1
no
second.
loan.
One second,
There
sir.
is no loan.
One second, sir. Kindly see page 2. My lord, I have itemized everything. I'm a salaried person, my lord. I'm not into business. Every single rupee of mine is accounted, come to my account, and only thereafter I've declared, I've placed everything on record. Kindly see page 2. I have listed out every single expense of mine. 52,000 rupees is the rent, my lord. Page 2 of my affidavit.
There are so many papers.
No, that is why I made a submission in the morning, my lord. If your lordship permits me, I will place on record the sale deeds of houses which we jointly owned, which were sold in the US, and the entire sale consideration has gone to my wife. The entire admittedly, my lord, the affidavit filed by the wife says she's not worked for more than 10 years. Where she got 3 crores from, my lord, is a question that she will have to answer before the court. I have the document. I have the documents from the sale deeds. When money has come into the joint account, and from there she has transferred it to her own account here.
No, but you show that
Yes.
5,75,000 is a monthly income.
But it's not, it is not.
No, you said so from your.
I've not said my income is 537.
Not income,
the
your
expense.
expenditure is.
My
55
father,
lakhs.
my lord, is paying me 1,20,000 rupees a month, every month.
Where from you said so?
My lord, my client is not here. They are slightly, all documents are placed on record. Every single document is placed on record. And my lord, so far as income is concerned, the money I got between September and November last year also included 18 lakhs bonus. I have placed those documents, my lord, page number 71.
So you get a bonus of 18 lakhs
18 lakhs. My lord. It
for
depends-
one,
it
for one
depends-
quarter.
Yeah, no, annually. It's given between September and November. I've placed all, but salary certificates for the entire year are placed on record, page number 71 onwards.
No, she's ready to, send the children for this entire, and she also wants to join
Yes,
parenting.
yes.
So till such arrangements are paid, what is that your client is going to do? Anyhow, she also said like 1,25,000 rent she shouldn't necessarily not pay that, and she's as the senior counsel said that she's going to shift into a lesser rent and
But if
accommodation.
you're looking at shared parenting, I will also have to have the similar kind of accommodation. Both of us will have to be near the school. I will also have to move. I will stay near Hebbal. But I'm grateful to the learned advocate.
One thing, Lord, that my friend is absolutely right.
I will also have to shift now.
Children are studying in, near the old airport, Lord, on Vijail Road. And Vijail Airport in the old
Yes.
Madras. But he lives in Hebbal.
I have to shift.
That entails about 2 hours, Lord, up and down, Lord, travel.
Therefore, I'll
That
also,
should be avoided if we can shift, Lord,
Therefore-
not immediately, but
in the next couple of months, my client, when I called him and spoke to him, he said he'll come and explain the entire AOD to me along with documents. He says, yeah, I will also have to shift now close to the school if we're going to have a shared parenting arrangement. All I'm seeking, is 10 days accommodation. I've already said 20,000 rupees a month is what I will pay, apart from 2.35. That statement is already on record. Kindly,
let me pay that sum for now. And whatever settlement takes place, we will be.
No, that's what I'm saying.
One
No, no. Now the court will not say like every month you'll be paying it. No, 15 days and again the matter will be listed, then it will be heard.
Yes,
No, some amount towards the maintenance, that's what I was telling you to get instructions. from the-
he's not, I'm handicapped because he's not in station, he's in Delhi today. He's coming back tomorrow evening.
Just one last, I forgot to make this submission. Please have page 15 of his affidavit. This 4.4 crores, really every time this is being bombarded against this lady, that she has taken away 4.4 crores and run away.
15.
Page 15 of the husband's affidavit. And see the last paragraph there. What it says is the deponent and the spouse have a joint NRI account, so and so in State Bank of India, corporate in Gurgaon. This joint account was used by the family members to transfer their income from abroad to India. During the pendency of the marriage over 12 years, more than 4.4 crore has been transferred to this joint account, more than 70% of which was transferred by the husband. So what he's saying is, I've actually maintained the family out of this 4.4 crore. It's not as if she's taken and run away.
No,
This is what he means.
First para on page 15. First para on page 15. With great respect to my learned senior friend, my lord. Page 15, first paragraph. I have listed out the amounts. What date the amount came into the account. Everything is mentioned, my lord. The lordship may kindly come straight away from the fifth paragraph. The bank account is still active and has a balance of $239,000, approximately 2 crores on 10/6/2022. And I produced a document. No, it's not that she's not without money. My entire life savings are with her. I will place everything. We have sold properties in the US. There were 2 houses, my lord. My pension that's come from Switzerland and the US is with her. It is in her account. I have nothing. And I have placed everything on record.
Pay 50,000 to her.
Sorry, my lord.
50,000 till all these things are discussed.
I was paying every, and my lord, my daughter's education.
So once she'll also shift into a smaller accommodation. Then she'll be able to.
Not if your lordship records the submission that they are undertaking.
Ready for the joint parenting.
Shared parenting, and she will shift to an accommodation with lesser rent, my lord. Until we arrive at a settlement, my lord, I will. If your lordship grants me 2 minutes time, my lord, my client's father is here. I will just check.
But this document that they're showing, he's showing annexure 15A, shows the wife's name. It's the same 2.32 crores. But this is apart from the fact, but in fact, Lord, if I take your lordship to my, the affidavit filed by the wife, Lord, we have given the expenses that were being incurred for the children before desertion and after desertion. Their, Lord, standard of living has come down by 50%. They are not getting any more extra classes, no tuitions, nothing.
No, the school they go, the school they go to has swimming, art, theater, food. All classes are taking place, including food.
All on payment.
What do you say?
No, he says ultimately he is the one who's funding his son. No, he says 50,000 rupees will not until some settlement is arrived at and the house shifting happens.
I not agree to that, Milord, because he himself is saying I spend on myself 1,20,000 rupees, Milord. But at least 2 lakhs he has to give.
In that case, I have this immediately after vacation. I will have the children be doing vacation. I will argue the matter on merits from affidavit. I'll have the benefit of my client's presence also over here. He will be able to demonstrate, my lord, every single rupee that's been taken from my account to her account.
Can we do this, Milord? He is saying 50,000 rupees. For the last 2 years, he has not paid me anything. For the last 2 years, Milord, let him pay the thing at arrears at 50,000 rupees. Rest we will.
I'm sorry. Lord, her own bank account that she has produced before your lordship. Not only does she tamper the bank statements, I will explain to your lordship how she's tampered the bank statement. Kindly see. Deposit is shown at, the balance is shown at 1,03,000 rupees, 1,300 rupees per month. There is no credit, there is no debit. The balance becomes 40 lakh rupees.
No, let's say that 50,000.
Yes.
What do you say about, it's also an admitted fact that from 2 years, you're not paying anything to her except the school fees?
School fees and rent.
Except the school fees.
And the rent.
Rent is after some time, some order is
And also,
passed.
my lord, he said, I don't have money.
Hmm?
Then 27 lakhs had been transferred on that very month. He said, I don't have money.
My lord, may I make this request, not 50,000 rupees, my lord, from today I will continue paying, and your lordship may have it immediately after vacation. My client will be here, I will verify with him and I will make my submission. No, it is not my intent, but if my intent was to ensure that she doesn't get any money, my lord, I wouldn't have paid my children's educational expenses, 12 lakhs per annum. My daughter will join first standard now, and the educational expense will go up by another 4 lakhs. It's going to become 16 lakhs per annum. And I'm undertaking,
No,
my lord, I'll pay all these expenses.
we'll post this matter on 16th of October.
Very well.
Then by that time, in the next, when you said it's 4th.
Yes.
4th the vacation starts.
4th to 13th, my lord, 4th evening, I'll pick them
Can I
up.
ask for one last thing? Subject to your lordship's pleasure. Lord, he's saying that, Lord, he will take instruction and come back. Let him pay in the meanwhile, my lord. I'm sending the children also. Lord, I am without.
No, that's what I'm
Some
saying.
lump sum.
No. 4th is
Friday.
Friday. That day you will pick up the children and you will again drop them back on 13th. 13th. Now, without like, what is the further arrangement and what are the things are going to be, you pay some amount as, please instruct your client.
My apologies.
Or else
Lord.
we'll-
I'm
we'll-
handicapped without his presence here. That is the only thing. He was
I'm
down.
doing this
He's-
mutual fund deposits, which are up to, my lord, 13.6 lakhs in one quarter. That's
Not
3 months.
The entire bonus I got, it is not that I have not placed those documents on record, but Leonard Fund is trying to make it seem like I'm hiding something from the court.
There.
Whatever 18 lakhs bonus I got, 6 lakhs, my lord, was taken away as tax. Page number 71, my affidavit contains the entire statement.
As per the orders passed by this court, both the parties have filed their respective statement of assets and liabilities before this court. When the matter came up, the senior counsel, appearing on behalf of the wife, submits that, in fact, she's ready for a joint parenting plan. With all completely, she's ready to send the children to the father. It is submitted with the senior counsel that the father has come before this court with several suppression and misrepresentation of facts. And as he stated, his salary is not 3,90,000, but is on, in fact, as per his statement, he's spending an amount of rupees 5 lakhs and odd the expenditure he has shown is 5 lakhs and odd. It is submitted that for himself, he's spending an amount of rupees 1 lakh,
20,000.
1,20,000. And in this, till now, towards their maintenance, no amounts are paid. Drawing the attention of the court to several documents which are filed by the husband, along with his statement of assets and liabilities, then the senior counsel submits that the version of the husband father cannot be believed. And even now, how the children were, the standard what the children were maintaining when they were, when all of them were together, and now it has drastically come down. It is also submitted that the father is staying in Hebal and the mother is staying near Whitefield. Staying and the children's school is near Whitefield. And even for a joint parenting plan also, joint custody, the distance between the two places is almost 2 hours. Even that aspect also need to be considered. Then counsel appearing for the father submits that the father is not available and as such is not able to place the instructions before this court. Instructions for the court, considering the same, this court is passing the following order. The father can have the interim custody of both the children from 4th of October to 13th of October. He shall pick them up from the mother's place on 4th at 10 o'clock.
Evening. School
At
finishes
3
on 4th,
3
evening,
p.m.
5 o'clock.
And they shall drop them back at 3 p.m. That's no, to pick up them, picking, and on 14th, on 13th, by 3 o'clock, the children shall be dropped back at the mother's place. The father shall pay an amount of rupees 2 lakhs by 3rd of October to the mother as an without going into or considering any of the contentions raised on behalf of the parties. An amount of rupees 2 lakhs shall be paid to the mother as it is admittedly father is taking care of the house rent allowance, the rent and is taking care of the educational expenses. The mother, it is submitted that the mother will be shifting to a premises where the amount of rent is, now she is paying is 1,25,000 to a lesser rental accommodation. She will be moving. Next point, the father shall also look for an accommodation for himself, which is near to the place where the school mother is residing. List this matter on 21st of October. Huh? What is that?
Only 2 lakhs. So blessed.
One more thing, they will not take the children out of the jurisdiction.
The father cannot take the children out of the jurisdiction of the, no, no arguments on that, out of the jurisdiction of, she voluntarily came forward, that itself, we shouldn't ask anything more. Yes.
Cell number 38. Reader G.
During the imprisonment, the mother may be permitted to have
While the children are with the father, whenever it is convenient to the mother can, whenever the children wants, the mother wants, she can have a audio video call with the children. No bar on that. Whenever she wants, she can. And the children also.
Yes.
At least once in a day.
Once again, yes. Lord, may I make this?
Yeah.
Since the matter has been heard considerable length, would it be for further?
Why every matter parted from Dharwad, I am supposed to hear all these
Yeah, only
matters.
Not since your lordship has heard this matter, not
No,
extended.
already I have at least 10-15 parted, sir.
Only
So 2 roasters I'll be doing from Dharwad, there and here.
Just this one matter. It's been heard for so long. I've understood. It's been heard for so long, therefore, my lord. May I, Lord, I'm sorry, I'm seeking your lordship's indulgence.
You suppose this as parted.
Obliged.
Cell number 38. Reader G.
For the appellant, which is defendant's appeal. My lords may recall last week it had come up different properties. The court has come to the conclusion that the plaintiff's property and the defendant's property are different. And my grievance is that the plaintiff is trying to
Why
utilize.
is it adjourned on that day? That's how it is adjourned. So now we'll clarify that both of you are claiming 2 separate properties. So now when you yourself are saying that in respect of his property, you're not interfering. And at the same time, under the guise of this order, he cannot interfere with your property. They're not even adjacent properties. Is it correct? Yes. No, we are not granting any order. We are only clarifying the order that is granted. Cannot, if at all. You are not saying that you are in possession of his property. They are 2. Correct. Now, both of them are not in the adjacent or not in the same lane. 2 properties in 2 different places. So if wherever let them, wherever your property you enjoy.
My lords, the records indicate undisputedly that I registered my property in 1997. He registered the property in 2011. If at all, if there is any claim to the same property, then they must establish that this is their property to claim a right.
He is not claiming that.
He is not claiming. Therefore, he must have no difficulty in agreeing for an order where he is not going to interfere with my property.
No, that's what, they're 2 different and distinct properties.
If it is
Agreed with the order passed. I number 1 and 2 in OS number 4230 of 2024, dated 17 September 2024. The defendant is before this court. The plaintiff had filed a suit for declaration.
Injunction, ma'am.
Where is your,
Plaint is at page
had filed a suit
30. Page
seeking
30.
the relief of injunction, restraining the defendants from interfering with the peaceful possession and enjoyment of the property of the plaintiff. The suit scheduled property is as below at page number 34 extracted. It is a case of the plaintiff that he is the absolute owner in possession and enjoyment of the suit scheduled property situated at 3rd Cross Anjaneya Temple Road, Eddie Bangalore. Earlier ward number 57, subsequent ward number 167. He had acquired the said property under a registered sale deed dated 13/6/2011 from the vendor, represented by the Registered General Power of Attorney. And from the date of the said deed, the plaintiff is in peaceful possession and enjoyment of the property. And the Kata also stands in their name. It is a case of the plaintiff that the defendants, without having any manner of right or the suit property, have come near the property along with their followers on 21/5/2024 and interfered with the possession of the plaintiff and tried to trespass over the property. In this regard, the plaintiff has also approached the jurisdictional police seeking police help. However, the police authorities declined to register the case as civil in nature. Hence, he has come up with the present suit. The defendants have filed their written statement.
From page 40 onwards. At page 43, para 13 is my property's description.
It is a case of the defendant that they've acquired the portion of the property belonging to cinema, being property consisting of site with old residential house bearing number 27/2, situated at 2nd Cross 6th Block, Eddie, Jayanagar, Bangalore, City Corporation Division number 59, measuring east to west 100 feet, north to south 39 feet, and bound on the east by the municipal Muniappa's house, west by road, north by Angappa's property, and south by common passage. They have acquired the said property under two separate sale deeds dated 18/2/1997. It is the case of the defendants that the defendants are in possession and enjoyment of the property which they have purchased. And they have also, after purchase of the property, they have filed an application for the BBMP for amalgamation of kata of the properties acquired by them, which was approved by the BBMP. I have very well stated that you are nothing to do with the you are not interfering.
My lords,
Where did you say in the written statement?
para 10, my lords. At page 42. Para 6 and 7, para 6 have denied the
Case of the defendants that they have never claimed the plaintiff's property nor ownership of the lease scheduled property. The plaintiff has filed the false suit seeking injunction with respect to suit scheduled property and to claim the property of the defendants as his property. And in their case, the defendants are in peaceful possession and enjoyment of the property. The next para, the plaintiff, along with the suit, has filed IA number 1 seeking injunction. The trial court, by order impugned, had granted injunction. While granting such an order, the court has observed that since both the properties of plaintiff and defendant are distinct and separate, and plaintiff has shown that he has purchased the suit property by virtue of sale deed and revenue records are mutated in the name of the plaintiff. The plaintiff has shown prima facie case as possession of the property. The suit being one for perpetual injunction. The position as on the date of filing of the suit plays importance. And since the plaintiff is shown to be in position prima facie, in the opinion of the court, there is a prima facie case in favor of the plaintiff. The property of the defendants are different and they have failed to show that plaintiff is claiming right over their property. Apart from this, there is a tribal case made out with plaintiff as some of the boundaries are disputed. The finding is to be given after taking evidence in this case. In this regard, as considerable time has elapsed after execution of the sale deed in favor of the plaintiff as well as defendants, the name of the persons mentioned in boundaries might have been changed due to subsequent acquisition. Hence, the court had granted, the court felt that there is a prima facie case, and if injunction is not granted, the plaintiff will suffer irreparable loss which cannot be compensated. Agreed thereby, the defendant is before this court. Learned counsel for the defendant submits that the property of the plaintiff, the suit schedule property, and the property which is purchased by the defendant are two different properties. Now, the defendants have stated in the written statement that they are not interfering with the plaintiff's possession and with the plaintiff's possession and enjoyment of the property. It is submitted that the trial court ought to have clarified all these issues while granting injunction. It is submitted that as there is an injunction granted in favor of the plaintiff, and the guise of it, now they are trying to interfere with the property of the defendant. Next part. The learned counsel appearing for the respondent plaintiff submits that as it's a suit for injunction, where he could prima facie show to the court that he is in possession of the property. The court had rightly granted injunction restraining the defendants from interfering with the suit scheduled property, and no grounds are made out seeking interference with the well-considered order passed by the court. Next para, having heard the counsels on either side, there is some material on record. The suit is for bare injunction. Here, the important factor in this case is that the suit scheduled property as mentioned by the plaintiff and as purchased by him, and the property that is purchased by the defendant are not the adjoining properties. They are two different and distinct properties. Vendor is one and the same.
No, my lords, they are also different.
And even the vendors are also there is no relationship even on that. The origin of or the flow of title is also different. The defendant in his written statement has stated that he is not interfering with the possession of the plaintiff, and he has nothing to do with the property which the plaintiff is claiming. The court has also given a finding that these two properties are different and granted injunction. Now it is submitted that under the guise of this order, the defendants are interfering with the plaintiff is interfering with the defendant's property, which is not admittedly not the suit scheduled property, as he is not claiming any right and title to that property, considering the submission of the counsels on either side. This court has, the appeal is disposed of in the following manner. The order of it is clarified that the appeal is disposed of, observing that as a trial court has given a finding that the defendant is not, the two properties are two different properties as such, and the plaintiff's case is only in respect of suit scheduled property. According to the defendant, he is not interfering. Under the guise of the order in respect of the suit scheduled properties, the plaintiff also cannot interfere with the property of the defendant, which is a separate and property accordingly disposed of.
Much obliged.
Yes, yes. Yes.
Cell number 42. Date record.
Yes.
Prasanna Kumar P.
Shall we hear him? Shall we hear him on his documents?
This one.
Yes. Synopsis is there. Page number 8. In page number 9. Eight. I'm looking at, oh, yes. Yes. Mm.
Dated 9/3/2015.
Mm.
Petitioner cleared maintained for 75,000 rupees per month.
Mm.
With litigation.
1 minute. When is that application filed?
93,000.
Hmm.
Along with that application works and
She sought how much?
75,000 as maintenance work and 25,000 rupees as litigation.
Hmm. Hmm.
By a lordship. Page of impediment again, paragraph 5.
Yes. Hmm. Yes.
We state that the respondent is being exactly this.
Mm.
I say that I am unemployed and I am very much in need of money to meet my day-to-day expenses and for livelihood. I do not want to be burdened on my aging parents. See that this application will not start and will discuss
When?
29/12/2015.
29/12/2015. On what ground?
You say 19 years ago. 19 years ago.
Para? Pet. Hmm. Yes.
So, the above evidence of the court, this court has come to the conclusion that though the petitioner is working, and there is sufficient money for her life, she has not to affidavit stating that she is unemployed. The above fact of the petitioner amounts to abuse of profit of probation. Therefore, it is clear that the petitioner has not acted. Considering the above evidence and this court has come to the conclusion at this stage, the petitioner is not entitled any injury.
Yes.
Thereafter, she filed one more application.
No, this is not question.
Has been questioned and that was limited back. Has been dismissed. Second time.
No. What is that she has filed? Again, is this order?
The criminal appeal was
Number?
the second application was I don't manage. 2016 was one more application.
So this is not question.
That is not.
Then thereafter, another application is filed on 1/2016, same under the DVC Act. How much claim? 20? 20? Page number 20?
22. Document number 2. Dated 16/1/2016.
Hmm.
Yes, claim 75,000.
Same.
This alert, case 25, document number 4, alert is the order.
It is dismissed.
This
Dated?
5/4/2016.
Against this appeal is filed.
Appeal. The document
Criminal appeal number? It was remanded.
During this, what,
No, this present order is passed after that.
page 44, document 6. Respondent my lords and handed over certain checks my lords to the father of the petitioner. Page 44, document 6. One of the checks. my
No,
lord,
criminal appeal is remanded. After remand, what happened? What is that? For your application, remand is the court has to deal with it.
Consider.
What is the order passed?
Dismissed.
When again dismissed?
Again, this. Page number. 118.
Date?
Date such as 18/4/2024.
On what ground? Please come to that. That's impugned in this writ petition. Okay. Where is that? Let's see.
Impugned order was the maintenance application rejected in matrimony.
So where is this order?
Page 124. Review proceeding, the application, second application, challenge and undertaker.
124. Petitioner is hereby rejected. Highly collective, so and so. This order is questioned?
No.
So now this order is not questioned.
Dismissed as non-constitutional, she didn't appear. That order.
Then? That's not relevant, yes.
Page 222, please.
Oh. Yes. 200 and?
222.
You know, it is dismissed for non-prosecution. Then, are they relevant for this case? Yes. You're reading at page number?
Argue that despite being granted 8 adjournments since May 15, 2020, petitioner and legal appeared before the court, not presented as evidence. Given this history.
Yes, rejected. Next.
He made the submission my lord before the magistrate that she is suffering from arthritis. That has been that she will be unable.
Yes,
to
yes,
do what-
yes.
Those submissions were made, sir. Appreciating those submissions, the entire proceedings. Simultaneously, my lord, the page 226, the page 226, my lord, there is the recent application which we have filed. After this one, we go, my lord, while passing the order of notification, directed to the other family court to conclude the entire proceeding. There, she filed one more application. On 2/9/2024, seeking expenses for the minor sentence of rupees 9,32,000. That is all. This application has been filed.
So one gratification by the dismissed. Now what is? Yes. So why she is not entitled for any maintenance according to you? And what about her income? What is your income?
Stable income other than the main which I am.
Other than the?
I'm not working and I have rental income here from
How much you're getting?
84,000. I have one, the elder son, my lord, is in Manchester. He's studying at
Hmm.
and also I have two dependents, each parents.
How much this court has granted for the younger son? How much the elder, I mean, what is the elder son studying? Hmm. Hmm. Yes. Yes.
Section liability, my lord, once they file one more application against me. before the commission. I have suppressed certain facts, they file an application in section 3.4. That was not considered with the pre-amendment.
Hmm.
Along with the bank statement that was.
So these are the grounds that she is not entitled.
Because she's working, my lord, she's not in.
That's what. Hmm.
And my lord, the petitioner's father, my lord, filed one case against me. The respondent in the petitioner, my lord, when you are citing the certain checkbook.
No, she is educated. Is there any other evidence on record that she is earning?
Nothing from the court, my lord.
Not the finding, about the bank statements are filed. As per that, what is what is the flow of money? Hmm.
Paid issue, my lord, was, other is getting monthly income of 15,000. It is being credited to my account and also other income, also credited to my account.
Also, how much credits are there?
Statements earlier which she had produced before the annual transactions of profit 5 lakh, 4 lakh, close to 4 lakh.
Per annum. Anything? Para number? Hmm?
13.
Hmm.
Partially, reason went up.
Hmm. Yes. Yes.
Let's go observe that the user is strictly confined to the scope and ambit of order 47 B 1 as the law has a point 42 individual application and answer. Parties are not entirely challenging the legal by alternative legal principle for exercising legal. Simply summarize human captain says as below. There is no following down the discovery of new and important matter or evidence which after the exercise of due diligence is not within the knowledge of the jury or did not be produced by the mistake or error apparent on the case of any other sufficient reason. You are any other and please the parents are Perjury approved by this court in Karnataka, most the reason sufficient on ground at least another way to.
Yes, yes, I understand. Yes. Yes, Mr. Sinegons. Yes.
Very safe ground.
Yes.
first application filed, that the Domestic Violence Act, first Domestic
Huh.
Violence Act is
Hmm.
filed when she was in New Zealand. And when she came here for second child's delivery, at that time he has not came to the India and is not maintained. Because of that reason, they filed a domestic.
Hmm.
At that time, Your Lordship can see when she was in the New Zealand, she was a earning member. Both are earning members.
Hmm.
Then after left the New Zealand, my lord, they came here and then she was no work. Because of that reason, she joined to the law course and studied law. Then she joined as a junior advocate. Now she is a junior advocate under the senior. Then Your Lordship can see that I have already produced the judgment of the Honorable Supreme Court to 2021 two Supreme Court cases, wherein para 60, may I read, my lord?
Yes.
Rajneesh versus
Neha, yes.
Neha and another.
Which para you are
Para
relying
60,
on?
my lord. Happy to- happy to-
Para?
Para 60.
Yes.
It is well settled that a wife can make a claim for maintenance under different statutes. For instance, there is no bar to seek maintenance both under the DV Act and section
That
150.
is settled law. That is settled.
Settled law. Because in view of this, Your Lordship can see if they have granted any maintenance order by suppressing of this fact and filed this petition, then I am not entitled. Here, Your Lordship can say they are not granted. Then he filed a petition for divorce, making allegation against this party, wherein I filed an application for maintenance against the child. And at that time, Your Lordship can see child was studied. When the first application is filed under the domestic violence, she was a born child, and he was not admitted to the school. Then subsequently he was admitted. Now he is in 5th standard. Then Your Lordship is well aware that the 5th standard student, how much I have to pay the school fees and that thing. Then moreover, Your Lordship can see she is a junior advocate, she is not earning. Then Your Lordship can see her earning is 5,000, she has clearly stated. Then in the application, Your Lordship can see she has stated that her father has obtained getting a 15,000 rent that was deposited in her account. That she is not earning, that is the amount not belongs to her. She has to take care of her father also, aged father. That amount is also not sufficient. Because of that reason, my lord, trial court has granted only 5,000 child. And on the ground that she is an employee and she is a working woman and she has refused to grant. And this court, Your Lordship, will see all these judgment without looking into all these judgments, my lord. This court is also refused to grant maintenance in favor of this lady and granted enhanced 5,000 to the child. In view of now, Your Lordship, I think she made an application. I think she has produced certain document wherein what are the expenses to the child and what is the expenses to the advocate also has produced. In view of this, Your Lordship, I can say this juncture, my lord, that she is very great hardship and
Will consider.
please.
His income is more than
Anita? Yes, yes.
And moreover, he's getting 85,000 rent admitted fact. Then he sold the property and that amount was deposited in the bank for 1 crore and that.
Gifted two properties to his
Yes.
father and mother.
Is a, how it is
There's
now?
any county
Huh?
law for it.
What is that?
And
Hmm. What is that? Why, when the money is there and when they, both of them are entitled, why they are not doing it?
money and deposited in
Both are rented as per the law.
New Zealand.
New Zealand.
Something is lying in New Zealand in a common account which they can, which she can have, she can make use of it if they, both of them come forward.
Yes.
That belongs to both of them equally.
Like even joint account that is there.
That's what both of them can have.
Otherwise, with the try. And moreover than the first child is an employee, he is earning member.
Hmm.
Let them produce document if he is studying. He is an employee that we have a document.
He has no responsibility towards his son.
Now we are claiming a maintenance in respect of second son, not first son.
Yes.
First son is an employee.
My lords, takes annual maintenance every year. And that, my lords,
No, I understand what is to be done according to you, what she should do. What is the procedure to withdraw the amount?
Then my client is ready to go with the husband.
And whatever is the amount, both of you will take half of it. How much amount is lying? 1 point?
ಎಷ್ಟಿದ್ದಾನಮ್ಮ? ಎಷ್ಟಿದೆ?
1.12 crore the maintenance. $225,000 New Zealand.
No, then we'll do one thing.
Please.
No, we'll keep this pending. And now that we were, so that we'll give a direction to both of them. And if substantial
Withdraw that amount.
amount comes, then it's also good for her.
This is good.
It is submitted by the council appearing for the, not reserved. Not reserved, keep it. It is submitted with the land council appearing for the respondent. The respondent husband that in the New Zealand, in the joint account, an amount of rupees 1 crore,
Date of application or date of order.
1.1 crore is lying, which both of them are equally entitled. As the wife is not coming forward, they would not withdraw the said amount. Then a senior counsel appearing on behalf of the wife submits that she'll cooperate for the same. And then what is to be done? A day for what? How? Whatever is equally. What is that?
No, he is telling something. In the meantime, he is interfering because of that. Let him complete his argument.
Yes. That anyhow will be done. So now, where shall she do, what she should do, when it should be done? There should be a time frame for that, isn't it?
Yeah, madam.
The wife is ready to cooperate with the same. And once the amount is withdrawn, after the statutory deductions, both the parties are entitled for half of the amount. The counsel for the appearing for the husband shall come in, shall inform the wife the procedure to be followed, and accordingly she shall also cooperate. And once the amount, once all the formalities are completed, the affidavit shall be filed for this court stating that what are the deductions and how much is the amount equally both the parties are entitled to. This is matter.
Then your lordship tells you one more thing. Your lordship kindly see the order of this court, my lord, on 11th day of June 2024, wherein your lordship has awarded a maintenance of 10,000. That from which date to which date, it is not clearly
When it
mentioned.
is 10th, when it is awarded, it
From the
always
date of
goes back
application.
to, it will goes back to the date of petition. When it is not mentioned, that's how it is.
Even they have not paid even 10,000 rupees every month.
Get instructions. When the matter,
They are not paying.
Oh, no, but please give the list of it, what to be done for him and for her. Will everything will write. How can you ask the court all this? Will the court secure her presence in the trial court?
He is not paying 10,000
When you want this matter to be listed, when? Yes, pose this matter on 4th of November. Yes.
Serial number 43, Pankaj Chenke.
It's an ex parte order. That's all that my respectful submission before this honorable court, set aside the order, remand it back to the tribunal so that I can place records and take the orders on merits. From 5,000 to 20,000, it is enhanced. Without considering the document, without producing the document.
List this matter on 14th of October. Yes, next, 45.
136 delays, my lord. Notice may be
Notice to the respondents.
Serial number
46.
46.
Post after service of notice. Next, 47.
47. Raghavendra KN.
40? Where is Raghav? Yes, delete from the caption dismissal. We close this matter on 25th November.
Number 48, 49 disposed. Cell number 50.
Notice to the respondents.
There's an urgency in this matter. No, its warrant has been issued against the.
Then what to do? MFA 2022 and notice and the
I'm
delay
ready
of
to-
71 days.
But-
Is it fair on the part of the court to grant interim order?
But I'm ready to deposit the money as well, 50% of the amount.
What is this? What is this order?
That's what the court below has done is, my lords, that an award of the appellant has passed an award amount of rupees 32,08,685, upon which the reference court has passed an amount of 2,39,148 rupees. This is the enhanced amount, my lords. The way the reference court has adopted is the sales statistics method. My lords, the
No,
preliminary
we are not at the
notification,
merits of the matter.
please.
Now, what is the purpose of staying this order? Now,
But the warrant has been issued, they're gonna come
no,
and.
they would
they'll take the-
issue a warrant when the amount is not paid as per the award. What are you doing from 2022?
But I've filed the NOC Wakalat. I've later come on the record.
Then let the client ask the advocate who was there earlier.
No, my lords, please.
No, how can it be? Why should the court stay that order? It can't be. Yes,
I'll leave it-
after vacation,
Please.
notice to
But
the
any date
respondents.
may be fixed, my lord.
Notice to the respondents, post after service of notice. Yeah,
Cell number
if the notice is served, list this matter on November 4th. Yes, next.
Please.
51 urgent, 52. Pawan Chandra Shetty. Notice delay. For appellant, my lordship.
Yes, notice to the respondents, post after service of notice.
Permitted to take.
Permitted to hand summons on the counsel appearing with respondent and shall file a memo to that effect. If the memo is filed by 4th, list this matter on 6th. Yes, next.
Cell number 53 urgent, 54.
Notice.
Lordship, appearing for petitioner, your lordship,
Notice.
through VC, lordship. Lordship, kindly tag this matter along with RPFC 289 of 23, your lordship.
Whatever number.
RPFC.
RPFC 289 of 23, your lordship. And
Post
notice may be
along with
issued, your
that.
lordship. And date may be given, your
Notice.
lordship.
Yes, next.
Cell number 55.
I appear for the
Date may be given,
petitioner,
your
my lord.
lordship.
This is a writ petition that we have filed arising from a petition filed by the father seeking for custody and also for divorce. It's an order on interim visitation rights. I filed
My
an
lord.
amendment
My lord, I'm appearing for the respondent, my lord.
Give that.
I've sought for a modification in my prayer. In fact, the writ petition had been filed because my application seeking interim visitation rights was allowed only in part, my lord.
No.
Lord, that application
Why
itself is
every
not
time before the
maintainable, my lord.
vacation, There will be an urgency for this case.
No, my lord, on previous occasions, I have moved the matter before
And you
vacation.
moved it on 25/4/2024. That day, the court has passed an order. Now
Yes.
again at the fag end, again another application has come.
My lord, the reason why I'm moving the matters before vacation is because I'm seeking the interim visitation
No,
during
but that
vacation.
cannot be one day before the vacation or 1 week before the vacation. It should be a prior
Always-
application, sir.
My lord,
Always
memos are-
the same.
My
Court
lord,
needs to
we
have,
move the memos much in advance, but it gets listed
Yep.
a week prior to the
My
vacation.
lord, there is no application for visitation, right, my
No,
lord?
I'm
The
not seeking
application
for
is,
visitation this time. My lord, I'm not seeking for visitation this time. If this honorable court has the time, I'm ready to address my arguments now. Else-
No time at all. What is
kindly have
urgency
it
now?
after
But
vacation,
date
my
may
lord.
be given.
Yes.
There is no,
After on 21st of October at the request.
much of,
and
much
comes
of.
with the petition. Yes, next.
Cell number 56.
My lord, in this case, my lord, I am appearing for a petitioner, my lord. My lord, I have been paying my maintenance of rupees 20,000 to respondent number 2. The arrears was rupees 11,20,000. Out of that, I have already paid rupees 6 lakh. Now my humble request to quash the order inspect of 5,20,000.
Today it will not be quashed.
My lord, just I will drive
Some
lordship
other
kindly attention.
officials, they
My
as per
lord,
the order
I have
passed
filed
by
a
the court,
affidavit of purchase
the appellant
liabilities.
had deposited the money.
My lord, I
No, it is
have
already,
filed.
permission is granted. Who,
I have been paying, my lord.
who are they to
Well,
tell
no,
that when there is an order? They will do what the court says. The court will not do what they ask the court to do. Let them, if they don't understand, then this court has already permitted the respondents to withdraw the amount on 22/8/2024. A submission is made that the registry is insisting the court to pass an order. As per the order, the respondent is at liberty to withdraw the money.
My lord, the interim order may be extended.
They will do it, not before this court, yes.
My lord, interim order may be extended, my lord.
Huh?
Interim order may be, because again, still the 5,20,000 is there. My take home salary just 42,327. I have filed my assessment liabilities, my lord.
Yes, pose this matter after vacation on 22nd of October. We'll see on that day, not now. Yes, next.
67,
Interim order earlier granted is extended. Yes, 57.
57, Suresh Latur.
What is this? What is this judgment? You that? It's a Act matter. They also filed an IA or something. You that? Why is it listed for judgment? 11/12/2023, post this matter after vacation. For delete from the caption. For judgment and post before the post in the usual course. Yes. Yes.
C8,
This is matter, my lords, where overlapping of layout, my lords, disobedience of interim order and
Yes, yes.
the sale, my lords.
No, we'll grant an order not to, what is it? Not to change the nature of the work.
Change in nature and not to alienate.
Huh?
Not to alienate and change. There are two IAP.
After vacation, let it come. In the meantime,
Please.
is property which he purchased.
My lords, development should not take in respect of A schedule property. Why that is because my lords overlapping that, my lords. Now, my lords, if they develop it, my lords.
Whatever it is, in respect, because your property is overlapping, your property is this much, you want acres of property to be
No, my
stored.
lords, I have, my lords, what, my lords, I may make one submission.
No,
I make
no,
one
what is
submission.
no, give the file.
I'll make one submission, my lord.
Yes.
Why, my lord? My lords, they have.
No,
they-
let's see what is the sue schedule property.
Please, my lords. Kindly see,
Where
my
is the
lords.
plaint?
Page 140. Schedule you got to make here, 140. 142 schedule.
147,
142.
my lord. So,
Plain schedule.
142.
142.
No, it's on 136.
147, my lord, Suddha.
What are all these 136, 137?
Two appeals are there, my lord. So that's.
No, I'm looking at MFA number 230 of 2024.
In this, my lords could see schedule property 147, my lords. Or 151, my lords.
It starts with all the piece and parcel of the land. Survey number 35, new survey number 80, extent of 8 acres. How can you seek for 8 acres when you purchase, how much extent you purchase?
Could I, my lords, see, my lords, my prayer one, my lords.
Huh.
Prayer A, my lords, declare the defendant 127 have no right to alienate in respect of A scheduled property, because what is now, my lords, by subsistence of interim order, my lords, they sold the property. Under joint development, my lord, they have given a right to a developer 90%. Out of 90%, my lord, they retain 10%, they received the money, my lord.
We'll
Now,
grant
my
an
lords,
interim order,
now
we'll
they're
grant an
changing
interim
the
order
entire layout, my
in
lords.
respect of what you have purchased, but not when the entire extent of
But
land.
I have a rights in respect of road and my lords and other.
For that reason, entire 8 acres will be stored.
My lords, otherwise what happens, my lord, they'll, my lords, overlap the site, entire layout, they'll change it, my lords. Then where do I stand,
You
my
can
lords?
only seek your remedy for an extent of how many square yards it would be your plot.
And let them form a layout in accordance
No,
with,
no.
my lords.
Your plot, how many square yards?
Mine is, my lord, total all five, my lord, 7,200, my lord.
7,200 square yards. 8 acres is how many square yards?
My lords, if they, my lords, go accordance with, my lords, in accordance with, my lord, the earlier layout plan, my lord, I have no difficulty, my lord. If they do it new layout, my lords, the roads are coming on my property, my lords.
No, as whatever it is, an extent of so and so should be preserved for you.
My lord, along with, my lords, my rights shown in my previous development, my lords,
What is
which I,
that?
that, my lords, which I am entitled for, my lord, civic amenities, I am entitled for roads, my lords, as shown in the layout, my lords, previously.
All that will not
That,
be.
my lords, has to be
the
protected, otherwise it
land
is more
council
right,
for
my
the-
lords. Let there be, my lords, my lord, there be a status code.
If he's not agreeable, what we can do?
I request this, my lords could be heard in detail, my lords, whenever my lords in immediate after vacation. Till then, let there be a status order, my lord.
But the
which
court has
I
to
had the
record that,
benefit of it, my lords, order of from
status
2013.
quo with regard to an extent of so and so which you purchased, not for the entire extent. It will not be
But
granted.
they should not overlap, my lords, my layouts, my lords.
Whatever it is, your property, then if some, that whatever your land is, now for the laying of the roads and all, you have to contribute for that.
I have contributed, my payment is sale consideration in respect of everything, my lords.
That you will get, whatever is your land, that will be preserved.
Preserve with all my rights, what is I am entitled in JD, my lord, that is, my lords. Protection is in
The
respect
petitioner,
based on site development agreement, my lords.
this court has earlier heard the ball and calls for the petitioner as well as for the appellant as well as the senior counsel. And the matter has underwent several adjournments. That there is a scope for settlement. Land counsel for the petition appellant submits that there was no scope for the settlement. They could not come, the settlement is not possible. Considering the submissions and the having perused the material. An extent of 4,000.
No, my lord, 7,000. As schedule B, C,
So,
schedule B and C,
7,000,
my lords.
7,000,
7,200, my lords,
an extent of 7,200 square yards,
as referred in
square feet, there shall not be, there shall not be any alienation or nature of the suit schedule property shall not be changed.
as in respect of schedule B, C.
Yeah, in respect of schedule B and C properties.
And my lords, rights which are covered under my lords, J development has to be
That will
reserved.
be decided by the court. No, your road, for example, you have a plot, that plot is secured. There would be, when they have already formed a layout, you will have your ingress and egress, your roads, your amenities will be there.
So violating interim order, they purchase it and doing it, my lord. That is my lord's
So
first
that
thing,
is
my lord,
true.
for
That's why the court is granting an order, but not to the entire extent. It's unfair.
But
Your
my lord,
extent you can ask.
my lord, so far as my lords in the overlapping the layout itself, my lords is my lords for consideration.
That is true, but now if the court is passing a final order, that's a different aspect. Yes.
My lords
Next.
would be hearing this after
Pose this
vacation
matter on 22nd of October.
in part heard.
No part heard. Yes. There is not in part heard.
It is in for judgments, my lord. Since
Delete from judgment. Yes. 40?
List one, serial number 43. Serial number 43, list one.
Yes. Pose this
Authorized
matter.
benefit.
Pose this matter after vacation. On 11th of November. Yes, next.
That passed over in. Number 3, passed over matter, serial number 10.
Plaintiff's appeal, madam.
Serial
It's a
number.
very short point. Serial number 10, very short point. Plaintiff's appeal. Suit for partition and for declaration that I have half share in the property. Plaintiff he claims that he is the adopted son of defendants 1 and 2 who are the father and mother. Defendant number 3 is a purchaser. There are only 2 items of the suit schedule. He is the purchaser of item 2 suit schedule property.
You are the plaintiff.
I'm the plaintiff, I'm the son, adopted son.
When did he purchase the property? Defendant number 2.
He acquired under a partition about 20 years ago.
Purchaser, when
I
did he
did not purchase. My parents sold the property to defendant number 3,
That's what I'm saying. When was it?
the 2023.
Ah,
Therefore, I came before the court. I
signify.
filed 3 applications. IA2, now I'm before this court, not to dispossess me, the parents are in the ground floor, I'm in the second floor. That is one application. IA3 is not to sell this house by the parents. IA4 is the third defendant who is the purchaser of another site, that is second item of property, not to sell. At a first instance, there are only 3 submissions to be made.
No. What is one IA only you're asking?
I am only,
What is
IA2
IA
is not to dispossess
You from that property.
from the second floor of the property.
Hmm.
Kindly now see the written statement. They admit, despite which they admit
They
that
admit that you are residing in the property.
I'm residing there.
Let's see.
Kindly see the written statement.
Not the written statement. Please
Written
come to the
statement,
impugned order.
ink page 48,
Come to the impugned order.
ink page 48. May I just request my lord to ink page 48.
Yes,
Last 4 lines.
yes.
Defendant wanted to senior and have mobility issues, hence shifted to ground floor, and not because the issues occurred since the plaintiff cited inability to secure accommodation to himself and his family members out of sympathy to his mother and Vanaja, he was permitted to reside temporarily in the second floor only a short period of time. So they admit that I am in permissive possession. I say that I am the son. They say any which way for deciding this case.
Please come to the order.
Kindly see the prior that they have sought. It's a counterclaim that they have made. Kindly see the counterclaim that they have made. Ink page 58, counterclaim. Ink page 58.
Yes,
Where the first defendant prays honorable please to issue mandatory injunction to the plaintiff and his family members to quit and vacate, hand over vacant possessions.
yes,
So they admit I am in possession.
yes.
Trial court at the ex parte stage, it grants me an ex parte injunction with respect to IA2. Now kindly see the order, impugned order. Ink page 21, para 9. Ink page 21.
Why is a discussion by the court? No discussion at all.
I have 2 more submissions. I have 2 more submissions. At the first, there are 3 applications as I mentioned, ma'am. For other 2 applications that are allowed on the same day along with this, the trial court says that I have established a prima facie case. And so far as IA2 is concerned, at an earlier point in time, the
Yes,
trial.
with that. Yes.
If completed, then I'll start. Lord, my contention before the court, when the court took up the injunctions was, suit is not maintainable. For that reason, Lord, this honorable court has said, wherever the suit is not maintainable, it should be considered along with the controlling. I made an application for rejection of the claim on the ground, Lord, the plaintiff has pleaded, these two scheduled properties are allotted by way of a registered partition to defendant number 1. So prior to his birth itself, there is a registered partition. Not the whole, all properties of the registered partition deed is not the suit scheduled property. Only that is what is allotted. So my contention before the court was, if it is an allotted in share in a registered partition, it attains a self-acquired status. But once it attains a self-acquired status, during his lifetime, suit is not maintained. To that effect, I place it before the court.
Now your rejection of plaint is pending will be considered.
But that is already.
Now you admit that so and so is in possession of the property. Let their portion be maintained. Why not an injunction restraining you from disposing the property? Where is that? What is the discussion? Is it a discussion for prima facie case? No, it's an admitted fact. And you have filed an application for rejection. Once the suit itself is rejected, he will not be entitled for interim relief. Till such time, why not he maintain
That
the
is
possession?
dismissed. That is dismissed. That application is dismissed. He has come in as here.
Please come. Agreed with the orders fast, right?
But may I request not, I'll produce document, we'll argue it out.
Considering the submission of the land counsel for the petitioner and the respondent. This court has heard the counsel for the appellant and for the respondent and peruse the plaint and the written statement. As per the written statement, there is an admission that defendant the plaintiff is residing in the second floor of the property. Land counsel for the respondent, defendant submits that he'll come up with objections and all necessary documents will be placed before this court, considering the fact that The defendant has already admitted that the plaintiff is in possession of the property. There shall be an injunction restraining the defendant from dispossessing the plaintiff from the suit scheduled property till the next date of hearing. This is matter on 23rd of October.
Great. Can I seek for,
Give the number. So and so, post along with so and so.
complaint?
Yes, next.
Can I seek for hand delivery? Because now the
Yes,
price.
yes, yes.
Great.
Yes, next.
Complaints can be dispensed now that my learned friend is appearing. I don't need to comply.
Your, that
39.3.
is, complaints is on your IA. On your IA.
That no notice in the order.
No.
But he filed wakalat. The norm. Allah, when he appears, what's the question?
The counsel for the respondent is permitted to comply with the office objection. Yes,
Dispense with complaints under order 39.3.
yes. Next.
Till number 16. Raghavendra, this side.
Because the main
Wait,
case,
what is that?
the interim order brought up, we had challenged that it has been rejected at the trial court level. And also, diverse degree.
No, all these, you have stated so many things. Court will have to look at it and pass it. We'll have it after vacation.
One day, date can.
After vacation and the request of land grounds for the petition on 16th of October. Yes, next. We'll see. That's not necessary. Yes, next. Yes, Paul. Yes.
The list matter. Till number 1. Somnath H.
Appearing for the petitioner.
Yes.
My lord, the petitioner has complied with all the directions issued by this honorable court on the previous date, my lord.
1 minute. What was the order? The father shall pay an amount of rupees 20,000 per month during the pendency of this decision. The 5th of every succeeding month. For the month of September, he shall pay the money by 26/9/2024. Is it paid?
He's paid.
Malad,
the
I'm
amount.
appearing for the respondent,
Is
Malad.
it paid?
Yes, Malad, he's paid the 20,000, but Malad
Yes.
specifically directed a visitation. And
One
there
minute, 1 minute. It's only like whether it is done or not. Father can exercise a visitation on coming Saturday and Sunday between 10 AM to 5 PM. The father shall pick up the children and drop them back. What happened to this?
Malad, it happened, it was complied, the children have gone, but Malads, the elder son is extremely upset, Malads. We had sent an email also saying that they have multiple classes, they have tuitions, etc., which have been scheduled on a daily basis for them. And the children, and we had sent an email specifically telling the husband, please, during the time of the tuition classes, please ensure that the children are in the house. Because earlier also, during visitation hours, the tuition is taken up in cafes and in restaurants where it is very noisy. So the minor child was very upset, and because of that, the father has, Malads, I don't even want to say what the father has told the children. I don't even want to say anything. He has threatened them. He has said that if you say things like this to your mother, I will not take you back to your mother. Malads, this is not the way to conduct. We also don't want the visitation to be completely stopped, Malads. We are not at all denying him. From the start, we are okay with it, Malads. But this conduct, there is physical violence. Now there is, he is threatening the children. How can he do this, Malads? How, this is really unfair on their part that he's still conducting himself like this. It's really not fair. And the children have called the mother, cried.
My lord,
This court has passed an order
my lord, if I may,
on
be permitted to make
23/9/2024, granting visitation to the father. According to the land counsel for the father, the visitation went on well. Land counsel for the respondent submits that the children were not comfortable while the father was exercising the visitation. This matter has to be heard in detail, and then only orders can be passed. Post this matter.
My
after
lord, the
vacation,
children have vacations, my lord.
15th of October, yes.
My lord, the children have
15th is a
vacations from
little
the
difficult
5th
for
to the
me.
13th, my lord.
Huh?
The children
Malads,
have
they're
vacations, my
already
lord, from
traveling.
5th to the 13th, my
We'll see,
lord.
we'll see. Yes,
Malads,
yes.
they're already traveling. The tickets I've given to
Yes,
my local.
next matter.
Please, Malads, 15th is a little difficult for me, Malads. Can I have 14th?
Yes, Ram.
Please
Children.
understand, matters are listed as per the Convenience.
My lords,
of
but
the
I
moment.
come all the way from Delhi, my lords. Today also I was going to come. They could have moved a memo yesterday. They moved it at
Yes,
10:15
Lord, it
AM
is
You
today.
can
only
appear
last
online.
night
You
we
can appear.
found out that
But
the
my
date
lords,
given
it's
matter was
difficult for
not
me when I
listed
have
on the
matters.
board, and that is the reason,
This
my
is
lord,
suppose this
the
matter
opposite
on
counsel
21st
cannot
of
blame us for
14th, my
each and
lords.
everything.
14th of October, my lords.
Yes, yes.
I'm
Yes,
super.
Till number 2,
Obliged.
S. Raghunandan. Majumdar. Sucheta Majumdar.
You.
Sucheta Majumdar.
Where are they?
Inform my lord, I informed that I need to, I've also said that, is coming back. I intimated that I am out of station. And this is matter, very short.
No, I remember, but without them, there is no purpose of.
I booked the tickets, I've taken, complete appointment on 4th.
No, had the council been present, we would have passed some order. No?
And S. Raghunandan. NOC Vakalati is
No.
filed by.
It is submitted that the council appearing in WP number 1904/23 has informed the council of the respondent and it is submitted that the order passed by this court is also not is not complied with by the respondents and the appointment before the consulate is on huh? As per the earlier order passed by this court on 4th, the father shall be present for the before the consulate.
Last time, directed to give a consent.
That is enough.
That is, he's supposed to give it as a form number OS 3053 in his absence. In this present, he has cleared. Last time, they made the observation that no present is necessary. You please give a consent form because their mother is going, she completed.
As per the earlier order passed by the court, the father shall give the, no, not. Father shall give the permission or shall give the consent form. Wow. In OS number? DS 3053 form. If the father fails to give the joint consent as submitted by before this court on the last occasion, the same will be viewed seriously by this court. Yes, next. Huh?
By tomorrow evening, because day after tomorrow morning, I have a flight, from Mangalore to Calcutta.
How do you expect the court to monitor all this? Huh? Who will intimate? Correct. No, that's what, if it is that, please tell him that what it is submitted that by tomorrow he has to send the that form as the matter is listed or going to be listed on the interview is the visa, the appointment is on 4th of October. Yes, next.
Till number 3.
For the petitioner's wife. The wife is before this honorable court. Because the interim order that was.
Typed
passed-
copy of the manuscript to be filed, photocopy of the quashing order at annexure to be filed, preamble portion to be filed. When will you do all this?
Situation is this. Friday, the interim order was vacated by the trial court. And was pronounced, only the order sheet portion and the operative portion was pronounced in the court. The entire text of the judge order was not yet released. Now so the urgency is this, that's
Where
why.
is the order?
Urgency is this is the annexure S is the operative portion of the order of vacating of the stay that was granted on an earlier occasion. That this court will find at page number 77.
No, there is no order also.
That's correct. Now, I should apologize to the court for the reason that I had to trouble this court to take it at the end of the list for the reason that if this money is released in the course of this vacation,
So if the court has specifically passed an order,
please.
say, already having granted an ex parte interim order, some things might have been placed before the court without knowing all that, how
Now-
can the
now,
court can?
May I request this honorable court to kindly take page number 54 onwards. At page number 58. Now, what happened was, this is the second time I went before this honorable court. Initially, when the matter was heard, the court did not pass an order. I came before this court, got an order, persuaded the family court to.
What
pass
is
an
the amount that is supposed to be paid to you?
Now, the situation is, I am claiming the marriage expenses for my child. Now, 20 years ago, a sum of rupees.
Under
6,000
125 CRPC.
Under 125, 20 years ago, 6,000 rupees was granted.
No, marriage expenses,
Marriage
you are
expenses.
entitled under 125.
There are few judgments of various high courts which entitles me, and I have placed that all those judgments. before
Then
the
we will
trial
so
court.
consider it not now.
Now, the situation is, may I persuade the court, may I persuade the court. Now, the typed copy of the order sheet as regard to the office objection, which is noted on the left-hand side. Now, the detail of the order that was passed by the trial court is not available with me. Now, what has happened is, I will only take 1 minute of this court. Now, kindly come to page number 68.
Yes.
Now, page number 68 is the letter that is issued by the Accountant General Office, wherein they have already determined what is the retirement benefits that the first respondent is entitled for. Now, if it is transferred from bank to bank, there is
No,
nothing.
how will he live without any money?
No, I'm
All
not asking
pensionary
for-
benefits you.
I'm sorry, I'm not
it
asking
is-
for the pension.
But then,
I'm not asking for the monthly
Hmm.
pension. Monthly pension is not something that I'm seeking the stay of.
when, from how long you people are living separately?
We have been living separately for more than 30 years now.
Now you want his retirement benefits to be held.
No, at the
What is the
initial-
age of the daughter?
Sorry,
What is the age of the daughter?
daughter is about 27 years.
Notice,
Daughter is about 27
notice to the
years.
respondents,
There are two
the
things.
petitioner shall comply with the office objections, no
No, no,
interim order.
The difficulty is this, the judgment is not even released by the trial court. That is my humble, that is the urgency that.
Once the court has to look at that, otherwise what is wrong with the order of the court that this court will interfere?
Difficulty is that I was entitled for an order of stay for the last 1 month. If it is extended only till 14th, because what happens is, if it is released, if it goes online and it goes into his account, nothing else will survive in this writ petition, or
No, but
only for
but for the
14
court,
days. I am
why
trying to
should
pers-
it be, court should know what is wrong? No, court is exercising the jurisdiction under 227. I should be satisfied that the
Absolutely,
reasoning
abso-
given by the court is wrong.
Absolutely.
Without that, this court is not in favor of those kind of orders. First of all, I am not convinced with an order of 125 CRPC.
127, 127 enhancement.
Not enhancing, original order is
correct.
125. 125
It's an
CRPC for marriage
extension of
expenses.
125, yes.
That
I
itself
have-
I am
I
not
have placed
convinced.
all the judgments also. I can place the judgments before this honorable court also.
What is one more matter? It's not there.
So my humble submission is, my only request is, till 14th, let the matter be listed on 14th. Till the 14th, let the disbursement be stayed.
No,
Now, the interim order, let it be extended only till the 14th
No.
during the vacation, when this court is on vacation. Otherwise, the judicial remedy is completely shut off.
if you get an order, then the petitioner had questioned before this court. The operative portion of the order, it is submitted that the entire order is not available. Without looking at the order and what is the illegality or otherwise of the order, this court cannot grant any interim order.
Very well.
If the petitioner has an order, the copy of the order, he is at liberty to move the vacation court. Yes.
Please.
Okay, number 4. Vilash Abdul.
For the petitioner, please, Millard. Millard, this is.
And the office objections shall be complied with when the next time, if at all he moves the vacation court, it shall be complied with. Yes,
That's only officer. The other type copy is of course ready, which I'll.
yes.
Millard, it's a 125 proceeding wherein the issue is emanating from the page of the order which has been passed. At the page number 11, please, my lords.
Hmm?
Page number 11. Before issuance of notice, an ex parte order has been passed. Very,
What is this BNSS?
yes, the petition has been filed in the BNSS, my lord. BNSS, the petition has been filed under the BNSS for the recovery proceedings.
What is it? BN?
Bharatiya Nyaya Suraksha Samhita.
Oh, the short form of it.
Yes, yes, yes.
Hmm.
So when at the page number 11, it can be seen, please, my lord. At the very same date when the matter was registered,
When is this order passed?
it's on 16/7, my lords, 24.
And you will ask for a hearing today on an order of 16/7.
Consequently, we have filed it, and also the perusal of the order sheet can be seen. We have appeared at the very first date. They have appeared, my lord. Before issuance of the notice, also the ex parte order has been passed, and no documents pertaining to petitioner's salary or anything which income has
What
been.
is your income?
It's around 10,000 rupees, my lord. 10 to 12,000 rupees. I'm working as a driver in Mysore.
How much is granted?
It's granted about 25,000 rupees. No, the 145, it clearly says, my lords, whether if I'm avoiding the service or if I'm neglecting the service before appearing, then it can be passed in ex parte, my lords. Not even I have been availed the services of filing my objections or anything.
The writ petition is filed, questioning the order dated. What is the date of order?
16/7/20.
16/7/2024, whereby the trial court had, the family court had granted an ex parte order of maintenance of rupees 25,000 per month. Then comes for the petitioner submits that he is working as a
Driver, man.
driver and 10,000 is your salary.
10 to 12,000 rupees I am earning.
Because you think and submit.
No, 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 no. Probably I'm just earning 10 to 12,000 rupees. I can able
It is submitted that his salary is 10 to 15,000 per month, and the court had granted 26,000 towards the maintenance. Considering the submission, there should be stay of all further proceedings pursuant to the order dated so and so, on the condition that he shall pay an amount of rupees 5,000 by 5th of every succeeding month. And for towards arrears for these 2 months, 10,000 shall be deposited by within 4 weeks and continue to pay by 5th of every succeeding month. Petitioner is permitted to take out notice on the counsel appearing for the hand summons on the counsel appearing for the respondent before the trial court, and shall file a memo to that effect by 4th of November. If the memo is filed, this is matter on 6th. And by the next time, if the office objections are not complied with, the writ petition shall stand dismissed on that ground.
Much of.
Lordship, may I make one submission, Lordship? I apologize for appearing through VC, Lordship. In serial number 54, kindly permit to take a hand summon, Your Lordship.
Circuit at 54.
That is
What is ordered if it is not hand summons permitted?
much obliged.
ಯಾವ್ದಂತೆ 54 ಯಾವ್ದಪ್ಪ 54 54 ಅಲ್ಲ ನೋಟಿಸ್ ಆಗಿದೆ RPFC ಟ್ಯಾಗ್ ಆಗಿದೆ ಪರ್ಮಿಟೆಡ್ ಟು ಟೇಕ್ ಔಟ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಅಂದ್ಬಿಡು
Madam,
ಸರ್ ಹೇಳಿ
Madam, serial number 11 judgment ಏನಾಗಿದೆ ಮೇಡಮ್? Cause list, second cause list, serial number 11 judgment.
serial number
11. So cause list.
11?
ಹಾ.
ಯಾವ ಲಿಸ್ಟ್ ಸರ್?
ಎರಡು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಮೇಡಮ್.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 11 ಆಲ್ರೆಡಿ ಪ್ರೊನೌನ್ಸ್ಡ್ ಅಲ್ಲ.
ಏನಂತ ಆಗಿದೆ ಮೇಡಮ್?
ಅದು ಒಂದು ಪೆಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಒಂದು ಅಲೋ ಆಗಿದೆ.
ಮೇಡಮ್ ಯಾವ್ದು ಅಲೋ ಆಗಿದೆ ಮೇಡಮ್?
ರಾಘವೇಂದ್ರ ಎಸ್ ಇಸ್ ಡಿಸ್ಮಿಸ್ಡ್, ದಟ್ ಬಸವರಾಜು ಬೆಲ್ಲವಂಗಲ ಅಲೋಡ್.
Okay, ma'am. Thank you, ma'am.